ಹೌದಾ ಕೊಡಿ. ವೆಂಡಿಂಗ್ ಮಾಡಿ ಬರತ್.
ವೆಂಟ್ರಿಫಿಕೇಶನ್ ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕು ಅಂತಿತ್ತು.
ವಿಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ವಿಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ? ಹಾ ಕೊಡಿ.
ವೆಂಟ್ರಿಫಿಕೇಶನ್ ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕು ಅಂತಿತ್ತು
ಅಂತಾನೆ. ಒಂದು ನಿಮಿಷ. GMCPC ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ, ಫ್ರೆಶ್ ಮೆಮೋಸ್. No, tomorrow, Monday or Wednesday. Wait, end of the list, wait. ಅದು ಕೊಡಿ. ಜನರಲ್ ಅವಾರ್ಡ್ ಕೊಡಿ, ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡೋಣ. ಮೇಡಮ್ ಜನರಲ್ ಅವಾರ್ಡ್ ನಾಳೆಗೆ ಹಾಕ್ಸೋಣ. CRP ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಇಲ್ಲ. ಹಾಂ ಮನೆಗೆ.
CRP matter, can we post it for tomorrow or Monday?
Why?
There's an urgency.
What?
Actually, Tahsildar DC office in ನಮ್ಮ ಕಡೆಗೆ order ಆಗಿದೆ lordship, but the opponents have already demolished the temple and they're setting up a.
ಆಯ್ತು, tomorrow ಅದೊಂದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. Which is that memo? Take it tomorrow. CRP ಕೊಡಿ ಸರ್, ಎಲ್ಲ ಕೊಡಿ ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ.
Lordship, BDA matter, threat of the disposition by BDA.
Tuesday.
ಇದನ್ನ ತಗೊಳ್ಳಿ.
Please to pass extension of parole. ಇನ್ನ petitioner ಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ನಡೀತಾನೆ ಇದೆ.
ಟ್ರೀಟ್ಮೆಂಟ್ ನಡೀತಾನೆ ಇದೆಯಾ? ಅದು ಪೆರೋಲ್ ಇರೋವರೆಗೂ ನಡೀತಾನೆ ಇರುತ್ತೆ.
He has to surrender tomorrow. Kindly have it today.
Very good. ಯಾವ offense ಏನು? Offense NI ಆಕ್ಟ್ ಕೊಡಿ. NI ಆಕ್ಟ್ ಅಲ್ಲಿ ಇರೋದೇ 6 ತಿಂಗಳ ಸೆಂಟೆನ್ಸ್, ಅದನ್ನು 6 ತಿಂಗಳು ಪೆರೋಲ್ ಕಳಿಸ್ಬಿಡಿ ನೀವು. ಕೊಡಿ.
My lord, case of impersonation, my lord. Trial court directed me to pay the court fee, my lord. Short point is there, my lord. For
Monday or Wednesday.
Sir.
CPC matter, my lord.
Give it, sir.
7-11 application was filed.
Next Thursday, give it.
Your lordship,
Wait, sir.
KHP matter. Your lordship, KHP matter, your lordship. We had
Give
sought appeal.
Give it, yes.
My lord, GMCPC in OS list for hearing a 12 rule 6 application, my lord. There is an urgency tomorrow, my lord.
ಯಾವತ್ತಿದೆ next date?
Monday.
Tomorrow ಕೊಡಿ.
ಮಂಡೇ ಮೂವ್ ಮಾಡಿದ್ದೆ, ನೀವು ವೆಡ್ನೆಸ್ಡೇಗೆ ಅಂತ ಹೇಳಿದ್ರಿ JMCPC. ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗ್ತಾ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ನಾಳೆಗೆ ಇದೊಂದು ನಾಳೆಗೆ.
Your lordship, KHP matter, your lordship. We have sought
Tuesday.
Tuesdays
and Thursday or Friday and KHPS.
Tuesday.
It will come, give it.
Tuesday.
This matter end up the today.
Why?
Tuesday or Thursday.
Rejected disputing application.
And
fixed date for evidence on case 8th of this month. Therefore, today it may be taken.
We can take it on Monday, 7th.
Monday 7th.
7th is before 8th.
With my lord's permission, GMCPC matter.
CPC idhar kodi.
My lords, I'm asking for end of list. The reason is.
Of the list, please.
GMCPC pending matter, my lord. The National Highways Authority construction work has approved the petitioner's property. Therefore, Monday,
My lord.
Give it.
My lord.
ಏನು madam?
Your lords.
ನಂಬರ್ ಬಂದ್ರೆ ಮಾತ್ರ. FR ಅಲ್ಲಿ ಆಗಲ್ಲ, FR ಲಿಸ್ಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ. WP ಆದ್ರೆ ಮಾತ್ರ ಲಿಸ್ಟ್ ಆಗೋದು.
My lord, this is a fresh matter, my lord.
My lords, GMCPC matter, your lords.
ಮೆಮೋಸ್ ಕೊಡಿ, ಎಲ್ಲ GMCPC ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಕೊಡಿ.
Your lordship, there is an urgency. We have no opposition for allowing of the WP. It may be listed today and allowed, my lordship, please kindly.
Review petition.
No, WP, your honor, GMCPC. The stage for cross-examination was closed. We are for the respondent.
Will list it tomorrow.
Tomorrow, please, your lord.
ಅದು ಅಲೋ ಮಾಡಕ್ಕೆ ಅಂತ ಹಾಕಿ.
Matter, my lord. GMCPC.
Wait.
My order 38 rule 5 application has been dismissed, your lordship, without a reasoned order. Is a threat of alienation by the respondent in this matter, your lordship.
Monday.
GM.
Partition, my lord, reassigning of the shares because of the death of the mother, my lord.
ನೀವು ಯಾರು ಗೌರ್ಮೆಂಟ್ ಯಾಕೆ?
Not government, my lord. It's a private matter.
ಪ್ರೈವೇಟ್ ಬ್ರೀಫ್.
Twice, my lord, it has not come. Tomorrow, my lord, tomorrow.
ಅರ್ಜೆನ್ಸಿ ಏನು?
Urgency itself tomorrow.
Urgency itself tomorrow?
No, madam. Tomorrow they will draw the final decree that the share will be allocated.
ಆಯ್ತು ಕೊಡಿ.
My lord, GMCPC, my lord. Urgent matter, my lord.
ಕೊಡಿ.
Execution ಇದೆ pending ಇದೆ.
ಇರ್ಲಿ ಪರಲ್ಲ ಕೊಡಿ.
CRP, my lord.
ಕೊಡಿ ಸರ್, GMCPC ಎಲ್ಲ ನಾಳೆಗೆ ಯಾವ ತಗೊಳ್ಳಲ್ಲ ಕೊಡಿ. Monday or Wednesday ಬರುತ್ತೆ.
CRP matter CRP matter arising out of my lord commercial court order. Lord, 7 rule 11 application is rejected. Now the trial court, my lord, is proceeding further in the matter. Lords may kindly have it tomorrow or
fresh matter.
Fresh matter.
ನಾಳೆ
or tomorrow.
ಅಲ್ಲ, CRP is Thursday. If it can wait till Thursday, no problem.
It's on 11th, my lord. That's on 11th and the 10th it can be taken.
That's
Please.
One further hearing matter, my
Much.
lord.
ಫರ್ದರ್ ಹಿಂಗ್ ಕೊಡಿ. ಯಾವ್ದು?
Codes matter, my lord. Where
ನನ್ನ
PML.
ಹತ್ರ ಇಲ್ಲಪ್ಪ ಅದು ಮೂವ್ ಮಾಡ್ತಾನೆ ಇದ್ದೀರಾ. ಇಟ್ ಇಸ್ ನಾಟ್ ಬಿಫೋರ್ ಮೀ. ನನ್ನ ಹತ್ರ ಆಗಿದೆ ಮೇಡಮ್ ಅದು. ಅವ್ರು ಮೂವ್ ಮಾಡ್ತಾನೆ ಇದ್ದಾರೆ.
Further hearing at 3:30 PM ಅಂತ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡಿರ್ತಾರೆ.
ಫರ್ದರ್ ಸಬ್ಮಿಷನ್ ಅಂತ ಯಾವಾಗ್ಲೂ ಬಂದಿತ್ತು 2 ವರ್ಷದಿಂದ. ಫರ್ದರ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ನಾಟ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
No, that is done. That is disposed.
ಯಾವ್ದು ಮತ್ತೆ?
This PMLA matter, my lords.
PMLA ನಾ?
Please,
All right.
predicate offense.
ಆಯ್ತು.
Please.
ಶ್ರೀರಾಮ್ ಲೇಔಟ್ ನನ್ಗೇನ್ ಗೊತ್ತಿಲ್ಲಿದೆ ಅಂತ. ಏನ್ ಬೇಕು ಹೇಳಿ. GMCPC ನ? ಎಲ್ಲೇನಾ ಕೊಡಿ. ಎಸ್
The GMCPC will not.
2:30 ಯಾರ್ಯಾರ್ದಿದೆ ಹೇಳಿ. ಒಂದ್ ನಿಮಿಷ ಎಲ್ಲ ತಾಹಿರ್ ಕೊಡಿ. ಯು ಶುಡ್ ಗೆಟ್ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಅಂಡ್ ಕಮ್. ಎಸ್ ಎಸ್ ಆಯ್ತು. 2:30 ಇನ್ನೇನಿದೆ ಏನು? ಆಯ್ತು. ವೈ ನೋ ಕಾಜೆಂಟ್ ಇಲ್ಲ, ಪ್ಲೇಟ್ ಫ್ರಾಡ್ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿ? 9 years ಆದ್ಮೇಲೆ ಟರ್ಮಿನೇಟ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಕೊಡಿ 2:30.
My lord.
This is pertains to Karnataka Country Town Planning Act. Because the petitioner he was invested huge money, madam.
ಆಯ್ತು, ಏನ್ ಹೇಳಿ ಈಗ?
Not this was very urgency.
Very urgent because you have invested huge money.
No, my lord, because from 15 years, my lord, without formation of the road and without payment of compensation, my lord, even
ನಾಳೆ ಕೊಡಿ.
My lord.
That's my 39 application is not being considered by the trial court.
2:30. 39(1 * urgency ಇರುತ್ತೆ.
GMCPC one submission, fifth time we are moving this memo.
ಅದು ರಿಜೆಕ್ಟೆಡ್. ಎಸ್, ಮೆಮೊ ರಿಜೆಕ್ಟೆಡ್. ಇದೆಲ್ಲ ಹೇಳಂಗೆ ಇಲ್ಲ ಇಲ್ಲಿ. 5th time 10th time ಎಲ್ಲ ಏನ್ ಹೇಳಿ.
It is fresh matter, my lord, but the file
ಕೊಡಿ.
is pending.
ಟುಮಾರೋ ನೀವು 5th time ಅಂತ ಇನ್ನೊಂದ್ಸರಿ 5th time 3rd time 10th time ಆದ್ರೆ ಮೆಮೊನೇ ತಗೊಳಲ್ಲ.
Pending branch ಇದೆ madam.
ಎಲ್ಲಾರು ಇರ್ಲಿ. How many matters can I also take?
CPC matter, my lord, the respondent in this matter. My lord, 7 Rule 11 application was filed, it was pending for orders, my lord. The petitioners have come before this court and taken a stay my lord, on a previously disposed 65B application, my lord. My lord, the 7 Rule application was it was
Me yavat ಬೇಕು sir?
Tomorrow, Monday, my lord.
Monday.
With my lord's permission, in a suit for partition, one day the trial court frames additional issues placing burden on me, rejects my application for leading further evidence, hears arguments in part on the plaintiff, posts the matter on Saturday for further.
PD justice sir 2:30 ತಗೊಳ್ಳಿ. Yes.
My lord. My lord, LA BDM, my lord, I'm trying to dispose of my lord 2:30.
Sir, Tuesday.
My lord, 2:30, my lord. Yesterday they had come with the JCB. I have requested them, my lord, because I am in the possession of the property, my lord.
JCB?
Hence it's urgency, my lord.
JCB problem.
ಅಲ್ಲ, JCB ತಗೊಂಡು ನೆನೆ ಬಂದಿದ್ರು ಅವರು, AEE ಅಸಿಸ್ಟೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಎಲ್ಲ. So yesterday we have requested them. So it's
2:30.
GMCPC next week.
Give the memos GMCPC ಕೊಡಿ. Give the GMCPC memos. 2:30 ಯಾಕೆ? ಅರ್ಜೆಂಟ್, ನಿಜವಾದ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳಿ. JCB ಅರ್ಜೆನ್ಸಿ ಏನ್ ಡೇ ಬೈ ಡೇ? ಏನ್ ವಾಟ್ ಇಸ್ ಏನ್ ಅಪ್ಲಿಕೇಶನ್? ಏನ್ ಅಪ್ಲಿಕೇಶನ್?
after death of the GP holder, the suit has to be abated. That's the reason I have filed the application.
ಕೊಡಿ ಮಂಡೇ.
Trial court fixed date on Saturday.
ಪರವಾಗಿಲ್ಲ, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಳಿ ಮಂಡೇ. ನೋ ಸರ್, ಅದ್ರಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ.
Extension of parole, madam.
Extension of parole.
Please, one matter, my lord, FDP proceedings, final stage has come, as a last chance date is given, CRP 816 of 24. The MS state was filed, it was converted into 816 CRP. Now FDP proceedings, partition suit. Now the FDP proceedings as a last chance it has been.
ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
So maybe posted tomorrow.
ಏನ್ ಆಗಿದೆ?
They have sought for stay of the
FDP.
Allah, stay of further proceedings because there is
in the FDP.
Sorry?
In the FDP you have sought stays.
Yes,
who are you?
CRP. I am the.
Who are you?
I am I am the respondent in the FDP, the partition suit. Partition already been final stage. Commission is already warranted.
Sorry, why do you want stay?
Stay because I filed the appeal before the trial court. It was dismissed. Now I filed MSA. Office, the court permitted me to file, convert into CRP. Now CRP is filed. Maybe tomorrow.
Tomorrow. Pending ಕೊಡಿ. ಕೊಡಿ, ಅದೇ no objection to allow. ನಾಳೆ ಹಾಕಿ ಮೇಡಮ್.
Lordship, it is sued for eviction, Lordship, and the plaintiff made me as a party in the Plaint.
Yeah. 23 matter, my lord. For it.
Successor.
Serial number 84.
No adjournment. Direct or indirect?
No, my lord. Serial number 84. A week's time you granted, my lord.
ಅದು adjournment ಅಲ್ವಾ ಅದು? ಮತ್ತೆ?
Because my lord's statement of objection.
Adjournment ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತೀರಾ? ಮತ್ತೆ ಅದೇನೆ. 1:00 ಮೆನ್ಷನ್ ಮಾಡಿ.
Objection is ready.
1:30. I'll call adjournment at 1:30.
Much.
75.
Adjournment. 1:30. ಏನಿದೆ?
28 lakh is ಅಂತ ಹೇಳಿ ಆಗಿದೆ. 28 crore ಅಂತ ಆಗ್ಬೇಕು. And not released in favor of petitioner.
28 lakhs.
It is 28 crores. It was
correct. Yes.
And and your lordships are directed not to.
Children. 25 paisa. Rupees. Yes.
And not released in favor of.
ಬರ್ಕೊಂಡ್ರ ಅದೇನು ಹೇಳಿದ್ರು? 25. Yes. This court on 30th June 2025 had passed the following order. The learned counsel with the petitioner has moved a memo of being spoken to on this court that there is inadvertent error with regard to mentioning of the amount which is reflected as 28 lakhs, which ought to have been 28 crores. 29 lakhs. 15,025.
And
so
the
correction ಮಾಡ್ಬಿಡಿ ಅದನ್ನ. 25 ಆಮೇಲೆ
and your lordships are directed not release any amount in favor of any of the parties.
ಹೌದು.
ಅದು not release in favor of petitioner ಅಂತ type of the fourth para.
ಅದು ಇದರಲ್ಲಿ the order as dictated was that no amount, the respondent 2 and 5 are restrained from releasing any further amount in favor of any of the parties to the list. The same should be, the correction shall be effected to and separate upload ಮಾಡಿ ಬೇರೆ. Certified copy be issued. ಅದು ಗಡ್ಬಡಿ ಆಗ್ತದಲ್ಲ. Yes. Non taking of hand summon 2020 ಇಂದ. of 2020. Needful to be done in the next 10 days, failing which the interim order subsisting would get automatically vacated.
But I appear for the petitioner. Partial rejection of the plaint, my lord, that your lordship.
Partial rejection.
Only, my lord, my argument rights are appeal.
Settled last, sir.
Settled down.
Yes.
Let him reconsider my entire aspect.
The entire application consider.
Application or accurate ಕೆಲವು item.
Fresh application if you want in law you can file, but not this.
You lordship may give save that word that
say what
word. Otherwise, either or else, my lord, it will be considered because my lord, partial rejection means it my lord blows both ways. In fact, my lord, if it is against allowing, my lord, if it is allowing, he has to file an appeal. You lordship say now that is partial rejection, I have nothing to say.
It is settled law. A suit cannot be partially rejected. Plaint cannot be partially
rejected. We know, my lord, we know it can't be done.
Yes.
Any number of application is for rejection insofar as certain items is concerned.
That is not, that was not even maintainable.
I know, therefore you lordship may say, my lord.
The petitioner, plaintiff is plaintiffs. Petitioner plaintiff 1 and 2 in OS 675 of 2022 are at the doors of this court calling in question an order dated 30th March 2024 by which the concerned court answers the application in IA3 filed by the defendants 1 to 7, 24 and 38, seeking rejection of a plaint in respect of certain parts of rejection of a plaint partially. The learned counsel appearing for the petitioner submits that the application itself was filed for rejection of the plaint partially and not the entire plaint, since the issue stands covered by plethora of judgments of the apex court that a plaint cannot be rejected partially. The petition on this short ground deserves to succeed. The learned senior counsel SP Kulkarni would submit that he be reserved liberty to file an appropriate application before the concerned court. The liberty, if available in law, is always available to the petitioner, to the defendant, to take necessary steps in accordance with law. In the light of the order, the order on the face of it being illegal, it is necessarily to be obliterated. In that light, for the aforesaid reasons, the following order allowed, quashed with the aforesaid liberty.
The other connected matter, my lords. Here, rejection of my application under 7 rule 11D. Illi 2001 deeds, my lord, 2001 first order. Kindly see the first order itself, my lord.
Yeah, this
has to be really
ನೀವು
the first
ಇಲ್ವಾ
order
ಇದ್ರಲ್ಲಿ?
itself, my lord.
ವಕಾಲತೆ ಹಾಕಿಲ್ಲ, ಯಾವ ಕೇಸ್ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ನನಗೆ.
Other side has appeared already.
ಅದು ಡಿಲಿಂಕ್ ಮಾಡ್ಬಿಡಿ 3.1 3.1 ವಸಂತ್ ಕುಮಾರ್ ಕೇಮ್ ನೀವಿದ್ದೀರಾ ಸರ್ ಅದರಲ್ಲಿ 3.1 ಅಲ್ಲಿ
3.1 ಅಲ್ಲಿ my lord, we are for the petitioners.
ವಸಂತ್ ಕುಮಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರು?
Respondents
1 to 4 ಇನ್ಯಾರಿದ್ದಾರೆ? ಸೇಮ್ ಪಾರ್ಟೀಸಾ?
ಅಲ್ಲ, parties different.
ಸೇಮ್ ಪಾರ್ಟೀಸ್ ಇದ್ರೆ ನೋಟಿಸ್ ತೊಗೊಳಕ್ಕೆ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ.
Very good, very good. I should say that. Let him say.
ಮೇಡಮ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್
ನೀವು dispense with ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ.
ಇದಾನ?
Dispense with ಮಾಡಿ.
ಕುಮಾರಿ ಬಾಯಿ ನೀವೇನಾ? ಐ ಮೀನ್ ಯುವರ್ ಕ್ಲೈಂಟ್.
ಇಲ್ಲ, ನಾನು ನಳಿನಿ ಬಾಯಿ, ಮಂಜುಳಾ ಬಾಯಿ.
ಎಲ್ಲ ಅಲ್ಲೇ ಇದ್ದಂಗಿದೆ. ಎಸ್. ಸೊ ಯು ಕ್ಯಾನ್ ಟೇಕ್ ನೋಟಿಸ್. Learned counsel Shankar Reddy accepts notice for the first respondent. 1, 2, 3, 4.
Yes, 1 to 4.
1 to 4.
1 to 4.
Registry to ಆಗ್ಲೇ ಹಾಕಿದ್ದಾರೆ ಯಾರು 1 to 4.
ಅಲ್ಲ, ಅದೇ ಹೇಳಿ, that's what he has already filed.
ಮತ್ತೆ ಈ ಕಡೆ ಬನ್ನಿ, ಅಲ್ಲೇ ಇರಿ.
Request to allow Murad 2001 deeds, partition deeds have registered party 2001, 2002, 2004.
ಈಗ your application is rejected, is it?
Application rejected. That is what I filed.
Partition suit.
Partition suit. 2001 Murad registered partition deeds.
We'll see. We'll hear it then. List on next Thursday.
Interim order is already there, Murad.
Interim order subsisting would continue till the next date of. ನೀವಿಲ್ಲ ಶಂಕರ್ ರೆಡ್ಡಿ.
Very. ಅಲ್ಲ, ಅವ್ರಿಗೆ ಡಿಸ್ಟೆನ್ಸ್ at present distance ಮಾಡಿದ್ದಾರೆ, ಬೇಕಾಗಿಲ್ಲ. At present, otherwise
connected case ಅಲ್ಲಿ ನಾನು appeal ಆಗ್ತಿದ್ದಾರೆ.
ನೀವ್ ಆಗ್ತಾ ಇದ್ದೀರಾ ಚಂದ್ರಶೇಖರ್?
ಇಲ್ಲ, connected case ಅಲ್ಲಿ I appeal for R70 37.
R37 ಇರಿ.
ಇಲ್ಲಿ ಏನೋ ಪಾರ್ಟಿ ಅಂತ ಇದ್ದಾರೆ, ಅವರೇ ನಡಿ.
ಅಲ್ಲ, at present dispense with ಮಾಡಿದ್ರು first time, not necessary.
Thereafter we can dispensed with. Dispensed with.
Yeah, at present ಮಾಡಿದ್ದಾರೆ dispense. He is made free. Yes. Interim order may kindly continue. Great.
For petitioner.
Post immediately after service of notice upon the respondents. Interim order ಇದೆಯಾ? Yes, madam.
This case, my lord.
Furnishing FPF.
No, he is not a necessary party. I will file a memo.
File a memo.
ಈಗ ಹಾಕ್ತೀನಿ. It may be disposed of, my lord.
Disposed of for what?
This is an application, a rejection.
ಏನಕ್ಕೆ ಮಾಡಿದ್ದೀರಾ? What's the prayer?
Prayer, my lord. ಇದು ಸ್ವಲ್ಪ ವಿಚಿತ್ರ ಇದೆ ಕೇಸು.
ಹಂಗಾರೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು. ಹಂಗೆಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ,
ನೀವು ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಮೇಡಮ್.
ಒಂದೇ ಒಂದು ನಿಮಿಷದಲ್ಲಿ ಹೇಳ್ಬಿಡ್ತೀನಿ. 23(1) ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು, seeking permission of the court to withdraw the suit and to institute a fresh suit. IA partly allowed, permitted to withdraw, but not permission given to file a fresh suit. And there is an observation in that order that the plaintiff can seek amendment. Making use of that observation, my lord, the plaintiff filed application for amendment.
That is rejected.
That is rejected. Against that, a writ petition came to be filed, that is allowed. ಆಮೇಲೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಗುವಾಗ ಡ್ಯೂ ಟು ದಿ ಚೇಂಜ್
ಇಷ್ಟೊಂದೆಲ್ಲ ಇದ್ರೆ ಎಲ್ಲ ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಅಷ್ಟೇ ಪ್ರಿಸೈಡಿಂಗ್ ಆಫೀಸರ್ ಚೇಂಜ್ ಆದ್ಮೇಲೆ ಅದೇನಾಯ್ತು, ನೀವು EIA ಉಳ್ಕೊಂಡಿದ್ಯಲ್ಲ, I cannot proceed further.
Let me see, it is in orders, I have not seen that.
And one submission, my lord, this may be connected with 103 and 104, my lord.
Oh, ಅದೆಲ್ಲ ಇದೆ ಮತ್ತೆ.
ಮೂರು ಕೇಸ್ ಇದೆ.
Tag this petition along with serial number 103, 104. List the matter next Thursday.
Please, much.
Your name is shown, madam?
Yes, my lord. Name is shown.
Mahesh Arkulgu. My senior's
Oh,
name is
Mahesh
referred.
Arkulgu, yes. 6, post immediately after service of notice upon the respondent interim ಮಾಡಿದ್ರೆ continue ಮಾಡಿ. Next. ಇಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನು continue ಮಾಡಿ. Yes.
7, my lord. I have served to the counsel appearing for the respondent before the trial court and filed the acknowledgement before the registry, my lord, on 1/7/2025, day before yesterday, my lord.
ಆಯ್ತು, ನಾಳೆ ತಗೊಳ್ಳುವ.
Please.
List tomorrow in preliminary hearing.
Lordship, the suit for declaration which
Non-furnishing of PF.
will take weeks accommodation may be provided.
Merits ಮೇಲೆ ಹೋಗ್ತಾರೆ.
Apologies, Lordship.
Council seeks a week's time to do the needful.
Grateful, Lordship.
Yes. Post immediately after service of notice upon the respondent.
I may seek a permission to serve the counsel appearing before.
Then counsel of the petitioner shall also serve on the counsel who represents the respondent in the trial proceedings.
Lord, ಇದರಲ್ಲಿ ನಾನ್ ಫರ್ನಿಶ್ ಆಫ್ ಪಿ ಎಫ್ ಅಂತಿದೆ. ಆಕ್ಚುಲ್ ಆಗಿ ಬೋತ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ವಕಾಲತ್ ಹ್ಯಾವ್ ಬೀನ್ ಫೈಲ್ಡ್ ಅಂಡ್ ಈವನ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹ್ಯಾವ್ ಬೀನ್ ಫೈಲ್ಡ್ ಬೈ ಪೆಟಿಷನ್. That was the stage that petitioner passed away.
ನೀವು ಯಾರಿಗೆ ಸರ್?
I appeared for the respondents, Lord.
R2 for second time. Who is R2?
ಅಲ್ಲ, ಇಬ್ಬರಿಗೂ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದಾರೆ ಅವರು.
ಹಾಕಿದಾರ?
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದಾರೆ. ಮೈನ್ ಪೆಟಿಷನ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ. ನೋಡಿ ಸ್ವಾಮಿ.
ಯಾರು ಹಾಕಿದ್ದಾರೆ? ಅಡ್ವೊಕೇಟ್ ಯಾರು?
Respondents counsel. I appeared for R1 and R2.
Learned counsel submits that he has entered appearance both for the first respondent and the second respondent. Therefore, the indication of fresh process fee stands deleted. Non-arraigning of so and so.
Not this is, I have written the note because my lord, all these respondents I have not arrayed. My lord, they have given the no objection and consent for dismissal of the suit. It's a partition suit.
The learned counsel
So they
for
are
the
not the
petitioner.
contested parties.
Learned counsel of the petitioner, the other objections, would submit that all the defendants who have not been arrayed as respondents to the subject petition have all given up their right before the concerned court by giving consent for allowing of the suit. The suit is for partition. In that light, the non-arraigning, the objections with regard to non-arraigning of the defendant stands deleted. List the matter on Thursday.
My lord, IA number 3, my lord, that is for
Bringing LRs of petitioner, allowed. Yes.
My lord, I
Allowed.
request your lordship to ನಾಳೆ ಆದ್ರೆ ಸ್ವಾಮಿ.
ನಾಳೆ ಆಗಲ್ಲ, Thursday.
ಬಹಳ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಬಹಳ ವೈ?
ಅಲ್ಲ, ಏನಾಗಿದೆ, number of applications that were filed in the trial court. The matter is posted for arguments and this is a matter which has got to be dismissed.
ಹೌದಾ?
ಹೌದು ಸ್ವಾಮಿ. My lord, it's a partition suit. My lord, partition suit.
ನಾಳೆ, tomorrow. Tomorrow in preliminary hearing. Admission, sorry, CRP. Yes. 11, post immediately after service of notice upon the respondents. Same order. LL entry ಮಾಡಿದ್ರೆ continue ಮಾಡ್ಬಿಡಿ. Same order. 14.
For the respondent.
And for petitioner, my lord.
Non-furnishing of PF.
Pray time for. Pray time for.
Mic ಇಲ್ವಾ?
Pray time for my lord.
Praise time. No grants time. Yes.
Please, my lord.
ಯಾಕೆ ಕಟ್ಟಿಲ್ಲ? Interim order ಇದೆ, vacate ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
My lord.
Less a week's time is granted.
Lordships, just one submission. On the last date, that is 1 week ago, I had made a submission before this honorable court that they had not filed any application seeking interim orders, my lords.
Oh, interim order is erroneously granted.
Yes, my lords. And IA number 1.
The learned counsel for the respondent had in fact on the last date of listing, i.e. on 26/6/2025 had made a submission that there was no application even filed for grant of an interim order. Or the non-filing of the application is accepted by the counsel for the petitioner. Therefore, the indication that the interim order granted earlier stands extended stands deleted. List the matter on next Thursday. Needful be done by then. ಎರಡು ವಾರ ಬೇಕಾ?
1 week.
1 week.
Interim order may be cancelled.
Objection file ಮಾಡ್ತೀವಿ, my lord.
Great.
ಅಯ್ಯೇಗ? ಯಾವ ಅಯ್ಯೇ madam?
I have filed an IA for vacating the stay, my lords.
Where is the stay?
There is no stay. That is what I indicated.
ಅದಕ್ಕೇನು objection ಬೇಡ. You first take steps.
Okay.
Next. Grateful, my lords.
Same
Passover, your lordships.
Passover, why?
My senior will come.
What's the matter? Steps have not been taken. Await service of notice upon the respondent.
Passover, your lordships.
Interim order is there, madam.
No.
No interim order. Interim order, madam.
My senior will come, your lordships.
Wait. He's told you to take a Passover, that's all. You have not seen the file?
No, your lordships.
You have not seen the order?
No, your lordships.
Post immediately after service of notice upon the respondent, interim order subsisting will continue till the next date of hearing. Interim order is there. Tell your senior interim order is there. Yes.
Referring for the petitioner, madam.
Wait for the first respondent.
Await first respondent.
Please, madam. ಇದರಲ್ಲಿ along with citations ಕೊಡ್ಲಿಲ್ಲ ಅದು ಹೆಂಗ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ
ಕೊಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ citation they have not produced.
ಏನ್ ಹಾಕಿದ್ದೀರಾ ಸರ್?
Citation memo. Citation also served, madam.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ ಇದು.
I am serving now.
Please.
The detailed interim order granted.
The detail I was not present, my lord, when the
ಎಕ್ಸ್ಪರ್ಟ್ ಕೊಟ್ಟಿರೋದು.
expert.
ಕರೆಕ್ಟ್.
Please.
ಅದನ್ನ ನೋಡಿ ಅಂತ ಹೇಳಿದ್ದ.
please.
ಅಲೋ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿಲ್ಲ.
Please.
12 ವರ್ಷ 3 ತಿಂಗಳಾದ್ಮೇಲೆ ಹಾಕಿದೀರಾ ಅಂತ.
12 ವರ್ಷ ಅಂತಂದ್ರೆ
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಹೇಳಿದೀನಿ ಆತರ. If you want to file an application seeking vacation of the interim order, no problem. Copies ಎಲ್ಲ ಕೊಡಿ ಅವರು.
ಕೊಟ್ಟಿದ್ದೀನಿ.
Learned counsel, you are Sunita, right?
Please, PC Sunita.
Learned counsel, PC Sunita seeks 10 days.
10 days.
10 days time to file statement of objections or seek vacation of the interim order as the case would be. List the matter on 17th.
Please.
Yes, interim order subsisting will continue till the next date of hearing. 17th in admission.
Same.
Admission. ಅಲ್ಲ 18 ಸೇಮ್ ಗೊತ್ತು, ಅದರಲ್ಲೂ ನೀವೇ ಅಲ್ವಾ? ಎರಡು ಸೇಮ್.
Undertake to file wakalat for R1 to R5.
Learned counsel so and so undertakes to enter appearance for R1 to R5. Register to print the name of so and so as appearing for R1 to R5. Interim order ಇದೆಯಾ? Let's the matter on 24th interim order subsisting would continue to the next date of hearing.
23 continues. ಎರಡರಲ್ಲಿ
ಏನ್ ಇಷ್ಟೊಂದು?
5 ಜನ separate sites.
19 to 23. Post immediately after service of ಯಾರು
ಇಬ್ಬರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ವೆಂಕಟ.
ಅವರಿಬ್ಬರಿಗೆ ಇನ್ನು ಮಿಕ್ಕವರಿಗೆ?
He was in trial court.
Same.
Venkata was in trial court.
Learned counsel for the petitioner submits that counsel TM Venkata Reddy had represent
21 and 23.
ಎಲ್ಲರಿಗೂ ನೀವೇ ತಗೊಂತೀರಲ್ಲವಾ?
ನೋಟಿಸ್ ಹೋಗಿದೆ ಒಂದು 2 weeks ಟೈಮ್. ನೋಟಿಸ್ ಸರ್ವಿಸ್ ಆಗದಿರೇ ಇದ್ರೆ we will file.
ಆಯ್ತು ಸರಿ.
And also 73 may be connected.
ಒಂದು ನಿಮಿಷ. ಇದು ಸೀಲ್ ನಂಬರ್ 21 ಆಮೇಲೆ 23 ಲಿಸ್ಟ್ ಆನ್ 24th. ಅದು ಎಷ್ಟು ರೆಸ್ಪಾನ್ಸ್ ಎಷ್ಟು R1 to R4 ಎಲ್ಲರಿಗೂ ನೀವೇನಾ?
ಅಲ್ಲ ಕೆಲವುದ್ರಲ್ಲಿ
ನೀವು ಯಾವ್ದಕ್ಕೆ ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
21 and 23 ನಲ್ಲಿ
ಅದ್ರಲ್ಲಿ ಯಾರಿಗೆ ಹಾಕಿದ್ದೀರಾ?
1 to 4 minutes
ಹಾಕಿದಿರಲ್ವಾ? Since the counsel is already represented, ಯಾಕೆ ಮೇಡಮ್ awaiting service ಅಂತ ಹಾಕ್ತಾರೆ ಇವರು ವಕಾಲತ್ ಹಾಕಿದ್ಮೇಲೆ? The counsel for the respondent TM Venkata Reddy has entered appearance for all the respondents in serial number 21
and
23. Therefore, the indication of awaiting service of notice be deleted and the registry shall responsibly list the matter. ಆಮೇಲೆ ಇನ್ನೊಂದರಲ್ಲಿ
permitted to serve the court
20 and 22 ಅದ್ರಲ್ಲಿ ಹಾಕಲ್ವಾ?
ಅಲ್ಲ ಅವರು ನೋಟಿಸ್ ಹೋಗಿದೆ ಜಾರಿ ಆಗದಿದ್ರೆ
post immediately after service of notice upon the respondents 20 and 22 ಅಲ್ಲಿ ಆಯ್ತಾ? ಯಾವುದು?
19 20
21 ಅಲ್ಲ 19 20 22 21 ಆಲ್ರೆಡಿ ಇದ್ದೀರಾ?
ಸಾರಿ
ನೀವು ನೋಡಲ್ಲ ಅವರು ನೋಡಲ್ಲ. Yes.
73 may be connected. 73.
Tag the petition along with 73. ಅದ್ರಲ್ಲೇನು?
73 is ಜೊತೆ tag. ಅದರಲ್ಲಿ
await ಇದೆ.
ಅದರಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಓವರ್ ರೂಲ್ ಮಾಡಿದೀನಿ ಸರ್.
ಒಂದು ನಿಮಿಷ. ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಇನ್ನೂ ಅದ್ರಲ್ಲಿ. ವೇಟ್ ಟ್ಯಾಗ್ ಮಾಡಬೇಡಿ. Post immediately after service of notice upon the first respondent.
First already filed ವಕಾಲತ್ ಮೇಲೆ.
ಯಾವಾಗ? Learned counsel
P. Prasanna Kumar.
Learned counsel P. Prasanna Kumar has is said to have entered appearance registry to print the Name of P. Prasanna Kumar is appearing for the
B Prasanna. B for bank.
B for Bangalore. All right, yes. B. Prasanna Kumar said to have entered appearance, registered to print the name of so and so as appearing for the respondent. Thus completes the service of notice, lists the matter on 17th for admission. Interim order sub.
ಇಲ್ಲ.
17th for admission.
Needful done, Lordship.
Interim order, yeah? Learned counsel submits needful has been done office to verify. Yes, next. 26 in terms of memo withdrawal. Yes. Same.
I appear for the petition. This is where, my lords, I have been stating.
Rectification of office objections.
ಅಲ್ಲ ಅದು ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ R1 ಗೆ ಅವರೊಬ್ಬರೇ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು. ಮೆಮೊ R2 to 20 ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿ ಅಂತ ಮೆಮೊ ಹಾಕಿದೀವಿ.
ಹಾಕಿದ್ದೀರಾ?
ಅದನ್ನ ಹಾಕಿದ್ವಿ. ಅವರು R1 to R6 ಡಿಸ್ಪೆನ್ಸ್ ಅಂತ ಬರೆದು ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದು ತಪ್ಪಾಗಿದೆ. R1 ಒಬ್ಬರೇ ಅಬ್ಜೆಕ್ಷನ್.
ನನ್ ಮುಂದೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು ಈಗ.
ಹೌದು.
ಓ ನೋಟಿಸ್ ಟು ಅದರ್ ರೆಸ್ಪಾನ್ಸ್ ಎಲ್ಲರಿಗೂ ಬರೆದು ಬಿಟ್ಟಿದೆ.
ಅದು ಯಾಕೆಂದ್ರೆ R1
ಯಾರ್ಯಾರಿಗೆ ಹಾಕಿದ್ದೀರಾ ಈಗ?
R1 ಗೆ ಮಾತ್ರ ಉಳಿಸ್ಕೋಬೇಕು. ಬಾಕಿ ಅವರಿಗೆಲ್ಲ ಡಿಸ್ಪೆನ್ಸ್.
ಎಲ್ಲರಿಗೂ.
2 to 20.
The coordinate bench of this court on 7/11/2024 had indicated notice to other respondents be dispensed with except respondent number 6. The learned counsel for the petitioner submits that the memo was filed to retain first respondent and dispense service of notice from 2 to 23. There has been an error on perusal of the memo. In that light, the first respondent ಯಾರು?
ಅವರೊಬ್ಬರೇ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದು ಕೃಷ್ಣಪ್ಪ ಅಂತ.
ಅಲ್ಲ ಅದಾಯ್ತು, ಇಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಿದ್ದಾರೆ ಅವ್ರಿಗೆ?
ಅಲ್ಲಿ ಅವರಿಗೆ ರಾಮಚಂದ್ರ ರೆಡ್ಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಸರ್ವ್ ಮಾಡಿದೀವಿ.
Counsel for the petitioner submits that he has already served the papers upon counsel who represented the first respondent in the trial proceedings. List the matter on next Friday 11th.
ಅಲ್ಲಿವರೆಗೂ ಒಂದು ಇಂಟರ್ವ್ಯೂ ಇವತ್ತು ಆರ್ಡರ್ಸ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ವಜಾ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ವಜಾ ಮಾಡಿದ್ದಾರೆ. ವೈ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ವಜಾ ಮಾಡಿದ್ದಾರೆ?
ನಮ್ಮ ಬ್ರದರ್ಸ್ ನಾನು ಸೇರ್ಕೊಳ್ಳಿಲ್ಲ. If they don't join me, number 1.
List the matter on 11th. Further proceedings before the concerned court shall remain stayed till the next date of hearing. Yes. On amendment of WP.
Amended petition is filed by the advocate and the court. Only have to amend, carry out the amendment is the original petition.
Amendment petition ಹಾಕಿದ್ದೀರಾ? ಸರಿ ಏನಿದೆ?
My lord, the file is given to them, my lord, I think like correct.
That's all right.
Matter pertaining to my lord acquisition, my lord.
Pradeep Kumar.
My lord, my senior is on his legs. He'll be here in a minute. Just give us a minute.
All right. Pradeep Bandral. Yen Pradeep ಇದು?
Lord, it's covered, my lord. The similar case, my lord, is filed by my lord, same counsel, my lord, in respect of my lord's adjacent survey number has been, my lord. Acquisition.
Covered.
Appeal is filed by status quo order is there already. But there, my lord, the original purchaser is different and subsequent purchase is different.
The case of the petition is that, my lord. Madam.
If they are ready, my lord, I will argue the case. It's not covered, right?
It's covered.
It's covered when
Last.
you lordships get this, my lord. At page number.
Last. 158.
158. 158 is the case where a writ petition was filed by my lord, the wife of the
But
petitioner.
under that order, appeal is filed.
It was
pending. There is an order of status quo.
Which is the one that is covered?
My lords, 158, page number 158. Geeta Shetty, 158.
The compilation.
My lord, index page number 158.
Geeta Shetty.
Yes, wife of the petitioner. Same notification was challenged, my lord.
Wife of the petitioner? This petitioner?
Yes.
No relation.
No relation. I'm sorry, my lord.
You're disowning your wife.
But here is the case, my lord. The Karnataka Shetty is owner of this property, my lord. My lord,
Survey
in
number.
fact,
Adjacent survey number, my lord, in this,
after hearing both the parties,
kindly, my lord,
ಇದು
your
ಯಾವ್ದು
lordship may kindly
ಕರುಣಾಕರ್
come
ಶೆಟ್ಟಿ
to.
ಅಂತಿದೆ.
Karunakar Shetty,
ಅಲ್ಲ,
my lord, entirely
ಅದು
different person is different.
Relatives ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾರ್ದು ವೈಫ್ ಯಾರಿಗೂ ಹಸ್ಬೆಂಡ್ ಮಾಡಿ.
I am sorry, I stand corrected. Sorry.
If they are ready, I will argue the case, my lord. No difficulty.
Ready only.
I will argue the case.
There is this.
How
liquid-
can you mismatch like this? Yes.
There is, my lord, 14 years delay in
419
approaching the
there is
court,
a
and in
delay
the
of-
meanwhile, all the processes have been
ಇವತ್ತು ಬೇಡ. We'll have it on Tuesday in preliminary hearing.
Well, urgency is that, my lord, we have taken possession, land is
ಆಯ್ತು,
developed. and my
Tuesday,
lord,
2 days. 2024 ಒಂದು ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ. ಈಗ ನಾನು ಟ್ಯೂಸ್ಡೇ ವರ್ಗ ಹಾಕಿದ್ರೆ ಪ್ರಾಬ್ಲಮ್.
ಆಯ್ತು.
What?
ಅದು ನೋಟಿಸ್ ಆಗಿದೆ.
Yes. List on Tuesday in preliminary hearing.
Interim order may explain.
Interim order ಇದೆಯಾ?
After hearing both the parties, my lord, granted.
Interim order subsisting will continue to the
On
next.
submission, my lord, I was not heard, my lord.
All right, interim order subsisting will continue to the next date of hearing. Yes.
ತಾವು ನೋಡಿ interim order last
Lord,
ಕೊಟ್ಟು ತಾವೇ
Adjournment ಆದ್ಮೇಲೆ argument
ಅವ್ರು
ಯಾಕೆ?
ಏನ್ ಹೇಳ್ತಾರೆ
Lord,
ಅಂದ್ರೆ,
matter was heard, my lord, thrice, my lord, this honorable court, my lord, declined to grant interim order. Thereafter, my lord, when I was absent, my lord, I was in another court, my lord, my lord.
Before me.
ನಾನು
ಕೊಟ್ಟಿರೋ interim order.
ಹೌದು ಸರ್, ಬೇರೆಯವರು it was came before, my lord, the coordinate bench, my lord, His Lordship Justice Devadas.
Wait.
Lordship kindly.
ತಾವೇ ಕೊಟ್ಟದ್ದು.
ಒಂದ್ ನಿಮಿಷ.
After noting the facts, delay in passing award, my lord has granted interim order.
Lord, in similar line, my lord, the arguments were addressed, my lord, before the division, my lord, the coordinate bench, my lord, the matter was heard, my lord, twice. The interim order was not granted, my lord. I was not there on that day, my lord, your lordship, my lord, granted the interim order.
Yes, sir, ಹೇಳಿ.
What's the matter?
But petitioner purchased the land in survey number 164/2 and 234/2 of law.
I think you should take the mic.
4195. Petitioner purchased the land lot in survey number 164/2 and survey number 232/4 of Vadaga Ulupadi village lot, Mangalore Taluk, to the extent of 6 acres lot. Lord, the application is not entered in his name in the year 2013 and 12. Lord, rubber industry is also blood is being run there. Annexure D is blood conversion order. Then my lord, 19/8/2006.
You are the owner or purchaser?
Owner, original.
ಆಯ್ತು.
19/8/2006, Lord. Annexure E. Lord, the preliminary notification, 1/3 notification, 3/1 notification, and 28/1 notification are issued by Lord, page 65.
Yes.
Proposing to acquire the land. Then, my lord, on 2/7/2007, annexure F, my lord, 28/3 order is passed. Kindly see that, my lord. Lord, deleting the land in survey number 232/2 and, my lord, part of the land in survey number 164/2. Kindly see that order, my lord, annexure F. Page 89. Page 93, my lord. 91.
Yes, sir.
My lord, that Vadaga Ulupadi Grama survey number 164/2 ವಿಸ್ತೀರ್ಣ 4 ಎಕರೆ 5 ಗುಂಟೆ ಜಮೀನಿನ 1 ಎಕರೆ ಜಮೀನು ಈಗಾಗಲೇ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಪೂರಿತರಿಂದ ಹಾಗೂ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಗಳ ಅಗತ್ಯವುಳ್ಳ ಪರವಾನಗಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಇಲಾಖೆ ಕೈಗಾರಿಕಾ ಉದ್ದೇಶಪಡಿಸುವ ಜಮೀನನ್ನು ಕೈಬಿಟ್ಟು 3 ಎಕರೆ 5 ಗುಂಟೆ ಜಮೀನನ್ನು ಕೈಗಾರಿಕಾ ಉದ್ದೇಶ ನಿರ್ಧರಿಸುತ್ತೇವೆ. Then, my lord, page 93 regarding 232/4. Lord, got it? 93. my lord.
Yes, sir.
Unnumbered paragraph 3. They have passed this order on 2/7, not 2006. Then, my lord, on 8/1/2010, Annexure G, page 95, my lord, final notification is
Compensation ತಗೊಂಡಿದಾರಲ್ಲ?
ಇಲ್ಲ. 17 ವರ್ಷ ಡಿಲೇ in passing the award.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಈಗ ಮೊನ್ನೆ ಪಾಸ್ ಆಗಿದೆ.
ನೀವೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು?
But I am questioning the notification
Of 2006.
as well as
When-
award both, because
When did you file the petition?
my lord, in 24. my lord.
Then?
24. My lord, question is now, my lord.
Allah, question is not that, question is delay.
Deal. I will explain. There is no difficulty.
Then
When I
we'll
explain,
dismiss it.
I am able to convince your lordship, my lord, with this regard, my lord. Absolutely no difficulty, my lord.
Yes, sir.
But I agree. There is no delay according to me. Not kindly see the
Page 19 prayer ಬನ್ನಿ. Page 19 prayers.
prayer has been amended, my lord, now.
ಅದು ಅವಾರ್ಡ್ ಚಾಲೆಂಜ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಿರ ಅಷ್ಟೇ. ಪ್ರೇಯರ್ ಫಸ್ಟ್ ಹಾಕಿದ್ ಹೇಳಿ. ಪೆಟಿಷನ್ ಫಸ್ಟ್ ಹಾಕಿದಾಗ ಪ್ರೇಯರ್ ಏನಿತ್ತು ಹೇಳಿ.
Prayer 2010 notification questioning ಮಾಡಿ.
ಸೊ 14 ವರ್ಷ ಡಿಲೇ ಫೈಲ್ ಮಾಡಿದ್ರಲ್ಲಿ.
ಇದೆ.
ಏನ್ ತೊಂದ್ರೆ?
But according to me, there is no delay. Why? Because I am explaining that. The award is possible by the authorities. Kindly see. When it is, my lord, on 20.
ಪ್ರದೀಪ್ ಇದರಲ್ಲಿ
4 to
ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್
23.
ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ. In all this. Yes.
24 to 23. Lord, award is passed. Nearly after, Lord, 10 notification, 19/8/2006 notification, no notification. Lord, 2/7/2006, my lord, they pass an Lord, order stating that no, we will delete this much. Award is passed after 16 years. Lord.
Yes.
Lord, there are interim communication with the government that they do not want to, Lord, propose to take acquire the land. Why? Because industry is being run there, rubber industry. And Lord, the award is possible in 2022. Nearly, my lord, kindly see the, my lord, 2006, 19/8/2006 is preliminary notification. 8/1/2010 is the, my lord, final notification. Lord, 22, especially, my lord, 18/8/22, my lord will find the award is passed. Annexure P, page 133.
Yes.
Lord, the petitioner questioned the final notification as well as award both, my lord. But according to me, my lord, there is no delay on my part because award is not passed more than, my lord, 2006. It counts, my lord, more than, my lord,
Yes.
14
Sure,
years.
sir.
No, my lord, I am coming to the principle by 7 golden principles are laid down by Supreme Court.
ಕೊಡಿ sir.
It is there, my lord, on record.
On record.
That is what, my lord. My lord, 2024 10 SCC, my lord, Kolkata Municipal Corporation. Only my lord is acquainted with this case law. My lord, the Supreme Court examining the acquisition law, my lord, para 33 has laid down 7 golden principles, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್ ಗೋಲ್ಡ್ ಕಾಣ್ತಾನೆ ಇಲ್ಲ ಇಲ್ಲಿ?
My lord, Kolkata Municipal Corporation.
ಜಡ್ಮೆಂಟ್ ಇಲ್ಲ ಇಲ್ಲಿ. ನಿಮ್ ಅಗೇನ್ಸ್ಟ್ ಇರೋ ಜಡ್ಮೆಂಟ್ ನೀವೇ ಕೊಡ್ತಾ ಇದ್ದೀರಿ.
22/5 ಅಲ್ಲಿ ಬಂದು we have filed this judgment, my lord.
Yes, madam, 22/5 ಇದೆಯಾ?
Passed over, my lord, so I will provide.
Otherwise, my lord can put it in 2 step, but I'll produce I'll ask him to produce it.
Yes, which is the judgment ಕೊಡಿ.
My lord, Kolkata Municipal Corporation versus Bimal Kumar, my lord.
Oh, that is 2024.
ಹೌದು.
ಕೊಡಿ.
para 33 ಅಲ್ಲಿ.
Notice is
I
to be
don't
issued
think,
is
my
what,
lord,
my lord, the court says, and party has to be heard is what that decision says.
You are not heard here, is it?
He has
No,
been
I have not
heard.
been heard.
He has participated in 28-3 inquiry.
I have not
and
been
we have
heard, my lord.
produced him
I have
a
not been heard at all.
Proceeding sheet also, which is at the page number.
What ground is, my lord, my name is not mutated.
By tomorrow you file all your
Yes.
judgments, whatever you want. Adil paragraph mark ಮಾಡ್ಕೊಡಿ. We'll take it Tuesday as in the preliminary, in the first hour itself. List on Tuesday.
Please.
Yes.
Interim order.
Entry order ತಪ್ಪಾಗಿ ಕೊಟ್ಬಿಟ್ಟಿದೆ. Yes.
ಅಲ್ಲ, ತಾವು till Tuesday, okay.
Till Tuesday. ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅಲ್ಲಿ.
ಕೊಟ್ಟಿದ್ದೀರಾ?
Till Tuesday. Yes.
Lord, presence memo.
Heard the learned senior counsel MS Bhagwat appearing for the petitioner, learned senior counsel Basar Shabrad appearing for the respondent along with Pradeep Kumar. List the matter on Tuesday. The counsel for the petitioner shall file a list of dates and events and list of authorities.
Now,
And the respondent as well. Yes. Both the parties of the body. Yes, next.
My lord, I'm appearing for the respondent. We have filed wakalat today, requesting 2 weeks of time to file statement of objection.
1 minute, sir. Learned counsel so and so undertakes to enter you've already filed wakalat?
Yeah, I filed it today morning.
Has submits that is entered appearance for respondents 1 and 2. Who are respondents 1 and 2?
One respondent, my lord.
Who is second respondent?
There's only one respondent.
Only
the
one.
MD and
The sole respondent. Registered to print the name of so and so as appearing for the respondent. Objections, if any, by the next date, list the matter on 7 CRP naidu. GMCPC list the matter on 16th in preliminary hearing. Objections, if any, by the respondent by then.
My lord, interim order.
Interim order subsisting will continue till the next date of hearing.
Much obliged.
Here for respondents 11 to 13, what has happened here is the property has been sold in the year 1989. They do not produce that sale deed. The husband of the first petitioner and the father of petitioners 2 and 3 is a witness to the said sale deed. Property has changed hands. Now they file a suit.
Now what has happened?
Now what has happened is compensation.
Disburse compensation.
26 ವರ್ಷ 36 ವರ್ಷ ಆಗಿದೆ. Property mari they have suppressed, they have not produced the sale deed, have the original sale deed.
Compensation disperse agilva inno agogide.
No, ಆಗಿಲ್ಲ.
Yes, sir.
Counsel on record is unwell, my lord.
The case will vacate the interim order. He'll become well.
Very short accommodation.
Tomorrow. Please. Interim order ತಗೊಂಡ್ಮೇಲೆ ready ಇರ್ಬೇಕು.
He was unwell, my lord.
Yes.
Please.
Yesterday, my lord, they filed it with some new documents also, some calculation. That, sorry, my apologies. This is not
matter.
33.
Yes, sir. ಇಲ್ಲ ಕನ್ಸಿಡರ್ ಅಷ್ಟೇ ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಆಗಿದೆ. ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಪ್ರಕಾರ ಅವ್ರು ಏನು ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಂದ್ರೆ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ. ಅಷ್ಟೇ ತಾನೆ?
ಇಲ್ಲ, ಕನ್ಸಿಡರೇಷನ್ ಏನಿಲ್ಲ. ನಾವು ವೆದರ್ ದಿ compensation has to be awarded.
ಅದೇ prayer B, we will direct them to consider the representation and pass necessary orders.
Already 50 years agide Swami. Unless there is a positive direction, they will never do it. At one time they admit that land has been acquired.
No.
After 30 years they give.
Have you one minute.
During the pendency of the writ petition, spot inspection was.
Spot inspection was directed. Report of spot inspection is here. Either prakara you have utilized the land in so many ownership and.
2,986.
I'm sorry, madam. Two things. One, it's Gramatalan land, which we have earlier issued an endorsement saying that it's a Gramatalan land, therefore.
That I will quash.
Great.
That I will quash and direct you to pay compensation for the usage of the land like this.
My lords, the extent is under dispute. We'll determine, my lords, after by considering the representation.
I accept the report given by the survey.
My lords, the extent is large. We don't know which portion, my lords.
You determine and do it. But within a time frame.
Yes. Great.
The petitioner is before this court seeking the following prayer. The issue in the list is with regard to payment of compensation to the petitioners for usage of the land by the BDA for formation of the road. The petitioner is said to be fighting for the payment of compensation for several years now. During the subsistence of the subject petition, pursuant to the orders passed by this court, a joint survey or joint inspection was conducted. The result of the joint inspection is placed before this court. In terms of the joint inspection so conducted, it transpires that several packets of the land of the petitioner has been utilized for the purpose of formation of road out of the large extent where road is already formed. Therefore, the
And 800 square feet as allotted to some allotted.
apart from the fact that about 800 square feet have been allotted to an allottee who had applied to the hands of the BDA. This is what is borne out from the joint inspection report. The learned counsel Muniappa, appearing for the petitioner, accepts the report in its toto and submits that compensation be determined in terms of what the joint inspection report is. The learned counsel appearing for the BDA, Sachin, would submit, BS Sachin, would submit that the extent is large and the extent of formation of road and any allotment would be determined on consideration of the representation of the petitioner. But however, has filed a detailed note with regard to what the survey report would indicate. The survey report indicates the following, flag in green. In the light of the acceptance by both the parties of the joint inspection report or the survey report as the case would be, I deem it appropriate to answer prior B of the petitioner, which is a direction to consider the representation of the petitioner. The representation of the petitioner shall merit consideration strictly in consonance with the report of the survey, which both the petitioner and the respondent are accepting, except to the fact that a further determination out of the larger extent should be made by the BDA. Since the petitioner has been fighting for compensation for years, I deem it appropriate to direct the BDA to consider the representation as per the survey report and pass necessary orders in accordance with law.
Market value, my lord.
In accordance with law. In accordance with law, within 4 weeks, huh?
4 weeks.
Within 4 weeks from the date of receipt of the copy of the order. It is needless to observe that there is no reason to disbelieve that the BDA would not drive the petitioner yet again to this court on the same cause of action.
Survey, my lords, may I refer to survey report dated 10/8/2020.
Survey report dated 10/8.
2023.
23.
Yes. Can I make one request? Question of title be left open, my lords.
In accordance with law,
Great.
If they are not done,
Can I request for 8
liberty
weeks?
to move before this court, my lord.
Always liberty is best.
8 weeks.
8 weeks.
Great.
Next. Yes. ಇದರಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದೆ.
ಹೌದು, ಈಗ ನಿನ್ನೆ ರಾತ್ರಿ they filed
Why do you file documents overnight?
No, these are not the documents. It's only a statement of the measurements.
But then we'll have to see
Original sanction plan.
ಮೊದಲೇ ಹೆವಿ ಮ್ಯಾಟರ್. ಇನ್ನ ನೀವು ಇದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ?
ಏನ್ document ಏನ್ ಹಾಕಿಲ್ಲ. Only a statement of the measurements in the original sanction plan and the modified sanction plan. We have given how the FIR and the UDS is affected, because their cases UDS and FIR is not affected.
I asked a synopsis and authorities to be filed. Is done.
It was filed. That's what they are submitting, that it was served on them yesterday.
ನಿನ್ನ ಹಾಕ್ಬಿಟ್ಟು
Synopsis ಹಾಕಿದ್ದು.
ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದಾರೆ.
It is not here.
ಇಲ್ಲ, yesterday morning it was filed. Written submissions, some charts showing the measurements.
Or written submission. ಇದರಲ್ಲಿ written submission ಅಷ್ಟೇ.
ಇಲ್ಲ, 7 documents.
Along with statements. They have filed written submission saying this is the measurement, the modified plan, we get more UDS and there is no violation of the FIR. We have filed a statement saying how the UDS is affected and FIR is affected.
Time ಬೇಕಾ?
I have to look into it. I'll check with clients and then look into it.
ಗುರುವಾರ ತಗೊಳ್ಳ? Next Thursday.
Can it be Tuesday? Next
Tuesday I have the Twitter matter likely to take the whole day.
Tuesday.
Wednesday GMCPC. Interim order ಇದೆಯಾ?
Interim order ಇಲ್ಲ, that is the problem. Only thing is a lot,
There is a suit
honorable,
filed.
this honorable court has
Address
said
filed. Suit filed.
that whatever construction they make is at their risk, no equity shall be pleaded.
A suit
So-
is filed, that order, my lord, is passed after hearing both the parties.
All right.
15th ಆಗ್ಬೋದಾ? Tuesday.
15th ಆಗ್ಬೋದು, 15th ತೊಂದರೆನೇ ಇಲ್ಲ. 15th at 3:30 PM. Yes, sir, Surnand, sir.
I'm just checking. Yes,
15th at 3:30 PM.
great.
Heard the learned Surnand and learned senior counsel Sudhevalla appearing for the petitioner. Less the matter on 15th.
ಅಲ್ಲ 3:30 ಆದ್ರೆ ಮತ್ತೆ 17th ಹಾಕೊಡಿ, ಯಾಕಂದ್ರೆ ಅದೊಂದು ಮಧ್ಯಾಹ್ನ ಒಂದು ಇನ್ನೊಂದು ಹಾಕೊಂಡಿದ್ದಾರೆ.
2:30.
ಅಲ್ಲ 2:30 ಇನ್ನೊಂದಿದೆ, ಅದು ಮತ್ತೆ ನಡೆದ್ರೆ ಬೇಡ.
ಇದಾದ್ರೆ ಬೆಳಗ್ಗೆನೆ ಬರುತ್ತೆ.
17th ಆಗ್ಬೋದು.
ಅಲ್ಲ, let it be in the list.
ಅಲ್ಲ
ಬೆಳಗ್ಗೆನೆ ಬಂದ್ರೆ ಬೆಳಗ್ಗೆ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. Because it's an old matter, it will come at the top. Yes.
Great.
I try to take an adjournment in other matter and come here.
Yes.
Koka matter. Koka matter, my lords, wherein your lordship had asked
Yes.
filing some material.
Silent ಅಂದ ತಕ್ಷಣ ಗೊತ್ತಾಗುತ್ತೆ. ಈ ಕೋಕಾ is quashed ಅಲ್ಲ?
Not question.
ಇಲ್ಲಿ challenge is to Koka here.
Entire.
399 402 no problem because you were in a police station. So ಅದೇನು, what is that? ಈ ತರ ಮಟೀರಿಯಲ್ ಯಾವ್ದೋ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಸ್ಕೆಚ್ ಕೊಟ್ಟಂಗೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
The reason why I filed this was I didn't want your lordships to go through the papers back and forth. Lord, in so far as Koka is concerned, my lord, section 19 is what permits the statement of the petitioner or any other accused person to be held against him. Lord, there are certain directions as under Koka, my lord. Number one is that it should be a person of a rank of superintendent of police or above. Number two, it should be that it should be in his language.
You filed a synopsis?
Yes, my lord, I filed my additional grounds as well with respect to the same.
Yes, Jagdish sir.
Yes, my lord. My argument, my lord, is section 19 of the Koka Act. This argument is except apart from confession statement, there is no material available against.
But that is available, that can be taken under Koka.
Yes,
Yes, ma'am. Yes, ma'am.
that's my statement. Lordship, we see section 9.
With respect to that very same aspect, my lords, there are 5 conditions which have to be complied for section 19 statements to be considered.
Correct.
Number 2, my lords, is that it should be in my own words. Number 3, there should be a memorandum which is attached to the bottom of the sheet. Number 4, it should be in a place where it is comfortable for the accused person. Number 5, my lords, there should be some, my lord, it should inspire confidence. The statement itself should inspire confidence is the words of the Supreme Court, my lords. Lords, I've already placed it, my lords. It's in a spiral bind, my lords.
Spiral.
It's there, my lords. I just placed it before the court. Now 2025. My lord, section 19 of Koka is parametria to both, my lords, Mocha as well
Mocha
as
and Koka, yes.
as well as Tada, my lords.
Yes, correct.
Lord, if your lordships would be pleased to just take my synopsis, my lords. Portion C of my synopsis, my lords, is only concerning Koka and the judgment, and with respect to how section 18 and 19 act. Not in all of this, my lords, they say, firstly, my lords, the person should be given some amount of time to reflect as to whether he wants to confess or not. My lord, and this should not be in the area which is supervised by the police, not in a police station. And in the first case, my lord, which I have produced in Roman number 4, page number, my lords, he was in a BSF camp. His statement is recorded in a BSF camp. The Supreme Court holds, my lords, that him being in the BSF camp at the time of reflecting itself is wrong. And number 2, my lords, there is no mandatory memorandum or certificate attached in any of our statements in our case, which is also a mandatory requirement. My lords, only when all of these 5 conditions as required under section 19 are considered or, my lord, are adopted in a case, can a statement under section 19 act admissible insofar as I am concerned. My lord, when the statements itself are not in the words that are given out either by the petitioner or by any of the other accused persons, and they are cyclostyle in nature. My lord, exact same statements. My lord, there is one judgment which, my lord, in Roman number 4, page number, my lords, the first statement, State versus Dinesh Tiwari.
Muhammad Iqbal.
My lord, Roman number 4, my lords, I've extracted all the relevant portions, the first 4 pages.
C, my lord.
My lord,
C.
Yes.
Serial number?
Lord, ತಾವು first
Page
3
number,
page
Roman number.
ತಿರುಗಿಸಿದ್ರೆ 4 page ತಿರುಗಿಸಿದ್ರೆ index ಮುಗಿಯುತ್ತೆ.
Oh, ಎಲ್ಲ
I have
ಇಲ್ಲೇ
extracted the relevant portions.
yes, yes.
ಅದರಲ್ಲಿ page number 4 Roman number.
The admissibility, I'm there.
Yes, my lord. My lord, this judgment is of the Delhi High Court. My lord, it is exactly on our point that when it is not accompanied with the memorandum.
Where do you get that 5 principles?
My lord, it's in the act itself.
Act itself.
It's a part of the act.
What is it? Koka could. Section
19. Lord, certain confessions made to a police officer to be taken into consideration.
Yes.
Lord, first one will not be applicable to us, my lords, because it's a person of a rank of SP who's recorded the statement.
All right.
Number 2 will be, my lord, the confession shall be recorded in free atmosphere in the same language
yes,
in which the person is examined and as narrated by him. Number 3, the police officer shall, before recording any confession.
Mocha has the same thing.
Mocha and Tada.
Mocha and
Exact
Tada
same.
has the same thing.
My lord, and Kartar same. Of the
Then
Supreme
straight
Court.
away come to page 71. Sorry, page 61, where confession is recorded under Tada.
Yes,
Rule
my lord.
15.
My lord, for the purpose of convenience, my lord,
You have already.
I've already extracted it.
All right. Yes.
My lord, the first judgment, my lord, it's of Delhi High Court.
That is Dinesh Tiwari.
Yes, my lord. My lord, this is again on the same point. They have acquitted him only on the ground that the mandatory requirement as under Mocha, that is the memorandum was not attached. Lord, the next judgment will be material to our case, my lords, because this is of the Supreme Court. This is under Tada. My lord, Tada was the one which laid down all these guidelines, my lord.
Correct. Began with Tada.
Yes, my lord. My lord, page number 7, my lords, Roman number 7. My lord, the second judgment starts. My lord, para number 14 of the judgment, they explain these principles, my lords. The next page, my lords. While sub-rule 1 mandates that the confession under section 15 of the Tada Act should be recorded in the language which the confession is made, but if that is not practical, then it should be recorded in the language used by such police officer for any official purpose or in the language of the designated court. In any case, the confessional statement shall form the part of the record.
Yes.
As per rule 2, the confession so recorded shall be shown, read or played back to the person concerned. If he does not understand the language in which it is recorded, it shall be interpreted to him in a language which he understands. At that stage, the person making the confession shall be at liberty to explain or add to his
Now,
confession.
one clarification.
Yes.
You are into this web of crime only on your confession, Koka.
Only on the confession.
Nothing else.
Nothing else.
Yes.
Lords,
120B and code.
120B IPC.
Yes.
Lords, 14.3. The requirement of sub-rule 3 is that the confession, if it is in writing, shall be signed by the person who makes the confession, as well as by the police officer. Additionally, the police officer shall certify under his own hand that such confession was taken in his presence and recorded by him. He shall also certify that the record contains a full and true account of the confession made by the person at the end of the confession. The police officer is required to make a memorandum, the substance of which is that the police officer had explained to the person concerned that he is not bound to make a confession, but if he does so, the same may be used against him as evidence. This is not available anywhere. The memorandum should contain a certificate of the police officer that he believes that the confession was made voluntary in his presence and recorded by him, that it was read over to the person concerned who admitted the same to be correct, containing a full and true account of the statement made by him. Subsection 4 deals with situation where the confession is recorded on a mechanical device. Since the device, my lord, this does not concern us. The next
Yes.
point, my lord. Mandates that every confession recorded under section 15 of the Tada Act shall be sent forthwith to the jurisdiction chief judicial magistrate or the chief metropolitan magistrate, as the case may be, who shall forward the recorded confession so received to the designated court, which may take
Text of
cognizance.
Tada.
What, sir?
The
Now-
text of Tada. Section 15 of Tada.
So this is
Rule.
Yes, madam.
This is the interpretation
Tada,
of Tada.
yes. That is interpreting Tada Rule 15.
Yes,
Yes.
and this is exactly what
It's
section
in
19
parameteria with
Yes.
Mocha and Koka is what he says.
My lords, now they refer to Kartar Singh on the next page. My lords. Para number 17, that's page number 10.
Yes.
My lord, in this they hold, this is, my lord, this is the 5-judge bench of the Supreme Court, wherein they hold, unless and until these 5 guidelines are considered, none of these confession statements can be admissible in the eyes of law. My lord, and if your lordships were to just take one more application that I had filed, my lords, I have filed an order sheet. I filed it today, my lords.
Really?
My lord, page number 36. My lord, my police custody is taken twice, my lords, after Koka is invoked. My lord, my statements are recorded on 4/4 and 6/4. My lord, 35, my lords. On page number 35 and 36.
One sealed cover said to be containing confession statement of even kept presence.
My lord, next page, my lord, 36. Accused number 11 and 12 have submitted, the police have taken the signatures on blank white papers and also thumb impression, and the accused 18 has submitted that the police have taken a signature on blank paper and type papers without reading the contents. The advocate representing the accused numbers 11 and 12 are also present. Accused number 11 and 12 and 18 are taken to court custody and remanded it to JC custody. My lord, next page, my lord, 37. His submission is recorded at the appropriate stage. Court will pass orders in this regard. My lord, in fact, as under Koka, my lord, if a person is coming and making a submission as such, my lord, on the very same day, the court had to initiate proceedings against him, or some sort of inquiry had to be conducted. My lord, I am not on one score that because of one aspect that the memorandum is not there, the confession statement has to be rejected. My lord, accused number 1 and 2 give the statement on 20th, and then again on 23rd, 3, my lords, of 2017. My lord, both of these statements, in the manner in which they implicate the accused number 11 and this petitioner, is exactly the same, cyclostyle in nature. My lords, and my statement recorded on 6 and 6/6, not 4/3 and sorry, my lords, 4/6 and 6/6, while I'm in police custody, is exactly the same. My lord, that is the chart that I produced before your lordships. And thereafter, my lords, there is not even a whisper about the time that I was granted to reflect on whether I want to confess, whether I was even informed that such statement, if made by me, will be held against me. Absolutely nothing. My lord, and if your lordships were to kindly take up the my lord, the additional documents I filed on the earlier date, my lord, the order of the coordinate bench, while
Quashing Koka.
My lords. My lord, they extract all the cases which were filed against me.
Justice R. Nataraja.
Justice R. Nataraja. My lord, in that, my lords, if your lordships were pleased to just take, my lord, there is a portion of the judgment, my lord, page number 61.
61 of this?
Yes, my lord. Of
Compilation.
Of the, my lord, judgment of R. Nataraj Sahib.
ಅದು ಯಾವ್ದ್ರಲ್ಲಿದೆ?
Lord, I filed it on 21/4/25 along with the memo, my lord.
Yes.
Lord, page number 61 in that.
61 ilve illa.
Sir, this is an old document. So sorry, sir. I'll give you another copy right now. You can have a copy.
No, Mayur.
Lord, in the petition as well, that's the last document. Even in the petition, Lordships gets the last page. There's no petition.
Yes.
My lord, in that as well, there is a table indicating, my lord, in that order.
Yes.
Of whatever the cases pending insofar as these accused persons are concerned.
Lord, no, you are appearing only for one accused, or?
I am only appearing for accused number 12.
Accused number 12, that is silence on.
Yes.
Yes.
My lord, if your lordships were to just go through Kavita Lankesh's judgment, my lord, as your lordship is very well aware of it. My lord, I have even produced it along with
it's here, it's here.
Yes, my lord, compilation.
Yes.
Lord, if your lordships were to just take that judgment for a second. Lord, in this, my lord, the Supreme Court had the opportunity to consider as to when 24(1) and 24(2) had to be considered, or when a sanction had to be provided. My lord, under 24(1), what a person of a rank of IG is required to do is to consider whether there is at least one case which connects all of these accused persons in furtherance of a criminal syndicate. Lord, if your lordships would be so pleased to just consider that table now, my lord, not one case. Not one case connecting any of these accused persons.
And that's why it was quashed.
Yes, that is the main reason why that matter was.
So the confession statement and no offense made out. Why surveillance you have printed?
Lord, on the last date of hearing, I had made a submission to your lordships, and the lordships had directed me to
is a pleading to that effect?
Yes, Lord, what happens in this matter is, Lord, there is one case filed in Yelahanka police station in crime number 42 by 2017. FIR comes to be filed against two people. Accused number 1 in that is the accused number 11 in this case, and another person. Lord, this petitioner is nowhere even mentioned in the complaint, nowhere in the FIR. Surveillance is being conducted in his house. He is dragged from his house, taken to the police station. On 8th, he is produced before the court. 504, 506, read with 34, my lords. Police custody is granted for 14 days.
504, 506.
504, 506. For 14 days, and while he is in custody in that case, between 8th to 21st. 20th, they implicate him in crime number 58. Lord, it's not one issue that pops up when it comes to this petitioner, my lord. It has been a continuing offense since 2019.
You have glorified silence, Adik.
My lord, the person who's glorifying it is not the petitioner, but the police department themselves.
Yes.
No, always police.
Huh?
Always police.
Correct, always police.
Always
Most decorated silent person. Yes.
And that is the issue, my lord.
Yes, Jagdish.
Yeah, all the judgment which my learned friend is relying on, or the judgment rendered post-trial, whether the confession statement was recorded in accordance with law, whether time was given or not given, is all matter of trial. Now, Lordship, you see, he's talked
But
about
ಈಗ confession statement, you forget it. Confession statement now taken, admittedly is not in consonance with those 5 principles.
No, but that's a matter of trial.
Prima facie ಇರ್ಬೇಕಲ್ಲ.
No, Your Lordship,
Trial, corroboration in trial. Yes.
Your Lordship, you see order sheet 36, my learned friend read
Yes.
trial court order sheet page 36.
Mm.
He is not retracted. He has no allegation against the police.
Sir, I have stated it, sir, that they have taken my signatures
I'll
on
show
empty
it.
sheet.
That's all right. Yes.
That's an allegation.
Order sheet.
Order sheet, page 36, madam. Second para. All the accused submits before the court that not
Complained anything against police
regarding ill treatment and cruelty on them.
Yes.
So that itself shows that the time of the whole allegation, my lord, the
They
principles are there.
voluntarily given their statement.
Yes. Whole principle, my lord, that they should not be torture, they should not be intimidation, they should not
ಅದಕ್ಕೆ
be.
ಹೇಳ್ಬಿಡ್ತೀವಿ ಏನ್ ಬೇಕಾದ್ರೆ.
ಹೇಳಿದ್ದಾರೆ.
My lord, even going on that lines, my lord, there is another judgment which I have produced in the compilation, wherein they very clearly hold.
Don't get worried about. Yes.
Grateful.
And second, my lord, they should have said it that police.
Jagdish has his own way of telling it. Yes.
He is very fair when it comes to these.
Absolutely. Yes.
So they should have said it that police have recorded my statement. They've taken or my lord, they've said it, they've taken signature on blank paper. No problem. They have not recorded statement. They've taken a blank signature. They should have said it. They've taken a blank signature to implicate me in a Koka. Please take it that I have not given any statement.
All right.
That should have been in the, because the advocate was there, accused was there. And our case, my lord, that it is, we have not ill-treated them. We have given them in complete faith and then they've recorded a statement. And whether the statement was.
But police custody ಯಾಕೆ ತಗೊಂಡ್ರಿ?
The third time.
Recovery.
ಅಲ್ಲ 504, 506 ಅಲ್ಲಿ why did you take police?
399 and 402.
ಅದು ಆಮೇಲೆ ಬಂದಿತ್ತು.
ಈ ಕೇಸ್, this case is pertaining 399 and 402.
ಯಾವ್ದ್ರಲ್ಲಿ 504,
But
506?
crime number
ಇನ್ನೊಂದ್ರಲ್ಲಿ.
42, where I was in custody, in that for 14 days.
ಇಲ್ಲ 504, 506.
He has not said it and I is bringing out now.
I have produced a
All
copy
right.
of the FIR
I'll have to speak why
ಅದೇನ್ ಪರವಾಗಿಲ್ಲ.
14 days custody was
ಮತ್ತೆ
sought.
ಲಿಸ್ಟ್ ಮಾಡೋದು ಬೇಡ. Answer all this. Those 5 principles,
Yes.
surveillance will see if
But
it
the
has to
reason
be
why I have not
answered.
produced any judgment in reference to Koka when it comes to confession statements, my lord, this issue is never raised yet. There are
No,
no judgments with it.
Whatever it is,
Yes.
issues never come up.
Yes, my lord. With respect to section 19, it's never come up. It's only with respect to 18 which has been
Tada.
referred to, of Koka, my lords. 18
Koka,
Koka and
18,
15
yes.
of Tada.
19 will see, will
Section
answer.
19, there is no discussion on this issue.
Will answer.
Yes.
Yes. One of those first we will do is, if needed.
And the surveillance, my lord, then we filed application yesterday. I have not.
Surveillance we will see.
Yes.
Surveillance, see what happens is, when a name is drawn in the rowdy sheet, the police have a duty to conduct surveillance. Not that surveillance should be intruding into privacy, but surveillance, yes, is necessary. ಏನಂದ್ರೆ information ಅಂತ ಅಷ್ಟೇ.
May just take 2
ಬಹಳ
minutes of your
ಸೈಲೆಂಟ್
lordship's
ವೈಲೆಂಟ್
time.
ಆಗಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತದೆ ನಮಗೆ. ಬಹಳ ಸೈಲೆಂಟ್ ಅಲ್ವಾ ಹಂಗಾಗಿ.
ಅದಕ್ಕೆ.
May just take 2 minutes of your lordship's time.
Yes, yes.
My lord, the way, in the manner in which privacy laws were evolved in our country, my lords. Number 1 was Karak Singh, when they spoke about UP regulations,
Correct.
rule number 236. Then came Gobind. Gobind was again a rowdy sheeter who was challenging it. Karak Singh
That's
as well.
what. No, I will look into that and answer.
Yes,
Prima facie view is.
Karnataka state, for a matter of fact, my lords, none of the police regulations, not the police act, governs it or lays down regulations for it. And that is the only issue, my lords. If there were regulations for it,
We will direct that also to be done. Other states ಅಲ್ಲಿ ಇದೆ.
every state has it, my lords, other than Karnataka state.
Surveillance, my lord,
No,
your lordship.
surveillance regulations on people who have been people who have been rowdy sheeter is there in all states that I've seen. Illu ಒಂದು direction ಕೊಡೋಣ.
But surveillance with respect to prevent
No,
petitioner.
you should have some
No, no, no,
guidance. See,
that's
ಏನಾಗುತ್ತೆ, you ಎಲ್ಲಿ ಹೋಗ್ತಾರೆ ಬರ್ತಾರೆ, you can't see, you can't, he is a criminal or whatever, is alleged criminal, accused, whatever it is. But you can't intrude into privacy of someone by keeping constant surveillance on them.
There is one statement made
unfortunately,
by the
no,
Andhra
the
Pradesh High
police are-
Court.
police are
called,
want-
my lords, they say your freedom to surveil ends when it touches my nose.
That's
That's
correct. No, I no dispute, my lord, but if the police were doing so much of surveillance, no crime would have happened in this country. No,
No.
but I'm saying, my lord, they
I
don't.
tell you, problem, and you ಹೇಳಿದ್ correct, that's an egalitarian society. But what happens here is,
And that's the problem.
that's the,
That's the problem. But in this case, there is no connivance.
ಅಲ್ಲ, ನೋಡೋಣ.
Deeply obliged.
So surveillance also, my lord, it is not that we are following him every
ಇಲ್ಲ,
day. and it is-
it's not that.
Yes.
Grateful. Lords, interim order may be continued.
Interim order subsisting, heard reserved, interim order subsisting would continue till the disposal of the petition.
Deeply obliged, my lords. Grateful for that.
So 19, there are no judgments here.
19, there is no judgment.
In Karnataka High Court, Koka may interpretation is.
Supreme Court illa, Karnataka High Court illa.
But your lordship may also keep in mind, my lord, that all the interpretation, even for section 15.
Post-trial.
Post-trial. So,
No, post-trial, no problem.
yes, my lord.
But prima facie material that was 5 conditions, we see,
In fact, the statement itself.
post-trial or pre-trial that a judgment would determine. But here it is the mandate of the statute itself.
In the statement itself, they
Yes.
should have initially recorded
Correct.
questions.
On the mandate of the statute, if it is in compliance or not compliance, we will see. Judgment to trial admele when there is no law, there is, the statute is already here.
In fact, the
In
statement.
fact, ask questions, my lord. Are you aware of what this section is? Now, ಇದ್ರಲ್ಲಿ statement ಕೊಟ್ರೆ ಇದ್ರ ಮೇಲೆ ನಿಮ್ಮ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೋಬಹುದು. ನಿಮ್ಗೆ ಅದು ತಿಳಿದಿದೆಯಾ? ಅದನ್ನ ಬಿಟ್ಟು ಕೂಡ ನೀವೇ ಇದನ್ನ ಬಂದ ನನ್ನ ಮೇಲೆ.
ಅದು ಸುಮ್ಮನೆ ಫಾರ್ಮಾಲಿಟಿ ಎಲ್ಲ ಗೊತ್ತಿರುತ್ತೆ ನಿಮ್ಗೆ.
But even that is not done.
Introductory questions also should have been asked. Unfortunately, it is not there, but that should have been the.
ಅದಕ್ಕೆ let us regulate something.
Yes.
Yes.
But whether cyclostant or not cyclostant, it's a matter of time.
That's
But
a different thing.
Yes.
Yes. But those 5
My lord, why
mandate
cyclostyle
of the
becomes
statute should.
why cyclostyle becomes material, my lord. Not if a person, if I'm making this argument with your lordship.
ನೀವೇನ್ cyclostyle ಹೇಳ್ತಾ ಇದ್ದೀರಾ? If you go and sit in a police station,
Yes, my lord.
ನೀವು charge sheet column 17 and column 7 is not written by the IO, written by the writer sitting there.
Exactly, my lord.
He writes everything. ಅದು ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ. 498 ಆದ್ರೆ ಏನಿದೆ, 307 ಏನಿದೆ, ಎಲ್ಲ verbatim same allegations.
ಇದ್ರಲ್ಲಿ 92 ಅಲ್ಲಿ.
Last Saturday, AG was there. We were having a meeting with IPS officers. We were telling them the column 17 is so short. It's shorter than the
Column
FIR.
10 of the FIR.
FIR content of FIR.
ಅದೇ column 10 of the FIR.
Column 10 of the FIR.
19.2, my lords, in Koka is very clear on the point that it should be in the words that I say it. That is the problem.
That's it.
Grateful. Yes.
Lord, this writ petition is of dependents number 19 and 22 in the lower court.
Mike use ಮಾಡಿ sir.
My lord, this writ petition is of dependents number 19 to 22 in lower court, my lord.
19
19 to 22, my lord.
ಹಾ,
Depends because there are 29 dependents in the lower court, my lord. Of them, 19 and 22 are challenging the orders passed by a lower court on IA number 5 and 6, my lord.
what is the applications?
Application was for rejection of the plaint under order 2 rule 2 and stay of the proceedings.
Why
under
earlier suit ಹಾಕಿದ್ರ?
Please, my lord, please, my lord.
Suit ಹಾಕಿ withdraw ಮಾಡಿದ್ರೆ ಡಿಸೈಡ್ ಆಗಿತ್ತಾ?
ಇಲ್ಲ pending ಇದೆ.
Which is
Suit
that
is not
same
filed
cause
by-
of action?
Same cause of action because it
Plaintiff is, that suit is not filed by this defendant, my lord.
See, order to rule 2 ಗೆ,
Please,
it
ma'am.
should be the same cause of action, same parties.
please, my lord.
Yes.
Please, my lord, because they have admitted in the release date on before filing a second suit, my lord.
Matter of trial, what he is saying, my lord. No,
No, my
Order
lord, they
to,
themselves
order to
admitted.
rule 2 is very clear.
Please,
It
my
should be between the same parties.
Because, my lord, the reason
It
was
is like
also
res
rendered by the
judicata.
lower court is this, my lord.
ಯಾವುದು ಅಪ್ಲೈ ಆಗುತ್ತೆ?
It is akin to
Well, the
section
plaintiff-
7,
No, my
section
lord.
11.
11 has been filed, madam, that has not been challenged because it is interlinked with.
Suit is pending, res judicata apply ಆಗಲ್ಲ ಅಂತ ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. 2 rule 2 principal
ಅಲ್ಲ,
reason is
2
this.
rule-
Parties ಇಲ್ಲ cause of action ಅಂತ ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
2 rule 2, same cause of action, same party. Section 11, conclusive suit between the same, conclusive
Moment,
proceedings between the same parties.
Please, ma'am.
Suit pending the res judicata ಇಲ್ಲಿ ಬರುತ್ತೆ.
No, my lord. I may be permitted to take my lordship note on page number.
Then
My lord,
we'll hear,
release date, my lord.
next week hear ಮಾಡೋಣ.
My lord, stay, my lord, please.
ಯಾಕೆ stay?
My lord, my submission is this, my lord, because
ಅಲ್ಲಿ ಇನ್ನು
on page number 152, my lord, 152, my lord. May I take a moment?
If you're on a weak ground.
No, because they admitted there is a pendency of suit, we will withdraw the suit pertains to.
Same parties.
Please, my lord.
ಅಲ್ಲ, they say that I am defendant number 6 in the earlier
no,
suit.
cause of
Summons
action,
was not served on
because-
me, my lord. It was
Oh,
served
they
on my
placed
deceased
expert
father. 21 suit ಅಲ್ಲಿ 2008 ಅಲ್ಲಿ ತೀರೋಗಿರೋ father ಗೆ ಸರ್ವ್ ಮಾಡಿದೀವಿ ಅಂತ ಬರ್ಸಿದ್ದಾರೆ. I was aware of that suit.
My lord, in between
for-
these two suits.
Suit
my-
for partition. That is
Partition.
also partition, this is also partition.
List on 11th.
It's a case where, my lords, the deputy commissioner proceeds to pass the order without even providing an opportunity.
Lord, I beg to appeal the respondent, my lord, along with my
Let
colleague.
him be heard. He was heard, is it?
No, my lords.
ನೀವಲ್ಲ ಅವ್ರು ಹೇಳಿ. Why are you silent?
Lord, am I audible, my lord?
Oh, you are there. All right. Yes.
Please.
I'm sorry.
Page
Lord, I'm
17 may kindly be seen, my lords. I have produced the order sheet, entire order sheet itself. Even the impugned order is also silent about the opportunity being given.
But you have to file an appeal against 34
That is
You can't convert 226 to
Insofar as, my
34.
lords, if it is on merits, my lords, yes, my lords, I
If
have.
it is on anything,
My
file
lords,
an
now
appeal.
kindly see the order sheet for a moment.
I have seen.
My lords, he says, my lords, respondent files wakalat, then pronounce it, the order is passed. That is why, my lords, let him provide an opportunity.
ಏನೇನ್ ಹಿಯರ್ ಮಾಡಿದ್ದೀರಾ ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, ಏನು ಮಾಡಿಲ್ಲ. At least, my lords, heard, posted for orders, ಏನಿಲ್ಲ, ಯಾರೋ ಒಬ್ರು DC ಬರ್ತಾರೆ, ವಕಾಲತ್ ಆಗ್ತಾರೆ ಅಂತಾರೆ, ಇನ್ನೊಬ್ರು DC ಬರ್ತಾರೆ, ಆರ್ಡರ್ ಪ್ರೊನೌನ್ಸ್ಡ್ ಅಂತಾರೆ. 2012 ಒಬ್ರು DC, 23, 24.
ನಿಮ್ದೇ ಸರ್.
After filing wakalat, we would have given an opportunity.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಶೀಟ್? Otherwise you have to file.
Otherwise, I have to file 34, no doubt about it.
Get the records.
ಅಲ್ಲ, records ನಾನೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
There is nothing in the writ
ಅಲ್ದೇನೆ
petition,
ಬೇರೆ
my lord.
ಇದೆಯಾ? Sir, wait, sir.
There is no averment in the writ petition. What prevented him
The
from filing
entire
the
writ petition
34?
is on that averment only. Yes.
Would you, my lord, he was not present on the day the matter was posted for hearing. Thereafter, my lord, it was disposed of on a
Wakalat filed,
subsequent day.
minutes, sir. Wakalat filed praise time 8/11/22. Next 8/11/22 ಏನಾಯ್ತು?
ಏನೂ ಆಗಿಲ್ಲ.
ಅಂದ್ರೆ
ನೆಕ್ಸ್ಟ್ ಅಲ್ಲೇ ಕೆಳಗಡೆ ತಾವು ನೋಡಿದ್ರೆ 8/11/2022 ಕಟ್ ಮಾಡ್ತಾರೆ ಆರ್ಡರ್ ಶೀಟ್ ಅನ್ನ.
ಮಾಡಿ 3/1/24 ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿದೆ.
2024 ಗೆ ಆರ್ಡರ್ಸ್ ಪಾಸ್.
Get the records. The learned HCGP is directed to secure the entire records in ಇಲ್ಲಿ annexure B ಅಲ್ಲಿದೆ. ಸ್ಫೂರ್ತಿ
17.
annexure B ಅಲ್ಲಿ ನಾನೇ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. annexure B ಅಲ್ಲಿರೋದು proceedings record ತರಿಸಿ ಎಲ್ಲ ಇದು ಎಷ್ಟಕ್ಕೆ ಕಾಪಿ ದಿಸ್.
Lord, may I make only one submission, my lord, lordship is
If
calling
you
for the
accept,
records.
we'll send it back. Otherwise, I'll have to pass an order.
Yes, no, only one question. my
This
lord,
is
only
the
one-
order, not the way to function.
Yes.
Yes, list the matter on 11th.
Lord, would
17th.
can it be on the 17th? Lord?
17th, yes.
Please,
I'm
next. 37, my lords, they have filed memo on the last date of hearing.
Consider representation.
Consider the representation anta. My lords directed, my lords, like my learned friend Krishna on the last date of
Oh,
hearing.
ಇದು ಮಾನ್ಯ ಭಾರತೀಯ ಸಿಟಿ.
ಭಾರತೀಯ city.
yes. ಏನಿಲ್ಲ.
Lords,
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. On the last date of hearing.
ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ? ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದನ್ನ ಬೇಕಾದ್ರೆ.
ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡೋದಕ್ಕೆ I said, my lords, I'll file amendment application.
ಸೆಪರೇಟ್ ಪಿಟಿಷನ್ ಹಾಕಿಬೇಕು.
ಅದನ್ನೇ ಮಾಡ್ತೀವಿ. With
Current
liberty
counsel
and
for
all
the petitioner
contentions may be.
submits that he would want to raise a challenge to the order that is passed during the subsistence of the petition on consideration of the representation of the petitioner. Is reserving such liberty, the petition stands disposed. All contentions remain open to be urged in the event that he would want to file another petition.
Please. Great.
Next. 38 general award. ಬರ್ತೀನಿ ಒಂದೊಂದಾಗಿ ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಎಲ್ಲ. ಎಸ್ ಜನರಲ್ ಅವಾರ್ಡ್ ಡಿಸ್ಪೋಸ್ಡ್ ಏಜಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀನಿ. ಜನರಲ್ ಅವಾರ್ಡ್ ಕೊಟ್ಟಿದ್ದೀವ? ಒಂದು ಜಡ್ಮೆಂಟ್ ಕೊಡಿ. ನೆನ್ನೆ ಜಸ್ಟ್ ಇಂದ್ರೇಶ್ ಅವ್ರದ್ದು ಎಲ್ಲ ಇತ್ತಲ್ಲ. ಅನೆಕ್ಷರ ಇದೆಯಾ? ನೀವು ಪೆಟಿಷನರ್ ಈಗ ಯಾವ ಅನೆಕ್ಷರ್ ಇದೆ?
B
ಅನೆಕ್ಷರ್ ಬಿ. ಎಸ್
ತಮ್ಮದ ಇದೆ ಬೇಕಾದ್ರೆ
ನಾನೇ ಒಂದು ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿದ್ರಿ, ಸುಮಾರು ಮಾಡಿದ್ದೀರಿ.
59 my lords,
Vachan,
for the
why
respondent.
executing sale deed is
Because,
taken?
now the issue my lords is that the allotment, site was allotted to the petitioner's father. Possession certificate is issued, LCSA is also issued my lord. Now
Correct.
my lords, we have issued a communication to the concerned officer to make a spot inspection as to find out who is in possession. This is important my lords because in the Arkavati layout my lords, as my lord is
Now,
aware.
when do you conduct that?
Lords may kindly grant me 10 days time, I shall
Learned
finish that
counsel for the
exercise.
petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus to execute the sale deed of the allotment of the site in favor of the father of the petitioner. The learned counsel for the respondent would contend that the officer has to inspect the property as to who is in possession of the property.
Petitioner is position recently is.
Inspect so and so. The inspection shall take place on the 11th of July at 10:30 AM in the presence of the petitioner. A report of such inspection be placed before the court on 15th, list on 15th. Yes, next. Ashte amale inspection prakara will close it.
The connected matter, I take notice for respond number 2 and 3.
ಏನ್ ಪರವಾಗಿಲ್ಲ ಸರ್, DD ನ 45 ಕಳಿಸಿರೋದಲ್ವಾ?
For respondent, they have not served any notice.
No problem, sir. The issue is whether demand draft can be sent for signature verification.
Whether the demand, the main issue is here,
Ah.
whether the demand drafts have been issued to me.
Oh.
The demand drafts which is supposed to have been issued to me have reached the defend number 5 and 6. From there, it has
That
been reached to the
demand, sir,
bank and-
demand draft does not contain the signature of the bearer. It's
No.
only the application.
For your
Basic principle. How can that be sent for
For-
signature verification?
For your kind information,
What's
my signature has been made on the demand drafts.
On
And,
the demand draft?
Yes, your,
Why?
my lord.
Why?
We don't know. The demand drafts have been presented from the society, and the society has presented those demand drafts in the bank and they have withdrawn the amount. And the demand drafts contain
Demand
my
draft
signature.
signature illa andrunu it will be given, sir.
But
In whose name the draft is drawn, it will be given. ಅದಕ್ಕೇನು signature ಅಲ್ಲಿ ತಗೊಂತಾರೆ ಅಷ್ಟೇ.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ there is a huge fraud ಆಗಿದೆ. ನನಗೆ ಬರ್ಬೇಕಾಗಿರೋದು ಅಮೌಂಟ್ ನ ಬೇರೆ ಕಡೆ ಡ್ರಾ
ಹೌದು,
ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟು ಬರ್ಬೇಕಾಗಿತ್ತು ನಿಮಗೆ?
1 crore 9 lakhs in respect of the demand draft.
Compensation.
Amount is a sale consideration amount which should have been given to me. But they have not given, they promised while the agreement execution of the sale deed.
This,
Subsequently.
no, this order defeats logic of referring the demand draft for signature verification.
And the demand draft contains my signature, but I have not signed. It is a forged signature. When I found it that it is forged, then I requested, because there is no other alternative. The documents have been executed in the sub-register with my force. I mean, by bringing force on me, willfully I have not sold the property.
Second matter, the one page some government survey.
ಕೊಡಿ ಅದು.
Number 166 in the other matter.
Give that.
What I have challenged before this honorable court. Page number 166.
That is not in my knowledge.
One
my
minute, sir.
lord.
ನನ್ನ ನಾಲೆಡ್ಜ್ಗೆ ಇಲ್ಲ ಇನ್ನು, wait. 160?
166, sir. The lordship statement. Mailreading, earlier order, heard counsel for defendant 1 to 3 on memo of instruction. Plaintiff is present, heard counsel on the memo of instruction. Counsel for defendant 1 to 3 submitted the disputed signature on the right side, back side of exhibit 44 to 48 is not marked or identified.
Exhibit to 44 to 48 demand draft.
Demand drafts.
Counsel for defendant number 4 is present at this stage.
ಇವ್ರೇನಾ?
I'm.
ನೀವು.
The plaintiff is directed to identify the disputed signatures on exhibit P44 to 48 in open court. The plaintiff who is present before the court is directed to identify the disputed signatures on the right side, back side of part 44 to 48 to be forwarded to the expert. Plaintiff shown the signatures of disputed on exhibit 44 to 48. The signatures identified by the plaintiff to be sent to the handwriting experts are marked as code series number C1 to C5. But he is not even entered the box. The trial court marks the documents on their own. But thereafter, at this stage, counsel for defendant 1 to 3, Manad Paisal, objected the procedure of marking and identifying the disputed signatures, though the plaintiff into open court. Since it is a direction matter of the Honorable High Court and the time will estimate is fixed, this court had to act fast in sealing the disputed signatures, and the trial court marks the document and check.
My lord.
Yes, sir.
the court, we submitted that my signatures are forged, and the document contains forged signature. At that time, the court only to make the expert to understand which are the
What is the
disputed
suit, what is the
signatures.
suit for?
Suit for cancellation of sale deeds.
Sale deed and
And
the alternative for
injunction.
payment of sale consideration, my lord.
Now the sale consideration is paid through demand draft.
Yes, my lord.
But
Yeah,
they
absolutely.
have not reached me. We have not received.
Daryl yellow is around.
It is stated in the sale deed, and one of those sale deeds he has also presented to the bank. Admitted.
Now suit is by you for
My lord,
cancellation of
yes,
sale
my
deed.
lord, yes, my lord.
After how many years?
1.5 years.
3 years.
Allah, sale deed agid yavat.
Sale deed on 31/8/2020.
Just 2 years.
But that was the period, it was COVID period, and I was requesting the purchaser to pay me the amounts in respect of the demand drafts. But they kept on promising. Even in the registration office also, they stated that we will provide the
This
demand drafts.
amount
But
has, one
subsequently,
minute, amount has gone to whom?
they have not provided the demand drafts to me after the execution of the sale deed. That is the main crux of the
No, no,
matter.
that's all right. Sale deed, demand drafts were taken by him.
Please, ma'am.
They, without my
Date-
knowledge,
dates, 1 minute, sir. Dates. Dates kodi.
Exhibit
Exhibit bada, dates ಕೊಟ್ಬಿಡಿ ಸಾಕು.
dated 29/8/2020.
29/8/2020 is the
Demand drafts. Exhibit
DD.
DDs, ma'am. ಹೌದು.
ಸೂಟ್ ಹಾಕಿರೋದು
2023.
DD drawn in the name of
Plaintiff, Armugam K.
Armugam K.
Annexure G is the 139 pages.
All right.
here I have to come, my lord. ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಏನಾಗಿದೆ?
ನನಗೆ ಅಮೌಂಟ್ಸ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಡಿಮ್ಯಾಂಡ್ ಡ್ರಾಫ್ಟ್ಸ್ ದೇ ಕೆಪ್ಟ್ ಆನ್ ಡ್ರ್ಯಾಗಿಂಗ್ ದಿ ಮ್ಯಾಟರ್. I had to go to the police station to complain to many places, but in spite of my demand, they did not give me the demand drafts.
ಅದು
ಮತ್ತೆ ಏನಾಯ್ತು ಅಂದ್ರೆ
drawn on which bank?
Punjab National Bank. Sorry, Indian Overseas Bank.
Account of his account.
no, it is the
Purchaser, D1 to D3.
purchaser's account, Indian Overseas Bank, my lord.
D1 to D, this is a landowner.
No, purchaser.
No,
You are the purchaser.
No.
Alle.
I am
Plaintiff is the
the
landowner.
seller.
He was a landowner, correct?
D1 to D3 are the purchasers.
D1, ನೀವು.
I am also landowner, part of that.
You are also landowner. Who is the purchaser?
D1 to D3 are the purchasers, my lord.
Now, the contention is amount has not come to your account.
Yes.
No, not that. They did not give me the demand drafts as per the stated in the sale deed.
So no amount has gone to your account.
No, my lord. They have reached
No amount has gone to your account.
only in respect of the amount, 1,09,00,000 lakhs, that amount, demand drafts which have been mentioned in the sale deed, they did not give me the demand drafts.
Account ಗೆ ದುಡ್ಡು ಬಂದಿದೆಯಾ ಇಲ್ವಾ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಬಂದಿಲ್ಲ sir.
Account statement produce ಮಾಡಿ.
Yes, produce.
Produce the account statement for 3
I have
years.
to come in, my lord.
No, don't worry, you come in.
No. I have to submit one matter.
Nothing. You produce the account statement between 29/8, DD date and
20th/9/2020.
the respondent shall place on record, respondent plaintiff shall place on record the account statement of his account at Indian Overseas Bank.
No, he does not have any account in Indian Overseas Bank, my
ಮತ್ತೆ
lord.
ಎಲ್ಲಿಗೆ DD deposit ಎಲ್ಲಿಗೆ?
ನಿಮ್ ಬ್ಯಾಂಕ್ ಹೇಳಿ ಸರ್ ಯಾವುದು?
Num bank HDF, come here.
ಹೇಳಿ.
Which bank do you have accounts?
Tell him.
ICICI and HDFC. ICICI and HDFC, my lord.
The counsel for the respondent plaintiff shall place on record the account statement for the years 2020 to 2023 at both the banks HDFC and ICICI by the next date of hearing. List the matter on 18th.
In between, kindly stay the orders in trial court because of the direction.
List on
the
18th.
Trial court is requesting me to complete the arguments.
List on 18th, yes.
Interim order extended till.
Interim order subsisting would continue
And
to the next date.
interim order in respect of only IR 33, my lord. For that reason, the trial
Only
court is
IR
asking me to complete the
yes.
arguments because there is no
The
stay.
interim order is restricted to the order directing the signatures to be to the handwriting expert.
Because there is a direction from this court, and this trial court is asking me to complete the arguments. That is the problem here, my lord.
All right, we'll stay the further proceedings. Further proceedings before the concerned court in the concerned court shall remain stayed till the next date of hearing. List on 18th. In the event the respondent would not place on record the account statement as directed, adverse inference would be drawn. ದುಡ್ಡು ಎಲ್ಲೋಗಿದೆ ಸಿಗುತ್ತೆ.
Random of my lord, consideration, I will take.
38D.
Yes, please. I will take
4000
notice.
square feet. ಅಷ್ಟೇ ಅಲ್ವಾ?
ಇಲ್ಲಿ 4000 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಇಲ್ಲ ಅವ್ರದ್ದು, ಅದಕ್ಕಿಂತ ಕಡಿಮೆ.
ಇದು ಎಷ್ಟಿದೆ ಎಷ್ಟಿದೆ?
1807.
Maximum is 4000, so 1800. Yes, disposed. Next.
Till then not to dispose in consideration.
ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ not to dispose. Yes.
But let them not put up any further construction also.
ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಬರ್ಕೊಂಬಿಡಿ. The petition stands disposed. The representation of the petitioner shall merit consideration in strict consonance with section 38D of the Act. The learned counsel for the petitioner submits that the extent of land that is now seeking benefit under 38D is 1875 square feet, which is well within the limit of 4000 square feet as obtaining under 38D. The learned counsel for the petitioner shall thus not put up any further construction beyond 1875 square feet, and the BDA shall not precipitate the matter till the consideration of the representation on 38D of the Act.
Please.
Ordered.
Time frame, my lord.
Representation of the petitioner shall merit consideration 8 weeks.
No, it requires 3 months.
12 weeks from the date of receipt of the copy of the order.
My lords, beg to appear for the petitioner, my lords. My lords, this is a matter, my lords, where
on the last date, lordship heard the matter and passed it over for passing order. Then the matter.
Commissioner, my lords, for the purpose of commissioner. My lords may just take my affidavit, my lords.
Next.
Much.
And this petition.
Kata.
Yes,
Did not get issued any documents from the other side.
Leonard.
I served the copies.
On whom?
To one Mr. Chinmay.
Who is Chinmay? I have directed Ajay Kumar to take notice.
We'll file a wakalat, my lord.
Serve on him. Learned counsel shall serve set of papers upon counsel Ajay Kumar forthwith. Kata gottu, but forgery anta heltare. We'll see. Yes. Next. List on 17th. Yes. General award.
Yes, ma'am.
Disposed.
Kindly fast over the matter, madam.
Possession ತಗೊಂಡಿದ್ದಾರೆ
Possession?
Acquisition is challenged.
ಗೊತ್ತು.
They have not taken possession. My lords have directed them to submit on the factual status on.
Pradeep Kumar ಬರ್ಲಿ.
Fast over. And also 46 also, madam. 46.
ಗೊತ್ತು 44, 45, 46 ಎರಡು.
46.
46 ನಿಮ್ದಲ್ಲ.
46.
ಎಸ್ ಅದು ಪಾಸ್ ಓವರ್.
28 for notification.
ಗೊತ್ತು ಪಾಸ್ ಓವರ್.
For the petitioner in this case, ma'am. The suit for partition.
ಈಗ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರ ಅಲ್ಲಿ?
ಆಗಿಲ್ಲ.
ಇನ್ನೂ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ.
39(1 and 2) no order is passed.
No order passed. Runner suit for partition. The property was purchased by the petitioner's mother. She died on 15/6/2017. After death of the
Petitioner shall serve on the defendants by way of hand summons and file an acknowledgement by the 9th of July 2025. List the matter on 16th of July. Status quo, the property be maintained.
They are trying to alienate the property.
The defendant shall not alienate the property till the next date of hearing.
Much obliged.
Yes, next. In the event steps are not taken to serve the defendants, interim order would automatically get vacated. Next. First
against-
appellate court ಅಲ್ಲಿ stay and ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇಲ್ಲಿ ಬಂದಿದೆ ಮತ್ತೆ.
ಇಲ್ಲ, what has happened is, my lord, I sought for stay of the further proceedings because there were two regular appeals, my lord, that were filed. I had filed one set of regular appeal and the plaintiff had filed a regular appeal. We both are aggrieved, my lord, by the fact of the dismissal.
What is
of
the
the suit.
RSA pending?
RSA is my appeal was dismissed on the ground of limitation by the very same court where, my lord, it was pending. In fact, I had filed a clubbing application when both the RAs were pending. No orders were passed and only on the ground of limitation, my lord, the RA was dismissed. I have come up, my lord, in an RSA before this honorable court. All that I said is there is RSA that I have filed. Now, what I squarely understand, my lord, is now once one set of an appeal is
Yes.
dismissed, what actually happens to the other set of appeal is, my lord, something that can be looked into. So what I said is I have filed an RSA already. Now, kindly stay until and unless, my lord, I make a head go in the pending RSA. Now, what
That you will never do.
No, I'll do it. Now, what the court says is, now you argue in this appeal only is what it says. Now, which I can't do because there is a
Well,
dismissal
you
of
serve
RSA.
on,
Please.
the petitioner to serve on the, who is the contesting defendant here? Yeah, first one, huh?
No, the respondent.
All the respondents?
No, respondent number 1 to 3 are sailing with me. My lord, the real contest is from respondent number 4 to 6.
Counsel for the petitioner shall serve on the counsel who represents respondents 7 to 9, huh?
Now, I'll take out, my lord, from on all the counsels. They are there, my
The
lord.
counsel for the petitioner shall serve on the counsel who represents the respondent 4 to 9 before the first appellate court. Proceedings before the first appellate court shall remain stayed till the next date of hearing. List the matter on 10th.
Great.
In
My lord, in this case.
Order Rule 10.
Yes, ma'am. The partition suit filed by the co-sharer has been rejected by the trial court on the ground that if at all, if he is having any right over the court, let him file a separate suit. So lordship kindly see the operative portion.
Where did you file the execution alla? FDP alla?
No, it lordship is a partition suit, your lordship.
ಅದೇ ಇನ್ನು suit pending ಇದೆಯಾ?
Suit pending ಇದೆ. Now, in the pendency of the suit, only one branch has filed a suit. And in the said suit, they are reporting the collusive compromise. Now the case is set on for reporting the compromise on tomorrow.
1, 2, 3. Petitioner shall serve on the counsels who represent the respondents before the concerned court and file an acknowledgement by the 9th. List the matter on 11th. Further proceedings before the concerned court shall thus remain stayed. 11th, bada. 14th shall remain stayed. In the event the petitioner would not take out steps to serve, the respondent's interim order would stand automatically vacated.
And delivery tomorrow.
Tomorrow ತುಂಬಾ time ಇದೆ. ಸಿಗುತ್ತೆ.
Upload.
Yes. And second distribution. Admission. Further reading, bada.
Serial number 3.
Wait. 2 ilva? Vivek. Notice. 3.
Lord, impugned order, my lord, arising out of application.
711.
711. Lord, what has happened, my lord? 2014, there was a suit for eviction. 2024, we retrieved.
What is the present suit for?
Suit for, my lord, declaration, declaring her as the ostensible owner, my lord. 2014, there was an eviction suit filed by the petitioner herein for eviction. And 2024, the matter reached the Supreme Court and we retrieved the possession, my lord. Now, the same person who is the defendant has, through his wife, filed another suit to declare her as the ostensible owner.
Where are the orders?
The Supreme Court order, the impugned order, my lord, page number 12.
No.
The Supreme Court order, page number 51.
No, this court's order.
Well, this court's order is page number 20. Man.
Page 20.
20.
What's happened to you? Serial number 3, right?
Serial number 3.
Page number 20.
My lord, this court's order.
Earlier ejectment suit ಏನಾಯ್ತು sir ಅದೇಳಿ?
My lord, the ejectment suit was allowed, my lord, in my favor.
Where is that order, I'm asking?
One second.
Page 53.
Yes, my lord, 53 RSA number.
Correct.
Sorry.
File ಓದಲ್ವಾ?
Alla, so pagination. 53, my lord.
Hmm.
The
Where is-
RSA.
Where is the order of the apex court?
Apex court order, my lord.
That is 61.
61.
Now, where is the plaint?
Plaint is
Present-
page number 24. The very same scheduled property, my lord, the wife of the same party, my lord.
The petitioner is the defendant.
My lord, I have not sought for stay in this matter.
ಮತ್ತೆ
ಅಲ್ಲ ನೋಟಿಸ್ ಕೇಳಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಹ?
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಕೇಳಿಲ್ಲ ಇದರಲ್ಲಿ.
ಮತ್ತೆ ಏನ್ ಬೇಕೀಗ? ನೋಟಿಸ್ ಅಷ್ಟೇನಾ?
ನೋಟಿಸ್ ಅಷ್ಟೇ. ಚಾಲೆಂಜಿಂಗ್ ದ impugned order.
That's rejected, correct?
Yes, my lord, that's
You want the
rejected.
proceedings to continue?
ಅಲ್ಲ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೀತಾ ಇಲ್ಲ ಈಗ actually. Long dates are given, so we are not.
With
sure.
this, it is a clear case for staying. Anyway, I have not.
ಅಲ್ಲ, true, my lord, that's why I mentioned.
Notice.
Yes, great.
I appeal for the
Notice.
petitioner.
Rejected.
Rejected, my lord. In fact, I acquired the property in the year 1986.
Suit for
Partition filed by the respondent.
notice.
But I sought for.
No,
interim order.
partition 711 ಬರೋದೆ. We'll see. Yes.
5,
Next. Notice.
6,
Lord, the LR application, my lord, is allowed when the relationship is in dispute. The first respondent claims that, my lord, she is the wife of one Nanjundappa. Nanjundappa during
That's
his
a
lifetime.
matter of trials.
No, he himself had come up, my lord, before the court.
Notice.
No, this is the FDP proceedings.
Notice.
And hence, my lord, there would be no trial again. This is only an inquiry, my
We'll
lord.
see.
On,
Notice, get the
no,
petitioner
my
to
lord,
serve on the.
the caveator is there. He has
ಎಲ್ಲಿದ್ದಾರೆ?
the contesting respondent has appeared on the caveat.
No representation. Passover.
7,
Notice.
8,
ಅಲ್ಲ emergent notice the response returnable by ಎಲ್ಲ 24th ಹಾಕ್ಬಿಡಿ. ಈಗ ಏನೇನು ನೋಟಿಸ್ ಮಾಡ್ತಾರೆ. 8 notice.
9,
ನೋಟಿಸ್ ಮಾಡಿದ್ದೀನಿ. ಸ್ಟೇ ಏನಿಲ್ಲ. ಬರ್ಲಿ. I have posted it on 24th. Let it come. No problem. No, sir. Yes. 24th, yes.
6, 9,
Small. Password.
10,
ಇಲ್ಲಾಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇಗೆ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್. 9 ಯಾರು ಇಲ್ದಾರೆ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇಗೆ ಹಾಕಿ. 10
number 10,
ಸೇಮ್ ಥರ್ಸ್ಡೇ.
7,
For a petitioner, Lord. This, my lord, suit is filed. Contract is basically to undertake construction of a warehouse and a factory premises. So wherein the defendant, wherein the plaintiff, my lord, did not perform within the timeline. So that LOA was terminated, and they went ahead and filed a suit, a civil recovery suit, wherein we have taken an objection stating that it should be a commercial, since it's a commercial transaction, the matter needs to be relegated to the commercial court. So that was the premise, but however, my lord, my application was rejected stating that it is a mixed question of law, whether it's a commercial transaction or not to be determined. So that is the premise under which the application was
Petitioner
rejected.
shall serve on the counsel who represents the respondent in the trial proceedings, i.e. in OS 5310 of 2024, and file an acknowledgement by the 8th, list the matter on 17th. Further proceedings before the concerned court in OS so and so shall remain stayed. Next.
12,
Rejection of plaint. If my lords could take one para in the plaint, my lord, page 86.
Suit for?
Suit for cancellation of my sale deed. The plaintiffs
Sale
are the
deed
one-
dated?
2017, 19/8/2017.
Sale deed dated?
19/8/2017.
Suit instituted?
2024. Page 86, my lords, para 26.
86, sir.
Please. The cause of action for the suit arose on 19/8/2017 when fraud was played on the plaintiff and the alleged sale deed dated so and so got executed in favor of defendant number 1 and 4.
The petitioner, you're on limitation now.
On the ground of
Next
limitation.
question.
No, it's now they themselves in their own pleadings. And if your lordships could see
The-
Article 56,
The petitioner, the defendant, is before the court calling in question an order of the concerned court rejecting the application filed under Order 7, Rule 11D, DIN of
Rule D,
D of
A and D.
A and D of the CPC. The cause of action in the plaint reads as follows, page 86. The suit is filed for a declaration or the cancellation of a sale deed executed on 19/8/2017, and the suit is preferred on
2024, my lord,
suit is instituted on in the month of July 2024.
August 2020.
August 2024, vaguely indicating that somewhere in July 2024 they came to know about the fraud played. The suit is admittedly beyond limitation. Therefore, till the respondents would enter appearance, the further proceedings before the concerned court shall remain stayed.
Grateful.
Emergent notice to the respondents returnable by the 24th.
Grateful.
Next.
13.
In this matter, suit summons were served. Of course, page number 2 was missing. I am just handing over to my suit summons. May take your lordship, page 34.
In miscellaneous petition.
Miscellaneous to set aside the decree of 2011, and after about 14 years, the trial court now set aside the decree on the ground that the suit summons were not served on the respondent number 1. I mean defendant number 1. Kindly see. Miss ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ನೋಡಿ
ಹಂಗೆ ಅದು ಸರ್ವಿಸ್ ಮಿಸ್ ಆಗೋಗಿರುತ್ತೆ.
I am sorry, my lord. What happened was, I just only 1 minute. It was received by the son of the first defendant.
The petitioner is before heard the learned senior counsel H. N. Shashidhar appearing for the petitioner. The learned senior counsel would take this court through the order to submit that is judgment and decree of the year 2014 is sought to be challenged in the year 2025 by filing a miscellaneous petition.
No, miscellaneous filed earlier, my lord. I am sorry.
Oh, by filing a miscellaneous petition, the same is now set aside after 11 years on the ground that the respondents, that the
Only defendant number
that
1.
the defendant number 1 was not served with the notice. The learned senior counsel places on record, Memo, places on record the service of notice upon the first defendant. Therefore, the
first defendant's son.
First defendant's son. Therefore, the premise on which the concerned court has proceeded appears to be erroneous, albeit prima facie. Therefore, there shall be an interim order of stay as spread for till the next date of hearing. Petitioner to serve on.
What happened is, I will take out only for the respondent number 1. He was the person who filed the miscellaneous petition. Others,
the petitioner to serve on the first defendant.
For the time being.
First respondent. Petitioner to serve on the counsel who represented the first defendant in the before the concerned court, and or take out hand summons upon the first defendant.
For the remaining, it may be dispensed with for the time.
Time being dispensed alla kotre purti marthivi. Yes, next.
15.
Rejection of Plaint, my lord, suit for specific performance. They have entered caveat. The rejection of Plaint application has been rejected. The land, my lord, is a granted land.
Who are you?
My lord, I was the owner of the land, my lord, for whom the land was granted. Now, within 15 years, my lord, there is a non-alienation clause. Within 15 years, my lord, we have entered into a sale agreement. Now, my lord, the respondent herein, who is the agreement holder, files a suit for specific performance. We, my lord, have taken up a contention, my lord, that the agreement itself is void ab initio.
Contrary to law.
Contrary to law, section 23 also. Now, my lord, that has been rejected. Therefore, my lord, I am before your lordship.
Yes, ದುಡ್ಡು ತಗೊಂಡ್ರಿ?
My lord, 25 lakhs. We are ready to pay, my lord, along with the interest. We are ready to pay.
ಈಗ ವ್ಯಾಲ್ಯೂ ಜಾಸ್ತಿ ಆಗಿದೆಯಲ್ಲ. Definitely will be ready to pay.
Now, my lord, this is a
non-alienation period ಅಲ್ಲಿ ಯಾಕೆ agreement ಮಾಡ್ಕೊಂಡ್ರಿ?
My lord, there is a condition, my lord, which says that, my lord, the entire purpose of the PTCL Act, my lord.
ಅದು ಗೊತ್ತು. Why did you enter into agreement, sir?
We are all illiterate.
ಸುಮ್ಮನೆ agreement. ಯಾರು? ಎಲ್ಲಿ ದೇವನಹಳ್ಳಿನ ಇದು? ದೇವನಹಳ್ಳಿಲಿ ಯಾರಿದ್ದಾರೆ? ಅಲ್ಲಿ ಫಾರ್ಮರ್ಸ್ ಇಲ್ಲ, ಇಲ್ಲಿಟ್ರೇಟ್ಸ್ ಇಲ್ಲ.
It's on Nandi Hills Road, my lord, next to Marriott.
ಅಲ್ಲಂತೂ ಇಲ್ವೇ ಇಲ್ಲ ಬಿಡಿ.
Therefore, my lord, now the point is covered, my lord, this honorable court has held. My lord,
No problem, ಅದಕ್ಕೆ judgment better, rudimentary, it is definitely.
therefore, my
contrary to
lord,
the
order
statute.
7 rule 11D, we have filed an application. Copy is also served on the other side, my lord, who had filed caveat. Also may have a short date, my lord, we can hear the matter and.
Correct. ಈಗ higher price ಬರ್ತಾ ಇದೆ ಅಂತ ಅಷ್ಟೇ ಇದೆಲ್ಲ.
Lord, whether the point here would be, my lord, whether the suit is maintainable or not.
We'll see, yes. Heard the learned counsel Vipin Hegde appearing for the petitioner. The petitioners are the grantees / landowners of the suit scheduled property. Enter into an agreement, our date.
Lord, agreement was entered, my lord, on my lord, 5/9/2015.
Enter into an agreement of sale of the subject property on 5/9.
16/6/2014.
16/6/2014. The land is said to have been granted to these petitioners with a condition of non-alienation of 15 years.
That will expire on 5/9/2015.
Which was set to expire on 5/9/2015. 5/9/2015, just before the said date. A few months before the said date, the agreement to sell is executed.
Suit is filed in, my lord, 21/10/2020.
The suit for specific performance thus springs as the petitioners did not come forward to execute the sale deed. The learned counsel Bipin Hegde is an appoint of subsection 2 of section 4 of the Karnataka Prevention of Transfer of Certain Lands Act 1978 to contend that within the non-alienation period, any sale that took place is void ab initio, even agreement for that matter.
Definition of transfer itself, my lord, in the act.
Agreement also. They 4(2). Yes.
Section definition.
So he would submit that since the sale was void ab initio, the entertainment of the suit could not have been entertained. Therefore, there shall be an interim order of stay of further stay application ilva.
Idara caveat or
Stay application ಹಾಕಿದಿರೋ ಇಲ್ಲ?
stay ಹಾಕಿದೀವಿ. My lord, stay bada. Matter might be discussed. Small date might be given.
That is so and so. Therefore, emergent notice.
Caveat, they have filed caveat.
ಎಲ್ಲಿದ್ದಾರೆ?
Alla caveat copy also served.
So and so. List the matter on 24th.
Any shorter date, my lord, only covered matter.
Shorter date, 24th.
My lord, this is the case under PTCL, my lord. I am the original grantee and the AC order was passed in my favor for restoration of the land, my lord.
ಏನ 711 ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Yes, my lord. AC order, DC order, ಮತ್ತೆ WP before, writ petition order before this court, WA or writ appeal order ಈ court ಮುಂದೆ ಎಲ್ಲ ನನ್ನ
purchaser.
I am the grantee, my lord.
ಎಲ್ಲ ನಿಮ್ಮ ಪರವಾಗಿ ಆಗಿದೆಯಾ?
ನನ್ನ ಪರವಾಗಿ ಆಗಿದೆ, my lord.
ಯಾವಾಗ ಎಂಟರ್ ಆದ್ರಿ ಇದಕ್ಕೆ? ಅಗ್ರಿಮೆಂಟ್ ಯಾವತ್ತು ಮಾಡ್ಕೊಂಡ್ರಿ? ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಅವರು ನಾವು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇರೋದು ಅಂತ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಹಾಕೊಂಡು
ಯಾರು ಹಾಕಿದ್ದಾರೆ?
OS purchasers, my lord. OS ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ. It's leading to multiplicity of cases, my lord.
ಹೌದಾ? Oh, yes. Serve on them, yes. Counsel for the petitioner shall serve on the counsel representing the plaintiffs 1 to 4 in OS 193 of 2023. Next date ಏನು?
ಸ್ಟೇ ಆಗ್ಬೋದು, my
Next date ಏನು?
1908 ಇದೆ, my lord.
1908 ಗೆ. Yes. List the matter on 24th. Serve ಮಾಡಿ.
My lord, stay may be granted.
1908 ಗಲ್ಲ 60 ಕೊಡ್ತೀನಿ 24. Let them come.
Yes, sir. Hearing on IA 16.
Okay, for the respondents, Your Honor.
CD in filing 37 days.
Please.
Notice.
ಅಲ್ಲ ಇದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೇವಿಯೇಟರ್ ನಾನು ಇದೀನಿ.
ಇದೀರಾ?
ಇದ್ರಲ್ಲಿ ನಾನು ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಸ್ವಾಮಿ. ಎವಿಕ್ಷನ್ ಸೂಟ್, ಎವಿಕ್ಷನ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡೆ, ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದೆ, ಆವಾಗ ಇವ್ರು CRP ಹಾಕೊಂಡು ಬಂದಿದ್ದಾರೆ. ಅಂಟಿಲ್ ನಾವು ಅದು CRP ಹಾಕಿದೀನಿ ಅಂತಾನೆ ವಿದೌಟ್ ಎನಿ ಸ್ಟೇ ಇಟ್ ಹಸ್ ಬೀನ್ ಗೋಯಿಂಗ್.
ಇನ್ಮೇಲೆ ಅದಿರಲ್ಲ ಬಿಡಿ, ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಇವರ ಟೆನೆಂಟ್
ಟೆನೆಂಟ್ಸ್.
ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದ್ದೀರಾ?
2022.
ಓ ವೆರಿ ಗುಡ್.
ಒಂದು ವರ್ಷನೂ ಅದು ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಾನೆ ನಾವು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿ, ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಾನೆ ಎವಿಕ್ಷನ್ ಸೂಟ್ ಹಾಕಿರೋದು ಸ್ವಾಮಿ. ಎವಿಕ್ಷನ್ ಸೂಟ್ ಆಗಿದೆ.
ಪರವಾಗಿಲ್ಲ, ಏನು 711 ಏನಿಲ್ಲ?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್?
the wife of the petitioner is pregnant. They are seeking a 10 months time. ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
Pregnant maximum is 10 months ಯಾವುದು?
ಅಲ್ಲ ಯುವರ್ ಆನರ್ಸ್, ಇದರಲ್ಲಿ ಅದೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ರೆಂಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಇದರಲ್ಲಿ
ರೆಂಟ್ we are ready to pay the rent.
ರೆಡಿ ಟು ಪೇ ಅವ್ರು ಕೊಟ್ಟು ಇಲ್ಲ. 2 ಲಕ್ಷ ಪೆಂಡಿಂಗ್ ಇದೆ ಸ್ವಾಮಿ. 8,000 ತಿಂಗಳಿಗೆ ರೆಂಟ್, 2 ಲಕ್ಷ ಪೆಂಡಿಂಗ್ ಇದೆ. Since the date of initiation of eviction suit, they have not paid the rent.
5 months ಇದಾಗಿದೆ pregnancy. On 10 months time ಕೊಟ್ಟ we
ನಿಮಿಷ,
are ready to vacate this.
ಇದರಲ್ಲಿ they were party. It's
ಅಲ್ಲ
not-
ಪ್ಲೇಂಟ್ ಎಲ್ಲಿದೆ?
Plaint produce
ನೀವು ಡಿಫೆಂಡೆಂಟ್ ಅಲ್ವಾ? WS ಹಾಕಿದ್ರಾ?
WS ಹಾಕಿದ್ವಿ but we have
WS
not read the
ಹಾಕಿದ್ರು,
defense evidence.
ಅವರು ಬಂದಿದ್ರು, ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದ್ರು,
Yeah,
they didn't heed
ಇಲ್ಲ
evidence.
ಅಲ್ಲಿ ಎಲ್ಲಿ ಇದೆಯಾ ಇಲ್ಲಿ WS?
ಇದ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ವಾ? ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Please ಬನ್ನಿ.
ನಿಮ್ ಡಿಫೆನ್ಸ್ ಏನು ಅಲ್ಲಿ?
ಅದ್ರಲ್ಲಿ ನಮ್ದು ಅಷ್ಟೇ
ಡಿಫೆನ್ಸ್ ಅಷ್ಟೇ, ಅವ್ರು ಟೈಮ್ ಬೇಕು,
ಒಂದು
ಮಕ್ಕಳು
time
ಸ್ಕೂಲ್
ಕೊಟ್ರೆ
ಅಲ್ಲಿ ಇದ್ದಾರೆ,
ನಾವು-
ಟೈಮ್ ಬೇಕು ಅಂತ ಅಷ್ಟೇ ಸ್ವಾಮಿ ಡಿಫೆನ್ಸ್ ಅವರು.
ಪೇಜ್ ನಂಬರ್ 8. ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ, ಸುಮ್ಮನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್.
ಮಕ್ಕಳು ಸ್ಕೂಲಲ್ಲಿ ಇದ್ದಾರೆ ಅಂದ್ರ?
ಅದೇ ಡಿಫೆನ್ಸ್ ಸ್ವಾಮಿ.
ಈಗ ಪ್ರೆಗ್ನೆಂಟ್ ಅಂದ್ರೆ?
ಅದ ಒಂದ್ ಮಗು
ಅಲ್ಲ, ಅದು ಎವಿಕ್ಟ್ ಆದ ಮತ್ತಿಂದ ಅವ್ರ ಆಫ್ಟರ್ ದಿ ಇನಿಷಿಯೇಷನ್ ಆಫ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅವ್ರ
ಇಲ್ಲೂ ಅದೇ ಹೇಳಿದಿರಾ? ಎಷ್ಟು ವರ್ಷದಿಂದ ಪ್ರೆಗ್ನೆಂಟ್?
3 ಜನ ಮಕ್ಕಳು.
ಈಗ ಇನ್ನೊಂದ್ ಜಾಸ್ತಿ ಆಯ್ತು.
ಅಲ್ಲ ನೋಡಿ ಸ್ವಾಮಿ, ರೆಂಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಮತ್ತೆ ಇನ್ನೊಂದು ಎಷ್ಟು ವರ್ಷ ಅಂತ ಕೇಳಿದ್ರೆ 4 ಮಕ್ಕಳು ಅಂತ.
ರೆಂಟ್ ಎಷ್ಟಿದೆ ನಾವು ಕೊಡಕ್ ರೆಡಿ ಸುಮ್ಮನೆ. ಅದು ರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು.
2 ಲಕ್ಷ ಪೆಂಡಿಂಗ್ ಇದೆ.
ರೆಂಟ್ ಎಷ್ಟಿದೆ ಅದು ಮೆಮೋ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡ್ಲಿ, ಸುಮ್ಮನೆ ನಾನು ಕೊಡ್ತೇನೆ.
ಮೆಮೋ ಏನ್ ನಿಮ್ ರೆಂಟ್ ಗೊತ್ತಿಲ್ವಾ ಎಷ್ಟು ಅಂತ?
ನಾವು ಕೊಟ್ಟಿದೀವಿ, ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಸುಳ್ಳು ಹೇಳ್ತಾರೆ.
ಹೆಂಗ್ ಕೊಟ್ರಿ? ಕ್ಯಾಶ್ ಕೊಟ್ರ?
ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀವಿ ಸುಮ್ಮನೆ.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ರ?
ಹೌದು.
ಇಲ್ಲ ಯಾರ
ಎನಿವೆ ಅಲ್ಲೇ ಮಾಡ್ಕೊಳ್ಳಿ ಅಲ್ಲ. ಎಸ್, ನೋ ಗ್ರೌಂಡ್ ಟು ಇಂಟರ್ಫಿಯರ್.
ಈಸ್ ಪ್ರೆಗ್ನೆಂಟ್ ಮೇಲೆ
ಮತ್ತೆ ಫೋರ್ತ್ ಥರ್ಡ್ ಒನ್
ಅಲ್ಲ ಸ್ಟೇ ಅಂತೆಲ್ಲ ಕೊಡ್ಬಿಡಿ ಸ್ವಾಮಿ.
ಸ್ಟೇ
ಅಂತ ಕೇಳಿದ್ದಾರೆ, ಅದು ಆಸ್ ಫಾರ್ ಸ್ಟೇ.
ಡೆಲಿವರಿ ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ ಸರ್. ಡೆಲಿವರಿ ವಾರಂಟ್
ನಾವು ಎವಿಕ್ಷನ್ ಸೂಟ್ ಹಾಕಿದೀವಿ, ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡಿದೀವಿ, ರೆಕಾರ್ಡ್.
ವೆಕೇಟೆಡ್.
ಯಾವಾಗ 3 ತಿಂಗಳಲ್ಲಿ ಕಟ್ ಮಾಡ್ತೀರಾ?
10 ತಿಂಗಳು ಟೈಮ್ ಕೊಟ್ಟು ಸರ್, ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. ನಾನು
No, then you'll say fourth pregnant.
ಅಲ್ಲ fifth month running sir. 5th month running.
5th month.
ಅಲ್ಲ 5th month ಅಂದ್ರೆ ಅಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ
10 months
ನವೆಂಬರ್ ಅಲ್ಲಿ ಡಿಗ್ರಿ ಆಗಿದ್ದು ಸ್ವಾಮಿ. ನವೆಂಬರ್ ಅಲ್ಲಿ ಡಿಗ್ರಿ ಆಗಿದ್ದು, ಫೆಬ್ರವರಿಲಿ ನಾನು ಇನಿಷಿಯೇಟೆಡ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
We will vacate it.
ರೀಸನಬಲ್ ಟೈಮ್ ಅಷ್ಟೇ.
ಅಲ್ಲ
10 months.
ಆರ್ಡರ್ ಅವರು
5th month ಅಲ್ವಾ?
ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. 2 lakhs is pending.
2 lakhs ಪೇ ಮಾಡಿ
ಕೊಡ್ತೀವಿ ಸರ್.
ಯಾವಾಗ?
ಒಂದು 15 days ಟೈಮ್ ಕೊಡಿ ಸರ್.
15 days ಬಿಟ್ಟು ತಗೊಂತೀನಿ. 2 lakhs ಪೇ ಮಾಡಿ
ಪ್ಲೀಸ್. ಅಲ್ಲ ಎಷ್ಟಿದೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಡ್ಲಿ ಸರ್.
ಅಲ್ಲ 2 lakhs
ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಕೌಂಟ್ ನಾನು ಕೂಡ ಕೊಡ್ತೀನಿ.
ಈಗ 2 lakhs ಇರೋದ ಎಷ್ಟಿದೆ?
2,07,000 ಸ್ವಾಮಿ ಇರೋದು.
ಸರಿ, 1.5 ಲಕ್ಷ ಕೊಡಿ ಈಗ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಕೌಂಟ್, ಆಮೇಲೆ ನೋಡೋಣ. ಪೇ 1.5 lakhs. I will stay it and I will permit you till the pregnancy ಅಷ್ಟೇ. ಥರ್ಡ್ ಒನ್
ಪ್ಲೀಸ್.
5th month ಅಂತ ಹೇಳಿದ್ರೆ ಇನ್ನು 4 months ಕೊಡೋಣ.
ಆಗ್ಬೋದಲ್ಲ. ಅಲ್ಲ ರೆಂಟ್ ಬಂದ್ರೆ ಆಗ್ಬೋದು.
ರೆಂಟ್ ಬಂದ್ರೆ
ಪರವಾಗಿಲ್ಲ. ರೆಂಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ, ಏನು ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಈಗ ರೆಂಟ್ ಕೊಡಿಸುವ.
Please.
The learned counsel appearing for the respondent plaintiff submits that the petitioner is a tenant who has not paid rent throughout and is squatting over the property. Ejectment suit is in his favor. Execution is now pending. At the time now pending and the delivery warrant is issued. At that point in time, the present petition is preferred. The learned counsel for the petitioner submits that the petitioner, the wife of the petitioner, is now pregnant, at 5th month of pregnancy, and would undertake to clear substantial amount of the rent that is in due. Therefore, there shall be an interim order of stay of further proceedings before the concerned court, including the delivery warrant so issued, subject to the condition that the petitioner would pay 1.5 lakhs by the 18th of July.
Please, subject to arrears of rent. ಅವ್ರು ಸುಮ್ಮನೆ
1.5 lakhs ಕೊಟ್ಟೆ ಆಮೇಲೆ
subject to arrears of rent. ಅದ್ರಲ್ಲಿ ಎಷ್ಟಿದೆ?
ಅದರಲ್ಲಿ ಮತ್ತೆ ಅದರಲ್ಲೇ
1.5 lakhs. So pay deposit 1.5 lakhs before this court on or before the 18th of July 2025.
1 month time maybe.
18th, 15 days andre 18th of July 2025. List the matter on 21st. In the event the petitioner would not list the matter on 24th. In the event the petitioner would not deposit as directed, the interim order would stand automatically vacated.
1 month time.
Almost 1 month ಆಯ್ತು. ಕಟ್ಟದೆ ಹೋದ್ರೆ ಅಷ್ಟೇ.
17.
And for the petitioner, my lord, it is an application for order 7 rule 11 is dismissed. The application is filed on the ground of limitation.
Notice.
I may be permitted to take notice on the advocate for first respondent. For the remaining respondent,
petitioner is at liberty to serve on the counsel who represented the respondent in the trial proceedings. Next.
Respondent number 1, my lord. For others, it
Respondent number 1. All right. Same order. Next. 120 days delay. Yes. Same order.
Seeking dispensation on hours 2 to 38 who are the defendants.
The petitioner memo mail order dispensed with ಬರೀತೀರ. dispensed with at the risk of the petitioner, has
Yes.
filed a memo.
I've already filed. I've already filed.
Yes. Next,
Date may be fixed in this matter. I'll serve the council. appearing
same
for the-
order, 24th,
I'm grateful.
19 was
Number 17
notice,
date
same
may be
order,
given.
24th.
The matter is
Serial number
listed for
17
the
date may be given, my lord.
witness of defendant side, my lords.
What's the suit for?
Suit for injunction, my lords, wherein we have disputed the title itself. And we have filed an application under 151 based on judgment of Honorable Apex Court in Anathala Sudhakar. That since we have disputed the title, my lords, a bare injunction suit is not maintainable. The trial court at para 9, my lords.
Then declaration ಆಗ್ಬೇಕು.
Yes, my lords, they have to file declaration. On trial court clearly observes the same.
ಏನು
my
ಏನು
lords.
ಬರ್ದೇ ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್?
Para, my lords, 9 at page 17.
No, I am there only. No reasons.
They have discussed just the facts, my lords. In para 9, they admit that, my lords.
You have relied on the judgment?
Yes, my lords. My application, my lords, at page number 27, my lords. At
delay
page
ಇದೆ.
28.
But delay ಇದೆಯಲ್ಲ 21 days.
My lords, I am permitted to serve and it may be.
Same order, same day.
Next week, my lords. Let trial court if
ಯಾವತ್
passed.
next date ಎಲ್ಲಿದೆ?
Tomorrow, my lords. ನಾಳೆನೇ ಇದೆ.
I'll seek time tomorrow there.
Kindly, my lords.
List on 11th ಅಂತ 10th ಅಂತ ಮಾಡಿ. ಇದೊಂದು ಮಾತ್ರ.
I am permitted to.
Sir, ಅದೆಲ್ಲ ಇದೆ. ಬರ್ಕೊಂಡಿದ್ದೀವಿ.
Great.
Yes.
Number 17 date may be given, my lord.
24th sir ನಿಮ್ದು. Yes.
Okay.
There is
ಇದು
not delay of
96 days delay,
Please,
same
my
order, 24th.
lord. Dispense to other respondents, 1, 2, 3, my lord. I'll place.
File a memo.
Please,
Yes.
It's number 1, continue. Admission.
Oyo.
50.
ನೀವು ಇರ್ಲಿಲ್ಲ.
Probably, my lords.
Not passing.
Could I make a request if it's taken up on Tuesday, my lords? My lords, the whole dispute.
I know his.
Yes, my lords. Management service agreement.
There is no illegality, right?
No, my lords. My
ಅಲ್ಲ
lords.
illegality of using the premises for
ಇಲ್ಲ, ಅದಕ್ಕಲ್ಲ.
other
Their
activities.
whole grievance seems to be, my lords, one is this deduction of electricity bills was not right. According to them, there's fabrication of accounts under which we get a higher share. And third is food that was being brought from outside. This seems to be the area of dispute. And in the agreement, my lords, the arbitration clause which is there, arbitration has just begun in 2025. All this gets covered in the arbitration itself. We have made a claim, they made a counter claim, but I'm willing to point out, my lords.
Interim order ಕೊಟ್ಟಿದ್ದೀನಿ.
ತಾವು ಕೊಟ್ಟಿದ್ದೀರಾ? In the meanwhile, coordinate bench, 2 similar matters pertaining to OU, it has been quashed. So I will. Last time ಕೊಟ್ಟಿದ್ದಾರೆ consider.
Yes.
Again, it was all based on.
ಹೇಮಂತ್ ಅವ್ರದ್ದು.
ಹೌದು. ಎರಡು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಕ್ವಾಶ್ ಮಾಡಿದ್ದಾರೆ. And it is covered by this
Where is your
agreement.
senior?
The facts of, I don't know, the facts of that case.
He wants
I
it on Tuesday.
requested if we could have it on Tuesday.
Oyo.
Oyo and Jagdish, my lords. So both
Jagdish
are-
ಯಾಕೆ?
Jagdish, they own the hotels, 3 premises. They're not that Jagdish.
Yes.
So operators and service providers, my lord, sharing 90 and 10% dispute therein.
Yes, Prabling sir, Tuesday. Yes.
Like,
51.
Interim order subsisting.
My lord, I am appearing on behalf of respondent number 2 in this case.
Complainant, wife.
Complainant, yes.
Wife, yes sir.
offense.
I filed a wakalat last week only.
Oh.
Kindly grant time for filing objection to petition as well as for IA.
ಮಾಡಿ. Husband.
I want time.
Husband ಅಲ್ವಾ?
For the husband.
I am a victim.
Victim. ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡಿದ್ರೆ ದಿನ ಬೆಳಗ್ಗೆ ಜಗಳ ಆಡೋದನ್ನೆಲ್ಲ 498 ಮಾಡಿ ಇಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, FIR ಎಲ್ಲ ಇದೆ. ಪೊಲೀಸರು
Ask him to stay back. This is not matrimonial court. Go and sit there. Yes.
Police people have manipulated and they have not brought whatever happened exactly with the life of the victim.
Yes.
They may file objections, my lord.
Huh?
Objections file
ಮಾಡಲಿ ಮಾಡೋದು ಬೇಡ ಅನ್ನಕ್ಕಾಗತ್ತೆ. This court on 17/11/2023 had granted an interim order which reads as follows. The learned counsel for the complainant has now entered appearance and seeks 2 weeks' time to file statement of objections or seeking vacation of the interim order as the case would be, lest the matter on 25th interim order stands extended till the next date of hearing. Objections, if any, by then IO stands extended to the next date of hearing. Yes, next.
Much okay.
52.
Niva,
ನಾನೇ respondent too, sir.
part in person. Have you appeared before the committee?
Yes, sir.
ಹಿಂದಿನ ಕೇಸ್ ಆಗಲ್ಲ, ಈ ಕೇಸ್ ಮಾಡಿದೀರಾ?
ಹೋಗಿದ್ದೀನಿ ಸರ್, ಹೋಗಿ ಅಪ್ರೂವ್ ಆಗಿದೆ. ಆಗ್ಲೇ 2 ಸಲ ಅಟೆಂಡ್ ಆಗಿದ್ದೀನಿ ಸರ್. ಒಮ್ಮೆ ಧಾರವಾಡದಲ್ಲಿ, ಒಮ್ಮೆ ಇಲ್ಲಿ.
ಅದೇ ಕೇಸ್ ಆಯ್ತು?
ಹೌದು, ಅದೇ ಕೇಸ್.
We'll take it in 18ಕ್ಕೆ. ಏನ್ ರಿಕವರಿ ಆಫ್ ಮನಿ ತಾನೆ?
ಇಲ್ಲ ಡಾಕ್ಟರ್, ಸಾರಿ, ಇಲ್ಲ ಸರ್, ರಿಕವರಿ ಅಲ್ಲ. It is not a commercial transaction, my lord. It is not a commercial transaction.
What transaction?
I have loaned him for 40 lakhs.
Loan?
Yes, I
No,
have
initiate proceedings.
Through check I have given, my lord.
138 initiate
No,
ಮಾಡಿ.
limitation period is over.
ಅದಕ್ಕೆ crime register ಮಾಡಬೇಕು
I
ಅಂತಿದ್ಯಾ?
am not pressing here for compensation.
Just because 138 limitation is over, you initiate proceedings for 420? No,
My lord,
sir.
there is a theft, there is a cheating, there is a conspiracy. there
Because
is a
you have
breach
lost
of trust.
138 limitation, you can't set the criminal law into motion.
He has stolen the check for 60 lakhs and he has written down himself and depositing in the bank, my lord. There is
ಮಾಡಬೇಕಾಗಿತ್ತು, 138 ಅಲ್ಲಿ ಮಾಡಬೇಕಾಗಿತ್ತು.
There is no legally
138 ಅಲ್ಲಿ ಮಾಡಬೇಕಾಗಿತ್ತು.
My lord.
You should have initiated negotiable 138 proceedings.
ಅದೇ ಮಾಡಿದ್ದೀನಿ ಡಾಕ್ಟರ್.
ಇದು 138 ಅಷ್ಟೇ ಆಗಿರೋದು. ಮತ್ತೆ
we have filed the 138 proceedings against him, my lord, regarding this check,
My lord,
list on 18th.
Yes,
Yes.
car I have purchased.
Bangalore.
He has fraudulently he has got transferred in his name and he is using the car.
Car?
How the, my lord? There are 3 crimes in this case. One is a stolen check and deposited in the bank. 2018 he has stolen and 2020.
Everything revolves around recovery of money.
No, my lord. No, I am not pressing for money. I am not pressing
Then
for
why
money.
case ever?
Because they should face whatever the
Civil suit.
difficulties I have faced.
Civil suit for anything. Not criminal. You can't use criminal. Criminal justice system cannot be misused for this, sir.
My
Yes.
lord,
Anyway, take it on 18th.
ನನ್ನ ಲೈಫ್ ಹಾಳು ಮಾಡಿದಾನ ಅವನು.
ಅದು ಸಿವಿಲ್ ಸೂಟ್ ಡ್ಯಾಮೇಜಸ್ ತಗೊಳ್ಳಿ.
ಅದು ಹಾಕಿದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್.
ಅದು ಹಾಕಿದ್ದೀರಾ?
4 ಕೇಸ್ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ನನ್ನ ಮೇಲೆ. ಎಲ್ಲ ಬೋಗಸ್ ಕೇಸ್ ಮೈ ಲಾರ್ಡ್. ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ, ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್
ಅವನು ನಮ್ಮ ತಮ್ಮನ ಅಳಿಯ ಮೈ ಲಾರ್ಡ್. ತಮ್ಮನ ಅಳಿಯ ಮಗಳು.
100% abuse of criminal justice system.
My lord,
Not doubt
how
about
can I convince you? I am not a technically qualified person. But the thing is, documents have been forged.
You can't tell that, sir.
ದುಡ್ಡು ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ.
Earlier you appeared in a case which I have held it in your favor.
Yes, my lord.
Then you
Thank
can't
for
say
that,
I'm not
my
a
lord.
technical person.
Thank you for that. But
Thank you.
This case is more difficult, my lord. They have
But for you it is more difficult.
ಅವರು ಕಾರ್ 14 ಲಕ್ಷ ಕೊಟ್ಟು ನಾನು ತಗೊಂಡಿದ್ದೀನಿ. ನಾನು ಗಿಫ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ. ದೇರ್ ಇಸ್ ನೋ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್. ₹1 ನಾನು ಕೊಟ್ಟಿಲ್ಲ. ಅವನು ತೋರಿಸಲಿ, ಎವಿಡೆನ್ಸ್ ತೋರಿಸಲಿ. ಇಲ್ಲ,
ನಿಮ್ ಕಾರ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರಾ?
ಟ್ರ್ಯಾಕ್ಟರ್ ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೆ. ಟ್ರ್ಯಾಕ್ಟರ್ ನನ್ನ ತಮ್ಮನ ಹೆಸರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾನೆ. ಫೋರ್ಜ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡಿ ಟ್ರ್ಯಾಕ್ಟರ್ ನನ್ನ ಪೊಸಿಷನ್ ನಲ್ಲಿ ಇದೆ ಅಂತ.
ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಏನ್ ವೆಹಿಕಲ್?
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ.
ಇನ್ನೊಂದು ಲಾರಿನಾ?
ಇಲ್ಲ, ಎಲ್ಲಾನು ಇದು ಒಂದೇ ಕೇಸ್.
ಟ್ರ್ಯಾಕ್ಟರ್ ಕಾರ್ ಅಷ್ಟೇನಾ?
3 ಇದೆ ಇದರಲ್ಲಿ. 3 ಇದೆ. ಒಂದು
ಟ್ರ್ಯಾಕ್ಟರ್ ಅವ್ರು ಇದು ಮಾಡ್ತಾರೆ.
ಟ್ರ್ಯಾಕ್ಟರ್, ಕಾರು, ಲಾರಿ.
ಚೆಕ್ಕು, ಟ್ರ್ಯಾಕ್ಟರು, ಕಾರು 3 ಎಲ್ಲ ಇಲ್ಲೇ ಇದರಲ್ಲೇ ಇದೆ.
ಎಲ್ಲ 3 ಇದರಲ್ಲೇ ಇದೆ. 18ಕ್ಕೆ
ದಯವಿಟ್ಟು ಅದನ್ನ
18th
ತಾವು ಸ್ಟಡಿ ಮಾಡಿ ಮೈ ಲಾರ್ಡ್.
ರೆಡಿ ಮಾಡಿ ಏನ್ನ? ಎಸ್, 18th.
ಇಂಟೀರಿಯರ್ ಮಾಡ್ಬೇಕು ಕೈಂಡ್ಲಿ.
ಅವರು ವಿಡಿಯೋ ಕಳಿಸಿದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್. ಎಲ್ಲ ತಪ್ಪಾಯ್ತು, ಇದು ಆಯ್ತು, ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತೀವಿ, ಆದ್ರೆ ದುಡ್ಡಿಲ್ಲ, ಏನಿಲ್ಲ. ಈ ತರ ನನ್ಗೆ 3 ಕೋಟಿ ಬರ್ಬೇಕು. ನನ್ಗೆ ಒಂದು
3 ಕೋಟಿನ
ಒಂದ್ ಕೇಳಿ ಮೈ ಲಾರ್ಡ್.
ಟ್ರ್ಯಾಕ್ಟರ್ ಎಷ್ಟು? ಯಾವ ಟ್ರ್ಯಾಕ್ಟರ್? ಕಮ್ಮರ್
ಡೈರಿ ನಡೆಸ್ತಾ ಇದ್ರು. ಫಸ್ಟ್
ಪಿಟಿಷನ್ ಮೈ ಲಾರ್ಡ್, ಐ ಗಾಟ್ ರಿಟೈರ್ಮೆಂಟ್ ಇನ್ 2014 ನಲ್ಲಿ ರಿಟೈರ್ಮೆಂಟ್ ದುಡ್ಡು ತಗೊಂಡು ಊರಿಗೆ ಹೋದೆ. ನಂಗೆ ಒಂದು ಕನಸಿತ್ತು, ಏನು ಅಂದ್ರೆ ಒಂದು ಡೈರಿ ಫಾರ್ಮ್ ಮಾಡ್ಬೇಕಂತ. ಶ್ರೀ ಸದಾಶಿವ್ ಮಿಲ್ಕ್ ಡೈರಿ ಅಂತ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದೆ ವಿತ್ 30 ಬಫೆಲೋಸ್. ಅದಷ್ಟೊತ್ತಿಗೆ 2016 ಅಲ್ಲಿ ಒಂದು ಶೇರ್ ಮಾರ್ಕೆಟ್ ಅಲ್ಲಿ ನಂದು ಲಿಟಿಗೇಷನ್ ಇತ್ತು. ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ವರೆಗೂ ಹೋಯ್ತದು. ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿ 6 crores ಕಾಂಪೆನ್ಸೇಷನ್ ಸಿಕ್ತು. ಆ ದುಡ್ಡು ಅವಾಗ ಊರಿಗೆ ಹೋಗಿದ್ದೆ, ಅಲ್ಲಿ ತಗೊಂಡು ಒಂದು ಗಾರ್ಮೆಂಟ್ ಫ್ಯಾಕ್ಟರಿ ಮಾಡಿದೆ. ಎಲ್ಲಾನು ಹಾಳು ಮಾಡ್ಬಿಟ್ರು, ಎಲ್ಲಾನು ಹಾಳು ಮಾಡ್ಬಿಟ್ಟು, ನಾನು ಗಾರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದೀನಿ, 1.5 ಲಕ್ಷ ಸಂಬಳ ಕೇಳ್ತಾನೆ, ನಾನೇ 50,000 ತಗೊಂಡಿದ್ದೀನಿ. ಆಮೇಲೆ ನಾನು ಡೈರಿ ಅವ್ನಿಗೆ 1 ಲಕ್ಷ ಇನ್ಕಮ್ ಇತ್ತು, 50,000 ನೀನ್ ಇಟ್ಕೋರಪ್ಪ 50 ಕೊಡು ಅಂತ ಹೇಳಿದ. ಬಳ್ಳಾರಿನಲ್ಲಿ ಅವ್ನು ಒಳ್ಳೆ ಕಂಪ್ನಿನಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದ. ಬಟ್ he did something, some mischief and he was thrown out.
No problem. Very good story for a pot boiler, not criminal justice system.
ಅದು
Anyway.
ಅವ್ರ ಲೀಗಲ್ ನೋಟಿಸ್ ಅಲ್ಲಿ ನೋಡಿತಾವು.
ಅದು ನೋಡಿ.
ಆಲ್ ಬೋಗಸ್
18th.
ಬೋಗಸ್ ಸ್ಟೋರಿ ಹಿ ಹ್ಯಾಸ್.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಲ್ವಾ?
ಅವ್ರು ಏನು ಕೊಡಲ್ಲ ಮೈ ಲಾರ್ಡ್.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗತ್ತಾ?
ವಿಚಾರ ಮಾಡ್ಬೇಕು.
ಇಲ್ಲಲ್ಲ, ವಿಚಾರ ಮಾಡಿ.
ಹೌದು, ಇಲ್ಲಲ್ಲ.
ಅವ್ರಿಗೆ ಮನೆ ಕೊಡ್ಸಿದೀನಿ ಮೈ ಲಾರ್ಡ್, ಸೈಡ್ ಕೊಡ್ಸಿದೀನಿ, ಅವ್ರ ಮದುವೆನೂ ನಾನ್ ಮಾಡಿದೀನಿ. ನನ್ನ ತಮ್ಮ
ಆಯ್ತು, ಏನು ಮಾಡಿಲ್ಲ ಬಿಡಿ, ಅವರು ಎಲ್ಲ ನಿಮ್ದೆ.
ನನ್ನ ತಮ್ಮ ಅಗ್ರಿಕಲ್ಚರ್ ಇಷ್ಟು, ಅವನ ಹತ್ರ ಏನೂ ಇರ್ಲಿಲ್ಲ, ಕುಡಿತಿದ್ದ, ಸೇದ್ತಾ ಇದ್ದ.
ಅದು ಸಾಕು, ಇದು ಕೋರ್ಟ್ ಇದು. ಸಾಕು. 18th.
ಇದರಲ್ಲಿ ಪಿಟಿಷನ್ ನಂಬರ್ 3 ವಾಸ್ ಡೇಟ್ ಮೈ ಲಾರ್ಡ್. ಅದು ಇಲ್ಲಿ
ಅದಾಕ್ಲಿ ಅವತ್ತು ಮಾಡಿ
ಅರೆಸ್ಟ್ ಮಾಡಿ ಇಂಟೀರಿಯರ್
ಅಬೇಟ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ, ಡೋಂಟ್ ವರಿ.
Consensual relationship between.
ಏನು?
Consensual relationship. Since 8 years.
80 years.
8
years.
ನಿಶ್ಚಿತಾರ್ಥ ಮಾಡಿ, ನಿಶ್ಚಿತಾರ್ಥ ಮಾಡಿ ಆಮೇಲೆ ಕೈ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾಕೆ?
ಅವ್ರು ಬರ್ಲಿಲ್ಲ.
ನಿಶ್ಚಿತಾರ್ಥಕ್ಕೆ ಬರ್ಲಿಲ್ವಾ?
ಅಲ್ಲ, ನಿಶ್ಚಿತಾರ್ಥಕ್ಕೆ ಬಂದ್ರು, ಮದ್ವೆ
ಬರ್ಲಿಲ್ವಾ?
ಎಂಗೇಜ್ಮೆಂಟ್ ceremony performed on 14/4/2024.
Why she ran away, is it?
She did agree. The marriage date fixed on 16/17/2024.
Correct. She did not come for marriage.
Did not come. We paid all the charges, chowdhury and other fees, but she didn't come. Merely the marriage is not performed. Yes, yes.
ಕಿಡ್ನಾಪಿಂಗ್ ಕೇಸ್ ಕೊಡ್ಬೇಕಿತ್ತು.
ದುಲ್ಹನಿಯಾ did not come.
ABS ಕಾರ್ಪಸ್ ಹಾಕ್ಬೇಕು, ABS ಕಾರ್ಪಸ್ ಒಂದು ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
ಅದೇ ಅಲ್ಲೇ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ನೀವು. ಇವಾಗ ಮದುವೆ ಆಗ್ತೀರಾ?
ಇಲ್ಲೇ ಇದ್ದಾರೆ,
ಇಲ್ಲೇ ಇದ್ದಾರಾ?
ಬೆಂಗಳೂರಲ್ಲಿ ಅದೇ ಅಡ್ರೆಸ್ ಅಲ್ಲೇ ಇದ್ದಾರೆ.
ಇಲ್ಲ, ನೀವು ಈಗ ಮದುವೆ ಆಗ್ತೀರಾ?
ಇಲ್ಲ ಸರ್, ಈಗ ಜೈಲ್ಗೆಲ್ಲ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಜೈಲ್ಗೆಲ್ಲ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇನ್ಫ್ಯಾಕ್ಟ್ ದಿ ಪಿಟಿಷನರ್ ನಂಬರ್ 2 lodged the complaint. She orally lodged complaint to the
oral complaint.
2 months prior to the complaint, she lodged the complaint.
Who are the petitioners?
Petitioners number 1 is the boy, 2 is his mother, 3 is neighbor.
Neighbor? Why?
He advisor, he participated in the marriage talks.
ವರದಕ್ಷಿಣೆ ದುಡ್ಡು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ. ವರದಕ್ಷಿಣೆ ದುಡ್ಡು ಕೊಡ್ಲಿಲ್ಲ.
ವರದಕ್ಷಿಣೆನೇ ಕೇಳಿಲ್ಲ ಸರ್.
ಅದೇ ಇರೋದು ರೀಸನ್.
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿದೆ.
ಜೈಲ್ಗೆ ಹೋದ್ರಲ್ವಾ? 3 ಜನ ಹೋಗಿದ್ದೀರಾ?
ಇಲ್ಲ, ಒಬ್ರು.
ಫಸ್ಟ್ ಒನ್ ಮಾತ್ರ. ಎಷ್ಟು ತಿಂಗಳು?
ಆಲ್ಮೋಸ್ಟ್ 1 month.
ಅಷ್ಟೇ ಅಲ್ಲ, ಅಲ್ಲಿಗೆ ಸೆಟ್ ಆಫ್ ಆಯ್ತು ಅಂತ. ವರದಕ್ಷಿಣೆ ಕೇಳಿದ್ರೆ ಅಲ್ಲಿಗೆ ಸೆಟ್ ಆಫ್ ಆಯ್ತು. ಎಸ್, ಲಾಸ್ಟ್ ಟೈಮ್ ಕಂಪ್ಲೇಂಟ್ ಬಂದಿರಲಿಲ್ಲ ಅಂತ ಮಾಡಿದ್ದೆ ಅಷ್ಟೇ. ದಿ petitioners are accused 1, 2 and 3 are at the doors of this court calling in question proceedings in CC 40547 of 2024 arising out of crime number 246 of 2024 registered for offences punishable under section 376, 420, 323, 504 and 109 read with section 34 of the IPC. The facts in brief, heard so and so. Facts in brief, Germain, are as follows. The petitioner and the second respondent is the complainant. It is the case of the complainant, so as the case of the prosecution, that the petitioner, first petitioner and the complainant were acquaintances for 8 years.
8 years.
For 8 years, and have had relationship for over 8 years, and the relationship being physical as well. The talks of marriage take place between the families of both the petitioner and the complainant. The betrothal ceremony is also performed. The betrothal ceremony did not lead to the logical conclusion of marriage between the two on the score of certain differences of opinion with on manifold circumstances between the families of the first petitioner and the complainant. On the alleging breach of promise of marriage, the complainant registers a crime on 29/6/2024 for the aforesaid offences of rape and criminal intimidation. The first petitioner, being in relationship with the complainant, is not the sole person drawn into the web of proceedings. The mother,
Mother.
mother of the first petitioner and the neighbor is also drawn into the web of crime. The police, after investigation, police conduct investigation in the aforesaid crime, file a charge sheet against these accused. Filing of the charge sheet is what has driven these petitioners to this court in the subject petition. The learned counsel appearing for the petitioner would submit that the relationship between the complainant and the first petitioner was ಎಂಟು
childhood friends.
ನಿಮಗೆ 23 ವರ್ಷ 8 ವರ್ಷದಿಂದ ಏನ್ ಮಾಡಿದೆ?
ಇಲ್ಲ, childhood friends.
Childhood friends. The learned counsel for the petitioner submits that the complainant and the first petitioner were childhood friends, and therefore the friendship had blossomed into relationship, and the relationship into becoming into a physical relationship as well. He would submit that on such score, breach of promise of marriage cannot result in an offence under section 376 for rape. He would further contend that the other offences laid against the petitioners are also frivolous based on no content. Per contra, the counsel for the complainant has remained, those served long ago, has remained unrepresented. 2 or 3 opportunities were granted awaiting the appearance, but even today the complainant is not represented. Therefore, the learned additional SPP for the state is heard. The learned additional SPP would take this court through the summary of the charge sheet as obtaining in column number 17 to contend that the police, after investigation, have filed a charge sheet, and the charge sheet would indicate that the offences are committed by the first petitioner, at least for the offences of offences punishable under section 376 and 504 or even 323 of the IPC. He would therefore submit
420
and 420 of the IPC, and would therefore submit that the proceedings must be permitted to be continued against these petitioners. I have given my anxious consideration to the submissions made by the respective learned counsel. The aforenarrated factum of relationship between the first petitioner and the complainant is a matter of record. The complaint itself narrates that the petitioner and the respondent, first petitioner and the complainant, were childhood friends and had a relationship between them since 2016 or 17, as the case would be. Since the entire as the case would be. The talks of marriage also trigger between the families of the first petitioner and the complainant, but did not end in marriage. Therefore, the physical relationship between the petitioner and the first petitioner and the complainant for over 8 years is now projected to become a crime for offence of rape. Since the complaint has triggered the registration of the crime, I deem it appropriate to notice the complaint. It reads as follows, page 23 to 25. The police, after investigation, file a charge sheet against these petitioners. A summary of the charge sheet as obtaining in column number 17 reads as follows.
Page number 45, column number 17.
Page 45.
45.
Reads as follows. A perusal at the complaint or the summary of the charge sheet would unmistakably indicate that the relationship between the first petitioner and the complainant for over 7 years was the relationship of love between the first petitioner and the complainant was for over 7 years.
You will become a minor.
ಅದೇ ತಪ್ಪಾಗ್ಬಿಡುತ್ತೆ. For over 6 years ನೀವು 17 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. For over 6 years. How old is the lady girl?
5 years. She was married and her husband died, and thereafter
widowed.
Oh, childhood friends. The complaint would narrate that the petitioner, who was at the time of friendship with the complainant, 18 years old, and the complainant then gets married to someone, who he dies, is it? Married to someone and the husband of the complainant died, and the relationship between the first petitioner and the complainant gets rekindled and goes on for another 5 years thereafter. The talks of marriage also ensue between the families of the first petitioner and the complainant. The talks of marriage fail, and the complainant goes to the jurisdictional police station to register the complaint of the offense of rape. The issue now would be whether the consensual relationship of the complainant and the first petitioner would amount to the offense of rape under section 376 or not is to be considered. The consideration of which need not detain this court for long or delve deep into the matter. The apex court and plethora of judgments right from the apex court in Dhruvaram Mudaliar so and so 2019 18 SCC page 191 has held as follows. The said judgment is later followed by the apex court in the case of Lalu Yadav versus so and so 2024 SSC online SC page 2876. Paragraphs 2876 is held as follows. The apex court in a later judgment in 2024 SSC online SC 3471 holds that mere breakup between the couple who were in a relationship for a long time cannot result in the offense of rape offense of rape under section 376 of the IPC. In the light of the aforesaid circumstances, in the light of the unequivocal facts as narrated herein above and the summary of the charge sheet, if considered on the bedrock of the principles laid down by the apex court in the aforesaid judgments, permitting further proceedings against the petitioners would become an abuse of the process of the law. The first petitioner who had relationship is drawn into the web of crime. The second petitioner, the mother of the first petitioner who did not encourage the marriage, is drawn into the web of crime, and the neighbor who had sat with the first petitioner and the second petitioner for talks of marriage is also drawn into the web of crime. If proceedings are permitted to continue, what would ensue is patent injustice. Therefore, I deem it appropriate to obliterate the same against these petitioners. For the aforesaid reasons, the following order allowed quashed. ಇವಾಗ ಮದುವೆ ಆಗಲೇಬೇಕು. Next.
54.
When is the husband coming?
In a week.
Huh?
In a week. He'll come and.
Senior counsel is coming?
One week till ಬಂದ್ಬಿಡ್ತೀವಿ.
ಆಯ್ತು.
This case, my lord, there are 254 complaints have been registered in NCRB.
Police custody ಬೇಕಾ?
Because this is the mule accounts, my lord, the all IT fraud.
The wife get no problem, but husband police custody told.
So far as the husband also is concerned, of course, wife they set out to say that there were accounts for the wife, adilla. Husband ಏನು ಇಲ್ಲ. He is the A13.
Husband?
Yeah, husband A13.
Charge sheet ಅಲ್ಲ, crime ಅಲ್ಲ?
Crime ನಲ್ಲಿ.
Crime ನಲ್ಲಿ.
FIR complaint.
ಅಲ್ಲ crime ಅಲ್ಲಿ.
Crime ನಲ್ಲಿ.
Charge sheet A1 ಹಾಕ್ತಾರೆ, don't worry.
ಅಲ್ಲ A1 to 5 is
there are
yet to
how many
investigate.
complaints have been registered on the NCRB portal? 250 plus complaints have been registered against this company.
Present petitioner ಮೇಲೆ ಇಲ್ಲ. It started off with a solid single complaint against one person.
No, you come cooperate with the investigation.
We'll come and cooperate with the investigation. And we will show all our accounts.
ಅಲ್ಲ police custody ತಗೊಳ್ಳದೇ ಇರಂಗ್ I can't pass orders. If they want to investigate, they will investigate.
No, this is a mule accounts created scam, my lord, because that
now,
is how entire IT scams are happening.
Since all this is documentary evidence, I will produce all the evidence before them. Let them peruse that and then let them come out.
No,
I'll come to
I
you.
will only protect you on when you land in the shores of this nation. But later, if they file an application for police custody before the concerned court, this order will not come in the way. You have to fight it out before the court.
But ಅವಾಗ
Now,
protection
for
will
it
not
on a
get-
bail court ಮಾಡೋದು ಬೇಡ.
ಅವಾಗ all the other directors, but they were just taken.
So these are if proved or if seen offenses against the society.
Correct. But ಅಲ್ಲಿ ಇನ್ನೊಂದಾಗಿದೆ. Their claim is there is a polytheist company ಅಂತ. That company I am the director ಅಂತ. That company made this app. That is their allegation. I am a director of a company which made the app.
Whatever, there are allegations against
It is
you.
not that that company itself participated in collecting the money.
Investigate
app
ಮಾಡಿ.
More than
developer.
50 plus people have online registered a complaint. On NCRB portal, 94 plus
Not
crores
against the
of,
company, not against this company.
So how do they know which company? They're only talking about their money is being
ಅದಕ್ಕೆ you
scammed.
come and ನೀವು ಅಲ್ಲಿ ದುಬೈಲ್ ಕೂತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಗಲ್ಲ.
ಅಲ್ಲ ಬರ್ತೀನಿ, I will give
ನೀವು
all my documents.
ಇಲ್ಲೇ ರೆಡ್ ಕಾರ್ನರ್ ನೋಟಿಸ್ ಕೊಡಕ್ಕೆ ಹೇಳ್ತೀನಿ.
all my documents, all the statements, everything I will give it to them and we'll cooperate with the investigation. But today, they do not have any substantial information against me that this is the amount that you have taken.
ನೀವು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕೋಆಪರೇಟ್ ಮಾಡಿದ್ರೆ ಬರುತ್ತೆ ಇನ್ಫಾರ್ಮೇಶನ್. You may be absolved also, who knows?
In fact, wife also, my lord, though they said no transaction, we have a record, my lord, show that the multiple
Now she has
accounts.
cooperated with the investigation?
She
has
fact,
cooperated.
she did, I say, my lord, she has given a statement, the statement is incorrect, and subsequent to her statement, through other means, we have detected a source where she received money, and she did not even disclose about those accounts.
The salary I have received.
No, but she did not even disclose those accounts.
ಎಲ್ಲ
Salary
entire
from
account
Anyway,
statement
I'm not going to grant bail here. Police custody or apply ಮಾಡಿದ್ರೆ you before the court you apply. I will only protect you from arrest once you land on the shores of this nation and reserve liberty to approach the court.
ಅವಾಗ ಏನಾಗ್ಬಿಡುತ್ತೆ,
ಏನು ಇಲ್ಲ, ನಾನು ಎರಡು ದಿನ ಇಲ್ಲ 3 ದಿನಕ್ಕೆ I will protect you ಅಷ್ಟೇ when you land here.
Let him seek for anticipatory bail. No,
ಅದಕ್ಕೆ you can seek an anticipatory bail, you need not be present. Seek anticipatory bail.
ಅಲ್ಲ 253 complaints ಅಂತ ಹೇಳ್ತಾರೆ, nothing against me or this company.
ಅದಕ್ಕೆ you seek
It is
bail
on the
before.
larger issue where
Seek
money
bail
has been
before the court.
transferred to some fictitious company. ನನ್ನ ಮೇಲಲ್ಲ.
ಅಲ್ಲ, whatever, seek bail before the court. If you cooperate with the investigation, definitely will protect you for 1 week after you land. ಅಷ್ಟ್ರಲ್ಲಿ bail ತಗೊಳ್ಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ they will whatever application file.
Please.
ಯಾವಾಗ ಬರ್ತೀರಾ ಹೇಳಿ.
Within 2 weeks I'll be here.
Date ಬೇಕು, within 2 because I have to say 1 ವಾರ ಅಂತ.
ಅಲ್ಲ, when are you coming?
ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ, ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ.
Within a week will come.
Correct. You tell me the date, I will incorporate the date. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ, ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ. ಅದಕ್ಕೆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬೇಡಿ. 16th.
Yes. 1 week.
10 days protection.
The petitioner, this court in the companion petition, the wife of the present petitioner, had granted certain protective orders. The
She can dispose of the petition itself.
dispose ಮಾಡ್ತಾರೆ.
The petition can be disposed of.
In the light of the protective orders and the cooperation with the investigation and in the opinion of the court, the investigation to continue, the companion petition stands disposed, reserving liberty to the petitioner to avail of such remedy as is available in law at the appropriate time. ಯಾವುದು wife?
Both can be disposed of.
ಅಲ್ಲ, wife to the protection lord is already granted.
That will be there.
Wife protection.
ನೀವು bail ತಗೊಂಡಿಲ್ವಾ?
ಇನ್ನು ತಗೊಂಡಿಲ್ಲ.
ಅಲ್ಲ, ಹಂಗಾರೆ you should take bail. Not to arrest ಅವೆಲ್ಲ will not go on for
Not wife petition, the husband's petition may be disposed of, wife petition next week happen. By then we will apply.
well, I will continue it for another 15 days. You apply bail and take it. Remedy available in law. The wife had been protected by the orders passed by the court. On the strength of the said protection, it transpires.
Wife too can we request the continuation because otherwise they will arrest her immediately.
Bail ತಗೊಳ್ಳಿ, bail ಕೊಡದೆ ಏನು?
Ingredients of the material would not show against. So for the 406
ಅದು bail ತಗೊಳ್ಳಿ.
He sought for quashing of the entire case.
Quashing ಅಂದ್ರೆ my dismissal will lead to problems.
That's the reason, Malad, keep it pending so that we'll cooperate with the investigation. Court can
withdraw it and
material is available against or not.
You do one thing. I have granted protective orders. You withdraw the petition, then file it in case of need. No problem at all.
Lordship can extend the benefit for next 2 weeks for them to approach the trial.
482 bail ಅಂತೂ ಕೊಡಲ್ಲ ನಾನು.
But my humble prayer to this court is, Malad, keep pending these matters so that if the investigation material discloses the commission of offence.
No, I am not here to scrutinize the investigation.
No.
We have now only we have.
No, then see, if I see the investigation papers and record it, it will become difficult for you.
We have bank statements, multiple accounts, money has been received.
ಅದು ಆ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಅಲ್ಲ ಅದೆಲ್ಲ
ಏನಿಲ್ಲ
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಬೇಕು. I am not, in this case, I am not going to stall investigation. In cases that are to be allowed, I'll allow it straight away, not in this case. 15 days protection continue ಮಾಡ್ತೀನಿ, you take bail before the concerned court.
ಆಯ್ತು.
Otherwise, matter for investigation, I will reject it.
Kindly pass over. Submit.
Passover, senior ಇಲ್ಲೇ ಇದ್ದಾರೆ?
ಸ್ವಲ್ಪ ಯೋಚನೆ ಮಾಡಿ ಹೇಳಿ.
ಆಯ್ತು. Passover.
2:30ಗೆ ಪ್ಲೀಸ್.
Passover ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡ್ ಬನ್ನಿ, 4:35 o'clock.
ಆಯ್ತು.
Yes.
ಇಲ್ಲ ನಾಳೆಗೆ tomorrow.
ಆಯ್ತು, ನಾಳೆ. Let's tomorrow, same stage. Entry module.
Please.
55.
Fine.
2020 da?
Yes, sure. ಒಂದು 10 ಸಾರಿ ಬಂತು ರೀಚ್ ಆಗಲಿ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ.
There was some talks for compromise.
Correct. Last time I have recorded.
I made a submission that trial court record advocates they have spoken a lot, but
ಇನ್ನೊಂದು ವಾರ, ಇನ್ನೊಂದು 2 ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ ಬೇಕಾದ್ರೆ.
2 ವಾರ ಬೇಡ ಸರ್, ಮುಂದೆ
ಒಂದು ವಾರ ಕೊಡಿ ಸ್ವಾಮಿ. Either we will settle it or we will.
List the matter on 10th. This court on 12/6/2025 had passed the following order. List the matter on 10th. The interim order granted earlier stands extended on the same terms. In the event no settlement is arrived at, matter
We'll
will be
argue
heard
it.
on its merit. Yes.
ಯಾಕೆಂದ್ರೆ purchaser during the pendency of the suit, she purchased the property. Then she filed the appeal after a lapse of 9 years.
FDP is also filed into the, I will anyway argue on merits.
Yes, I agree.
Yes.
56.
For the petitioner in this case, your lordship. Lordship, without giving a proper opportunity.
Proper opportunity?
Your lordship may kindly appreciate the judgment is passed within 4 months' time.
ಮಾಡಬಾರ್ದು ಅಂತಿದೆ.
ಅಲ್ಲ, ಮಾಡಬಾರ್ದು ಅಂತ ಏನಿಲ್ಲ, but I have not given with a proper opportunity.
Respondent ಯಾರು?
Apart from that, what has happened?
Respondent.
ಕಳೆದ ಬಾರಿ ಬಂದಿರ್ಲಿಲ್ಲ.
ಅಲ್ಲ, ಹೆಸರೇ ತೋರಿಸಿಲ್ಲ.
ತೋರಿಸಿದಾರ?
ಎನ್ ದೇವರಾಜ್.
Lordship, what has happened? Petition scheduled property, I have come out from the petition scheduled property.
ಬರ್ಲಿ ತಾಳಿ. Heard the learned counsel appearing for the petitioner. There is no representation behalf of the respondent. In the event the respondent would not be represented on the next date, petition would be disposed on hearing the counsel for the petitioner. List on 10th. Yes, next.
57.
Interim order subsisting will continue till the next date of hearing.
Appearing for the respondents, my lord.
List on 17th. Next.
58.
No representation behalf of the petitioner. List on 17th.
For specific performance of a land belonging to an SC/SC.
711 rejected.
711 rejected.
Ah.
As against which we have preferred this revision. 4-2, my lord, is a bar. It's a void.
Oh, same matter.
Same matter. The other matter where my learned friend had 24, that matter.
ಯಾವತ್ತು ಹಾಕ್ತಾ ಇದು?
ಅದು 24.
50 ಅದೇ ಹಾಕೋಣ. Stay ಇದೆಯಲ್ಲ?
Stay.
List the matter on 24th. Interim order subsisting, it should go. Subsisting shall continue till the next date of hearing. Yes.
59.
Appearing for respondent number.
Suit for partition, my lord. Petitioner is the defendant number 1 before the.
Correct. 711 ಅವರೇ ಹಾಕಕ್ ಸಾಧ್ಯ.
There is no cause of action on the.
Reason.
Already partition, as per the, in the year 1982, my lord, already partition has been taken place, my lord. The plaintiff has, in the plaint amendment, my lord, the plaintiff is clearly admitted, my lord. Can you see the page number, annexure C, my lord, page, annexure.
Plaint government ಹೋಗಿ sir.
Annexure, B, page number 22, my lord. Page number 22, my lord.
That before that, I would like to make one submission.
Para number 4,
Trying to tell something before that ಅಂದ್ರೆ ಹೆಂಗೆ?
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದೇ ವಿಚಾರ.
ಹೇಳಿ.
The very same petitioner has filed one more partition suit. The same is pending before the trial court. These two properties were not included in that partition suit.
ಅಲ್ಲೇ ಮಾಡಿ.
ಎರಡನ್ನು ಕ್ಲಬ್ ಮಾಡಿ ಲೆಟ್ ಬೋತ್.
ಅಲ್ಲ, ಅದ್ರಲ್ಲೇ ಮಾಡಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿ ಪ್ರಾಪರ್ಟೀಸ್.
ಕೊಟ್ಟು.
ಸೇಮ್ ಪೆಟಿಷನರ್.
Same petition.
Yes, sir.
ಅದರಲ್ಲಿ this respondent is also one of the party.
ಗೊತ್ತಿರ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ?
Before the third additional senior civil judge. ಅದಕ್ಕಿಂತ
ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ? ಪಾಸ್ ಓವರ್, ವಿಲ್ ಕ್ಲೋಸ್ ದಿಸ್.
ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಪೇಜ್ ನಂಬರ್.
ನೀವೇನ್ ಬರೀ ಬಿಫೋರ್ ದಟ್ ಅಂತಾನೆ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಇನ್ನೊಂದು
ಆಫ್ಟರ್ ದಟ್ ಹೇಳಿ.
ಅವ್ರು ಸ್ಟಾರ್ಟ್ ಮಾಡೋದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ವಿಚಾರ. ಇದರಲ್ಲಿ ಮುಂಚೆ 1/4 ಶೇರ್ 1/5 ಶೇರ್ ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿತ್ತು ಪಿಟಿಷನರ್ಗೆ. ಆ ಪ್ರಾಪರ್ಟಿ ಮದರ್ ಆಫ್ ದಿ ಪಿಟಿಷನ್, ಗ್ರಾಂಡ್ ಮದರ್ ಆಫ್ ದಿ ಪಿಟಿಷನರ್ಗೆ 1/5 ಶೇರ್ ಅಲಾಟ್ ಆಗಿತ್ತು. ಸೊ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅದ್ರ ಪ್ರಕಾರ
ಒಟ್ಟಿಗೆ ತಗೊಳಕ್ ಹೇಳೋಣ, ಇಲ್ಲ ಒಂದ್ ಕ್ಲೋಸ್ ಮಾಡಿ.
ಅದು ಎರಡನ್ನು ಕ್ಲಬ್ ಮಾಡಿ ಲೆಟ್ ದ ಅರ್ಲಿ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ಬೋತ್ ದ ಕೇಸಸ್.
ಪಾಸ್ ಓವರ್, ಸೇಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್.
60.
Respondent, my lord, I am the owner of the scheduled property.
Some reasonable time, my lord. Avenue Road is where the property is there. It's a shop premises. I've been doing
reasonable
business.
time?
My client 2 years time, my lord.
2 years, sir. Already 1 year, ಅದು ಡಿಗ್ರಿ ಆದ್ಮೇಲೆ 1 year ಇದ್ದಾರೆ ಅವರು. 1 year 2 months ಇದ್ದಾರೆ. Once ಏನೋ reasonable
months ಅಷ್ಟೇ.
It's a commercial property.
So what?
20 years
Some
ಅಂತ
reasonable
ಇದ್ದಾರೆ.
time. Some more.
No, 6 months. ಆಯ್ತು ಸಾಕು, ಎಷ್ಟು ಟ್ರಬಲ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ, trouble ಅಲ್ಲ, my lord. I am running business and
20
there
ವರ್ಷ
is
ಆಯ್ತು
no
ಅವ್ರನ್ನ.
default, my lord, whatsoever.
ರೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಕರೆಕ್ಟ್ ಆಗಿ?
ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ರೇಟ್ ವರ್ಷಕ್ಕೆ ಒಂದ್ಸಲ ಕೊಡ್ತಾರೆ.
ಇಲ್ಲ, every month, my lord, I can.
Annual rent, monthly rent?
No, every month, my lord, I am paying.
Not
My
every
daughter, my lord.
Every month you are paying annually?
No, every month, monthly rent is being paid.
After filing this appeal, my lord, in month of April, he has paid 1 year rent.
No, my lord, I'll pay, my lord, produce.
Arrears ಎಷ್ಟಿದೆ ಈಗ?
Yes, on the
Our daughter accepts it. By Google Pay, it is being made.
What? Arrears ಎಷ್ಟಿದೆ?
Arrears 4 months ಇದೆ ಸರ್.
My lord, absolutely, I can produce it.
ಅದೊಂದು, ಆಮೇಲೆ ಯಾವಾಗ ವೆಕೇಟ್ ಮಾಡ್ತೀರಾ? 6 months?
ಇಲ್ಲ, 6 months.
ನನ್ನ ಇದ್ರ ಪ್ರಕಾರ 3 months. ಆದ್ರೂ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಇಸ್ ಪರ್ಮಿಟೆಡ್ 6 months. I know objection.
ಈಗ ನನ್ನ ಪ್ರಕಾರ 12 months ಅಂದ್ರೆ?
ಇಲ್ಲ ಅಲ್ಲ, ಅದು ಆ ರೀತಿ ಹೇಳಲ್ಲ.
ಹೇಳಲ್ಲ.
I got ಹೇಳಲ್ಲ.
6 months.
6 months.
I'll relocate, my lord. Some
6 months time.
ಇಲ್ಲ, some more.
ಒಂದು affidavit ಹಾಕ್ಬಿಡಿ.
ಇಲ್ಲ, some more time. My lord, next week, my lord, I'll file it. Some more reasonable time.
Landlady is a widow, my lord. He is a widow. Her husband died in the COVID, my lord. Some problem is facing.
No, 2 daughters are there. My lord, I'm paying them the rent regularly. No arrears whatsoever. Throughout, my lord, I have been.
9 months ಮಾಡ್ಬೋಣ.
ಇಲ್ಲ ಬರ್ತದೆ.
A good
6
tenant
months.
throughout.
Please, my lord. 6 months.
1 ವರ್ಷ ಆಗೋದಿಲ್ಲ ಡಿಗ್ರಿ ಆಗಿ?
1 ವರ್ಷ ಆಗಿದಾಗ.
This honorable court has granted because there was 2.
Already ಡಿಗ್ರಿ ಆಗಿ 1 ವರ್ಷ ಆಗಿದೆ ಇವರು.
Interim order ಇದೆಯಾ?
Granted by this honorable court.
1 ವರ್ಷ ಆಗಿದೆ.
6, my lord, they kept on asking.
File an affidavit of 9 months from today with no default in rent. ಅಷ್ಟೇ maximum. No.
1 year.
I'll reduce it to 6 months.
1 year done.
I'll reduce it to 6 months. 9 months affidavit ಹಾಕಿ. ಮುಂದೆ ಲಿಟಿಗೇಷನ್ ಇಲ್ಲ, ಕ್ಲೋಸ್ ಮಾಡೋಣ.
ಮುಂದೆ ಫರ್ದರ್ ಶುಡ್ ನಾಟ್.
ಅದಕ್ಕೆ affidavit ಅಂಡರ್ಟೇಕಿಂಗ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆಲ್ಲೂ ಹೋಗಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕಷ್ಟೇ.
Monday.
Tuesday. Tuesday, Wednesday. By Wednesday you file. ಅವತ್ತು ಕ್ಲೋಸ್ ಮಾಡೋಣ ಬಿಡಿ.
Without fail, my lord. Again, they're going to file.
On Wednesday, the learned counsel for the petitioner shall file an affidavit of undertaking of vacating the premises within 9 months from today and paying all arrears of rent. List on Wednesday.
Advance amount will pay at the time of the vacant person, my lord. Advance was to pay 7 lakhs rupees. Yeah, deposit.
ಕೊಡ್ಲೇಬೇಕು.
ನಾ ಕೊಡ್ತೀವಿ.
ನೀವು ಕೊಡ್ಬೇಕಲ್ಲ, ಕರೆಕ್ಟ್?
ನಾ ಕೊಡ್ತೀವಿ.
9 ತಿಂಗಳಾದ್ಮೇಲೆ.
ಅದೇ ಅವತ್ತು ಲಾಸ್ಟ್ ಡೇ ಕೊಡ್ತೀವಿ.
ಲಾಸ್ಟ್ ಡೇ ಕೊಡಿ.
ಅಲ್ಲ, ಬಿಫೋರ್ 1 week also I am ready to write this.
Wednesday. Next. Interim order will continue to the list. Next. Next.
61.
I am the 4th defendant in the suit. The trial court.
Suit for?
Suit is for declaration and partition. Now the.
Why 711 is rejected?
711 is rejected on the ground that it is unfair to rely on pleadings. The trial court excerpts the law on order 711.
What else it wants to rely on?
That's right. Your lordship will have page 36. at the middle of the paragraph, the trial court says at this stage, it is utmost unfair to hold no cause of action to the present suit solely on the basis of pleading. Now, what happens is a 1991 sale deed is challenged in 2023.
The petitioner defendant is before this court calling in question an order of the concerned court dated 2/4/2024 rejecting an application filed under Order 7 Rule 11 A and D, read with 151 of the CPC. The reason for rejection is found in paragraph 10 of the said order, which reads as follows. The concerned court holds that no pleading can be referred to in answering an application under Order 7 Rule 11D, while the law is, it is only the pleading that have to be looked into for an application under Order 7 Rule 11D. The learned counsel for the petitioner submits that a sale deed of 1991 is sought to be questioned by filing a suit in OS 4757 of 2023, which is more than 30 years vintage. Therefore, the application had been preferred. In the light of the aforesaid reasons, there shall be an interim order of stay.
Stay there.
Idya, matya kelilla.
Stays out.
Yes. Nande order. Yes. So and so.
Petition is uncontested, Your Lordship may allow it.
Alli, uncontested, illi.
No one appears to the respondent. Your Lordship had declared service is deemed to be complete on the previous date. Now the ground of limitation has also found favor with the MFA court, albeit for a different purpose, but
it's held against the plaintiff.
That's right.
Anyway, then type madiri, I'll tell you. I'll have to just look into it then.
Good.
Yes, we'll take it on Thursday next and close it. Yes. Just on Thursday in admission.
62.
Your Lordship, in this matter, suit for partition without challenging the sale deed of 1958. Sale deed is dated 9/11. Please, madam. In fact, last time they took, Your Lordship, given.
For the respondent number 1 to 3, my lords, the contention made before this court that the sale deed is 65 years old and stay was granted, my lords.
Correct.
But the limitation has been, it is clear from the plaint, my lords. That was not the ground for rejecting the 7 Rule 11 before the trial court, my lords. It's a whole different conflict.
But that's a different thing. 65 years correct ado?
No, my lords.
Mate.
Because our knowledge was whole different, because there are two grandfather and father. Both name are Munyappa. And there is a conflict between them, my lords. We have received the paper
Munyappa
only.
versus Munyappa, what is wrong?
My lords, great father was Munyappa and their son was Munyappa and Nanjappa, my lords. We had acquired the property, its ancestral property, my lords. We had went for the partition.
Suit for partition.
Yes, my lords. Suit for partition.
Suit for?
Suit for partition.
Partition.
Your Lordship may kindly see the family tree which has been given. It's not a family property at all. For the first, Your Lordship may kindly see. The plaintiffs are the son of grandson of Nanjaya. The property belonged by virtue of a grant to Kari Muniyama. He has sold the property in 1958. Now the brothers' grandchildren are seeking for a partition of the property which was sold in 9/11/58. His grandfather has not challenged, his father has not challenged, and these people seek to challenge now.
My lords,
and who are not born also at the time of sale.
No, my lords.
I mean, it's only to arm twist them to settle the matter. That's all.
My lords.
Elli property idu?
It's a property located in Biddi.
Bidina?
Yes, my lords.
My
My lords, my small contention is the defendants who are my brothers. When a suit for partition is applied, the defendants are born before the partition was enforced. As per their claim, they were born before the partition, my lords. First point. Second point, the defendants are my brothers and sisters. Automatically, they gain the right. Even they are made as a defendants in the suit for partition because they have the equal right.
Well, here it's.
Yes, my lords.
File your objection.
No, my lords. We'll file an objection and with citations, my lords.
Any short date, if I may request.
I'll take it on 23rd.
Yes,
Objections, if any, by then.
Yes,
List
my
the
lords.
matter. Heard the learned senior AGL,
No.
Learned senior counsel K. Shashkiran Shetty appearing for the petitioner. This court on 19/6/2025 had passed the following order, noticing the fact that the sale deed of 1958 had sought to become the subject matter of the list before the concerned court in OS 12 of 2024 filed for partition. The interim order of stay was granted. Counsel for the respondent submits that he seeks 2 weeks time to file statement of objections. List on 23rd, objections if any.
If possible, earlier, my lord, just short point.
ಇಲ್ಲ, first August.
23rd.
ಅಲ್ಲ 23rd. Change ಆಗದು 1st August. Yes, 23rd.
63.
Last time I promised.
Appearing for the
Very
respondents.
33,000.
ಎಷ್ಟು?
33,000. my lord.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ, ಅದೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾರ್ಚ್ ವರೆಗೆ ಕೊಟ್ಟಿದ್ವಿ. ಏಪ್ರಿಲ್, ಮೇ, ಜೂನ್.
3 ಆಯ್ತಾ ಈಗ?
Please,
Satisfied? All right, so we'll
But-
take it after 2 weeks.
My lord, it's an 80-year-old building, my lord.
ಆಯ್ತು, we'll take it. ಈಗ ಜಾಸ್ತಿ, ರೆಂಟ್ ಜಾಸ್ತಿ ಬೇಕಾ?
ರೇಂಜ್ ಜಾಸ್ತಿ ಬೇಕು ಅಂತ ಅಲ್ಲ ಮೈ ಲಾರ್ಡ್, 3 months ಟೈಮ್ ಕೊಟ್ಟಿತ್ತು ವೆಕೇಟ್ ಮಾಡಕ್ಕೆ ಪೊಸಿಷನ್ ಡಿಗ್ರಿ ಅಲ್ಲಿ, ಬಟ್ ಸ್ಟಿಲ್ ಅವ್ರು ಸ್ಟೇ ತಗೊಂಡು ಇನ್ನೂ ಆದ್ರೂ ಮಾಡ್ತಾ ಇಲ್ಲ. ಲೈಕ್
ಈಗ ಯಾವಾಗ ವೆಕೇಟ್ ಮಾಡ್ತೀರಾ ಸರ್?
ವಾಶ್ಮೆ ಕೈಂಡ್ಲಿಸಿ ಅವರು ಕಂಟೆನ್ಷನ್, ಅವರು ಲಾಯರಿಗೆ ಆಫೀಸ್ ಬೇಕು ಅಂತ.
ಮತ್ತೆ ಆಲ್ ದ ಮೋರ್ ಇಂಪಾರ್ಟೆಂಟ್, ಯಾವಾಗ ವೆಕೇಟ್ ಮಾಡ್ತೀರಾ?
ಆಗಲ್ಲ, ಅವ್ರು ಇರೋದು ಸ್ವಂತ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲೇ ಅವೆನ್ಯೂ ರೋಡ್ ಅಲ್ಲಿ. ಆಮೇಲೆ ಒಂದು ಬಿಲ್ಡಿಂಗ್ ನಾನು 2 ಕೇಸ್ ನಡೆಸ್ತಾ ಇದ್ದೆ.
ಅದು ಏನಾದ್ರು ಜಸ್ಟಿಫಿಕೇಶನ್ ಇರಲಿ,
ಒಂದು
ಸಫರ್ಡ್ ಅನ್ ಆರ್ಡರ್
15/20 ಕೊಡ್ಸಿದ್ದೀನಿ.
15ರಿಂದ 20,
15/20 ಒಟ್ಟು 5 ಶಾಪ್ ಇದೆ, 3 ಶಾಪಿಗೆ ಹಾಕಿದ್ದಾರೆ.
ಮೈ ಲಾರ್ಡ್, ಹಿಂದೆ ಒಂದು ಶಾಪ್ ಇದೆ, ಅದ್ರ ಈಕ್ವಿವ್ಯಾಲೆಂಟ್ ಆಗಿ ಮುಂದ್ಗಡೆ 4 ಶಾಪ್ ಇದೆ. 1 ಶಾಪ್ ಈಕ್ವಲ್ಸ್ ಟು 4 ಶಾಪ್, ಆ ತರ ಇದೆ. ಅದಿದೆ,
ಹಿಂದ್ಗಡೆ ಇದಾರ ಮುಂದ್ಗಡೆ ಇದಾರ?
ಇವರು ಮುಂದ್ಗಡೆ 4 ಶಾಪ್ ಇರೋ ಕಡೆ ಇದಾರೆ. ಅದ್ರಲ್ಲಿ 1 ವೇಕೆಂಟ್ ಇದೆ, ಇನ್ನು 2ರಲ್ಲಿ ಇವ್ರ ಅಣ್ಣ ತಮ್ಮ ಇದಾರೆ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ಮೆಡಿಕಲ್ ಶಾಪ್ ಇದೆ. ಸೊ ಇವಾಗ ಅವರೆಲ್ಲ ವೇಕೆಟ್ ಮಾಡಕ್ ರೆಡಿ ಇದಾರೆ, ಮೆಡಿಕಲ್ ಶಾಪ್ ಅವರು, ಸೊ ದಟ್ ವಿ ಕ್ಯಾನ್ ಡೆಮಾಲಿಶ್ ದ ಬಿಲ್ಡಿಂಗ್ ಅಂಡ್ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಅ ನ್ಯೂ ಹೌಸ್. ಮೈ ಲಾರ್ಡ್, ಇಟ್ಸ್ an 80-year-old building.
ನೋಡಿಲ್ಲ ನಾನು ದಿವಸ.
ಮೈ ಲಾರ್ಡ್, ಐ ಹ್ಯಾವ್ ಅ ಫೋಟೋಗ್ರಾಫ್. ಮೈ ಲಾರ್ಡ್, ನೋಡಿಲ್ಲ ಅಂತ ಹೇಳೋಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ, ದಟ್ಸ್
ಫೋಟೋಗ್ರಾಫ್ ಅಲ್ಲಿ ನೋಡೋದಕ್ಕೂ ನಾನು ನೋಡೋದಕ್ಕೂ ವ್ಯತ್ಯಾಸ ಇದೆ. ಅವು ಹಿಂದೆ ಮುಂದೆ ಇಲ್ಲ,
ಎಲ್ಲ ಒಂದೇ.
ಅಲ್ಲಲ್ಲ, ಹೀಗಿದೆ ಸ್ವಾಮಿ, ಒಂದೇ ಕಡೆ ಇಲ್ಲ. ಅದು ಅವು ಹಿಂದೆ ಮುಂದೆ
ಅದು ಹೆಂಗಾದ್ರೂ ಇರ್ಲಿ, ಯು ಹ್ಯಾವ್ ಸಫರ್ಡ್ ಎನ್ ಆರ್ಡರ್. ಯಾವಾಗ ವೆಕೇಟ್ ಮಾಡ್ತೀರಾ ಹೇಳಿ?
ಈಗ ಒಂದು ಒಟ್ಟು
1, 2 ಎಲ್ಲ ಇಲ್ಲ, ಯಾವಾಗ ವೆಕೇಟ್ ಮಾಡ್ತೀರಾ?
3 ಕೇಸಲ್ಲಿ ಒಂದು ಇನ್ನ ಸಮನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ.
ಮೈ ಲಾರ್ಡ್, ಡಿಗ್ರಿ ಲಾಸ್ಟ್ ಇಯರ್ ಆಗಸ್ಟ್ 1st ಗೆ ಆಗಿದೆ. ಮೈ ಲಾರ್ಡ್, 3 months ಟೈಮ್ ಆಗಿ ಇವಾಗ ಆಲ್ರೆಡಿ ಆಗಸ್ಟ್ ಬಂದಾಯ್ತು, 1 year ಆಗಕ್ ಬಂದಾಯ್ತು.
ನಡೀತಾ ಇದೆ, ಇನ್ನ 2 ನಡೀತಾ ಇದೆ.
ಈಗ 2ರದ್ದು ಬಿಡಿ, ಇದ್ರದ್ದು ಹೇಳಿ. ಇದ್ರದ್ದು ಯಾವಾಗ ವೆಕೇಟ್ ಮಾಡ್ತೀರಾ?
2 years ಕೊಡಿ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್? 6 months, 9 months ಅಷ್ಟೇ. ಅಫಿಡವಿಟ್ ಹಾಕಿ, ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. ಆಲ್ ಲಿಟಿಗೇಷನ್ ವಿಲ್ ಎಂಡ್.
1 year ಆದ್ರೂ.
ನೋ ಮೈ ಲಾರ್ಡ್,
ಯಾಕಂದ್ರೆ ಇನ್ನೊಂದು ಕೇಸ್
ಅದು ಆಮೇಲೆ ಆ ಕೇಸ್ ನೋಡ್ಕೊಳ್ಳಿ. 6 ಇಲ್ಲ 9 ಯಾವ್ದು ಬೇಕು?
3 months ಮೈ ಲಾರ್ಡ್.
ಒಂದು 12 ತಿಂಗಳಾದ್ರೂ ಮಾಡಿ ಸರ್.
6 or 9? 9 is fine. Yes. Affidavit ಹಾಕಿ. Tuesday file an affidavit.
Tuesday ಬೇಡ, 8 ಬಿಟ್ಟು.
8 ಬಿಟ್ಟು 10.
ಸಿಕ್ಕಾಪಟ್ಟೆ ಆಯ್ತು.
10. List on 10th file an affidavit. So that ಮತ್ತೆ ಯಾವ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕಾಗಿಲ್ಲ, ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡೋಣ. ಇಲ್ಲ,
ಪ್ಲೀಸ್ ಮೈ
interim order subsisting will continue till the next date of hearing.
ಗ್ರೇಟ್ಫುಲ್.
33,000 may kindly be recorded.
ಯಾವುದು?
Amount paid.
On the learned counsel for the petitioner hands over a demand draft.
Demand check.
Hands over a check of rupees 33,000 being the arrears of rent as on today. The learned counsel of the petitioner shall also file an affidavit of undertaking of delivering vacant possession of the premises within 9 months from 10th. The affidavit shall be filed before this court on the 10th.
List number 2, serial number 1. I think mentioned at 2:30 is what the officer is here.
2:30 ತಗೊಂತೀನಿ. Petitioner status report.
I'll place it, my lordship can other matter at 2:30 only.
ಕೊಡಿ. ಅದರಲ್ಲಿ I would require your assistance. I'll tell you. Interim order will continue.
My apologies, my lord. Serial number 42, my lords have heard and reserved the matter for order.
Serial number 42.
42.
ಇವತ್ತಾ?
Yes, my lord.
ಏನಾಯ್ತು?
P&AC matter, in the last date of hearing, we had filed an affidavit requesting court to appoint a court commissioner to check the bank lockers and submit a report before the town court, my lord.
ಅದರ್ದು not with regard to who should be appointed ಅಲ್ವಾ? Oh, then ಅದು ಬೇಡ. We take that tomorrow, reserve ಬೇಡ. I thought Mr. Ajay ಇನ್ನೊಂದಿದೆ, ಆ ಮ್ಯಾಟರ್ ಅನ್ಕೊಂಡ್ಬಿಟ್ಟೆ. Yes.
Serial number 8. My apologies, my lord. Serial number 8 in list number 2.
ಅದು ಮಧ್ಯಾಹ್ನ ಅದು. Yes.
Serial number 75 morning.
ಈಗ ಪೇಜ್ ವೈಸ್ ಕರಿತೀನಿ, ಒಂದು ನಿಮಿಷ. Yes. ಕರೆದ್ಬಿಡಿ.
Serial number 65.
ಒಂದು ನಿಮಿಷ ಕರಿತಾ ಇದ್ದೀನಿ.
Page wise adjournment. Page 12, 64 to 67.
65, my lord.
60.
Respondent 64.
64 ಅಲ್ಲಿ ಏರಿಯಸ್ ಪೇಡ್ ಆಗಿದೆ.
ಅಲ್ಲ ಏರಿಯರ್ಸ್ ಇನ್ನ 22,200 ರೂಪಾಯಿ ಬ್ಯಾಲೆನ್ಸ್ ಇದೆ.
36,000 ಲಾಸ್ಟ್
ಹಾಗಾದ್ರೆ ಇರಿ. Yes, next. 65.
Serial number 65, my
Appearing
lord.
with the petition in this case.
Appearing for respondent number 1 and 2. Today I filed a wakalat, my lord. Kindly 2 weeks time may be granted. Today I filed wakalat.
ವಕಾಲತ್ ಹಾಕಿದಾರ. Learned counsel so and so submits that he has entered appearance for respondent 1 and 2 registry to print the name of so and so. List the matter on 24th. Objections if any by then. Next.
Page 13, 68 to 73.
ಇಲ್ಲ 73 appear ಇಲ್ಲ 73 emergency notice ಅಂತ ತಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಬಟ್ ನೋಟಿಸ್ ಡಿಸ್ಪ್ಯಾಚ್ ಆಗಿಲ್ಲ ಮೇ ಬಿ ಕನೆಕ್ಟೆಡ್ ವಿತ್ ಅದರ್ ಮ್ಯಾಟರ್
73 tag with serial number.
19 to 23.
90 to
19 to 23.
19 to 23.
ಅದರಲ್ಲಿ
ಅದರ
ಸರ್ವ
ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡಿ ಮೇಡಮ್. ನೆಕ್ಸ್ಟ್
71.
70 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ?
I appear for the respondent because they have delivered possession on 10/3/2025. The only question is that arrears of rent and they said that they want to
Party
settle
in
it.
person.
ಅವರು ಇವ್ರು ವಕಾಲತ್ ಹಾಕಿದಾರಂತೆ.
Learned counsel Raghavendra Agnihotri submits that he has
ಹೌದು.
entered appearance for the petitioner registered to print the name of so and so is appearing for the petitioner. Next week.
We are settling the matter, bro.
Learned counsel for the petitioner submits that talks of settlement between the two are afoot AFOT.
So far the arrears of rent discussed.
In so far as it concerns the arrears of rent, therefore, as the possession has already been delivered, list the matter on 24th.
First week.
ಆಯ್ತು, first week ಹಾಕೋಣ. List the matter on 7th August.
So by the time we'll make.
Next.
Number 75 ಅಲ್ವಾ? Week after next.
Interim order will continue. 75?
I informed the other side.
Yes, madam. No objection.
They want, yes. Next week, any date will be.
Next week ಇಲ್ಲ, 17th.
ಅದು
List on
interim order will
17th.
kindly be.
At the request of the council appearing for the petitioner, interim order will continue.
Page 15, 79 to 83.
Serial number 74 please.
74 CRP. ಏನು?
ಇವತ್ತು ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ.
ಸ್ವಲ್ಪ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೇಳಿದ್ದೀರಾ?
ಇಲ್ಲ I will kindly inform.
If we come, if we interim order ಇದೆಯಾ?
Entry ಮಾಡಿ.
ಅದಕ್ಕೆ
ಇಲ್ಲ.
rest on 24th, interim order would continue at the request of the council for the petitioner. Next.
Page 15, 79 to 83. Page 16, 84 to 89.
Lords, 84, my lords.
Ah.
In 2 weeks' time may be granted, my lords. Statement of
84,
objection.
learned counsel BS Sachin seeks 2 weeks' time to file statement of objections. Objections, if any, in the next 2 weeks, 24th.
Much.
Next.
Page 17, 90 to 95. Page 18, 96 to 104. Page 19, 105 to 109. Page 20, 110 to 114.
My lord, 111 for respondent number 3. Adjourn for 2 weeks, my lord. I file my statement of objection.
Same respondent, 2 weeks' time, file objections, 24th.
Your Honor, serial number 109. I appear on behalf of Nayantara PG. We seek time in this matter, Your Honor.
Same 24th,
Officer
same
petitioner,
order.
You extended.
Interim order. Next.
Serial number 109, Your Honor.
Done, madam. Yes.
Oh, grateful, Your Honor.
ಒಂದು ನಿಮಿಷ.
Hello? Hello, court officer? Hello? Hello, court officer? Hello? Hello?
Investigation is going on. If the other court would quash the crime,
That's an apprehension, I understand from the complainant side as well. If
No, even any
matter has
contrary.
been posted
no,
on
conflicting
22nd,
orders cannot be.
When there were less graver offences, the predecessor bench had not given interim relief. When there are more graver offences now, and the Supreme Court had already confirmed your lordship's order to now ask for staying of an FIR once we have already progressed to the stage of investigation, and investigation having to culminate in a report that has to be
So
filed. with the
we'll
lordship.
pass an order of tagging the two and to this court.
if I may, your lordship.
Okay, other
22nd
lane
is the
problem. I am not, accused need not be heard at the investigation stage at all, madam.
problem with that, lordship. I may submit it's on 22nd.
Maybe.
If 22nd, if the matter can be heard, and then if a call can be taken.
No,
up,
no,
then
no,
we'll
no,
get
no.
it.
Now we'll pass this order. Yes. The counsel for the petitioner has filed a memo.
Order that
Why are you apprehensive,
court's
madam?
action, it can be tagged along.
No problem. Yes. The petitioner, learned counsel for the petitioner has filed a memo appending certain documents. This court, by an order dated 25th April 2025, had passed certain orders of constitution of a special investigation team and the same to be and the status report to be submitted before this court. The order reads as follows. In furtherance of the said order, the matter is listed today for the status report being placed before this court. Accordingly, status report is placed before the court. A perusal at the status report would indicate the investigation is still at the periphery. Though it is neatly structured, it is still at the periphery, and a deeper delving into the issue by the investigating team that is constituted is imperative. The learned counsel for the petitioner also submits that a petition seeking quashment of the FIR so registered had been filed in the month of February 2025, and the matter is pending before the coordinate bench. And an application is filed seeking amendment of the petition before the coordinate bench. The coordinate bench is said to have listed the matter for the matter to be heard on the inclusion of on the entire crime on 22nd is it? 22nd July. Done? Yes. 22nd July 2025. The counsel for the respondent, counsel for the accused who is representing the petitioner, should I say that? For the counsel for the accused in criminal petition so and so is present before the court and would submit that the matter is on the 22nd, and therefore this court should wait till the coordinate bench would pass necessary orders on the 22nd, if any. The issue is the probability of conflicting orders being passed by two different courts. This court constituted a special investigation team. The special investigation team was directed to investigate in bearing in mind the observations made in the course of the order, as it was observed that the subject crime had the color of a cyber espionage, and therefore espionage. This was carried to the apex court by the accused. The apex court turns down the SLP. The issue now turns down the SLP. Therefore, in the light of the fact of probability of emergence of conflicting orders, it is necessary that both the petitions be heard together, i.e. the present petition, which present petition in which orders are passed directing the status report to be filed by the investigation team from time to time, and the petition seeking quashment of the crime that was registered anterior to the order passed by this court constituting the SIT. The registry is directed to place the files before Honorable the Acting Chief Justice for appropriate orders to be placed, appropriate orders and further action. List the matter on
22nd, the matter is posted.
There it is posted. We'll see what the Honorable Chief Justice will do. Yes. On the 25th, the status of investigation conducted by the special investigation team of all the offences now on file shall be placed before the court on the said date. 24th. You are not a party here. Ad tag admele. In the event it's tagged. All right. Yes.
So then that second aspect may also be investigated, not the role of the relative of the accused who had facilitated the destruction and tampering of that evidence.
Observation I've already made in the original order itself. Yes, that is Rajasthan.
Rajasthan.
SIT is looking at all that.
So investigation is neatly done, but in the periphery still. Yes.
2 months.
A learned heard male, learned counsel, learned additional SPP B and Jagdish. So I'll say you're representing the SIT. Representing the SIT.
So
one submission, my lord. Sorry to interrupt in between.
Yes, sir.
Serial number 114. My lord. Serial number 114. For cause list number 1, my lord, we missed seeking for interim extension. Request
So
if
don't
my
worry,
lord
sir.
can consider.
If interim orders is there, it'll interim orders are there, it'll get extended. Next, yes.
114. Well, much obliged, Your Honor. Much obliged.
Paying for.
Where's the ASG?
He'll come.
Start.
Yes.
Such a jute. Yes.
The jute is slightly
jute,
on the
that's-
other side. The
Take
such is
credit.
the problem.
Jute pe jute bol raha hai.
But I don't think, my lord, anyone is disputing that the act, that is the Jute Packaging Materials Act, is to the benefit of the persons, my lord, who are involved in the manufacture
Correct.
of. But the point is, there is a mechanism.
That could be indisputable. Yes.
That, I want to say that first because obviously there will be a lot of submissions made as to how the act is really for a beneficial piece of legislation for a particular class, and therefore you cannot ignore it. And our case is not that you must ignore it. Our case is that notwithstanding the fact that it is beneficial, you can't ignore the health of the masses, nor can you ignore the importance that you must give to quantities of jute that are actually available, and most importantly, as to what is the role of the Standing Advisory Committee in doing all of this.
No, if I can recollect, 3 submissions, I think Udayola sir had come.
Yes.
3 submissions are made. First, the jute packaging material causes carcinoma because of the content in it.
Because of an oil called the jute batching oil.
That's jute batching oil, which is used for preparation of the jute bags, would cause carcinoma. That is study whatever it is. Next is jute is the jute for the as a byproduct there is unavailable. Not byproduct, but the raw material.
Raw materials.
That is to be for the jute bags is unavailable. You are importing it from Bangladesh. One thing. Bangladesh and China, na?
Mainly Bangladesh.
Bangladesh. Fine. The third one is what did you say about the third one? Just now you said
hygroscopic.
No, not hydroscope. Third one anyway. I think he has filed. This is what I remember. Heli.
Now, my lord, in the structure of the act, there is a particular mechanism which requires a standing advisory committee to evaluate it year after year and give advice to the central government as to what quantity and for what material this jute packaging should be used. Now, we have, my lord, looked at all the standing committee reports over the years, and I can tell you also fairly confidently that it is more or less cyclo-styled. There is absolutely no application of mine. And of course, now the Jute Mill Association has placed the latest before your lordships. What the main and most important point that I want to place before my lord is, everyone have been consistent in the position that jute is not suitable for sugar. The reason is, sugar, as your lordships know, is hygroscopic. It absorbs moisture.
Correct.
Absorption of moisture automatically results in all kinds of germs, my lord, accumulating in, and not only germs, but also sugar itself hardening. And no one across the world uses jute for sugar. Everywhere else, it's HDPE bags itself. As a matter of fact, every single entity to who a huge quantity of sugar, my lord, actually is purchased by institutional buyers. No institutional buyer says we will love jute, like when it's Coca-Cola or Nestle or any of the entities.
That's a necessity now because of the act or because of the direction.
No, not. They don't accept jute bags.
And that is what I'm telling. Now it has become necessary because of their insistence.
Yeah, no, obligation is on us as every single sugar manufacturing
Correct.
company.
Obligation is on you.
Yes.
The imposition is by them.
Imposition is by the SAC.
That is what I'm telling.
Oh, I meant not that the buyers.
Obligation is on you. Correct.
That's the buyers who actually buy it as an institution for purposes of utilization of sugar in chocolates or soft drinks or any other products.
Nobody would accept.
No one accepts it. So that is universal. As a matter of fact, tenders called by state government undertakings themselves say we will not accept jute bags. And every single state which has appeared before the Standing Advisory Committee has been consistent in saying that jute bags for sugar is impermissible. Now, when all of that material is available, and I show your lordship some material, because my entire objective is to show your lordship as to how the SAC has failed to examine anything and simply proceeds as if there is a whole bunch of statements made. Statements are made, we will simply say 100% for food grains, 20% for sugar. And that is how almost every year it has been going on. From every single decision does not take into consideration any statement made by any authority. Now, just to start with this, can I request my lord to look at the latest SAC recommendations, which have been filed along with a statement of objections, filed by respondent number 3, my lord, on 16 June 25.
Madam. Objection, 16 June 25. Objection.
Shravan Lokre hakir. Madam, it's thin volume. I have an additional copy, should I?
Memo.
No, no, it is. It's called additional objection filed on behalf of respondent number 3. Yeah, I have another copy, my lord.
Give it. Go ahead, sir.
Because this is the latest. And now, my lord, there is one more extension that is made. From point number 4, my lord, your lordships will see. First is a representative of National Federation of Cooperative Sugar Factories and Indian Sugar and Bioenergy Manufacturers Association. My lord will see all the complaints.
Yes.
Then Sugar Department, Government of Andhra Pradesh. Indian Federation of Woven Technical Textiles. My lords have that at, sorry, page 16 onwards. Page 16.
Just saying, what are these documents?
Oh.
Yes.
Page 16.
Minutes of 30-second meeting.
30 seconds. This is the latest note on 30th July 24.
Yes.
The first 3 paragraphs, my lord, are with respect to convening of the meeting. Then please see 4 onwards. The first is, my lord, the statement by the National Federation of Cooperative Sugar Factories, Indian Sugar and Bioenergy Manufacturers Association on various problems. Sugar Department, Government of Andhra Pradesh, and they say 100% exemption. Then, Lord, 4 at the bottom is Food Corporation of India.
Yes.
Then,
yes, sir.
Government of Madhya Pradesh.
So one stream that runs in this is gap in jute bags.
Gap in jute
leakage
bags.
And moisture will destroy the sugar inside.
Sugar entirely. So what they've done is, and I must
that is the common objection of all the states.
Everybody. there is a thin lining that is given inside the jute bags. This is
Yes.
a plastic lining.
Yes.
But plastic lining, that is a 30 micron thin lining which is provided. And the oil, my lord, which is used.
That's batching oil.
No, first they use batching oil.
That is for preparation of the bag.
Yes, for preparation, because the jute will not, otherwise will not soften.
And that's what softening of the
They have to
jute.
soften it with jute batching oil.
Generally, the softening oils are carcinogenic. rather.
Certainly carcinogenic, and I'll show you lots of the reports as well. On top of that, my lord, they put a lining. Now, the danger of the lining is it's a plastic lining. It's a very thin plastic lining, and your lordships know that when sugar is actually lifted, they use that hook to push through a bag and lift it out. And therefore, my lord, the entire lining which is there actually is of no consequence.
One clarification.
Yes.
Does it require for the mighty union government for a sugar growing whatever association to project before it that there is health hazard in jute batching oil? Are they not aware of it before they bring in these things?
They should be.
Would not the mighty government know it that yes, it does cause health
And
hazard?
your lordships know, now this petition itself has been pending before my lord, where we have gone from a learned single judge who has recorded it to the division bench to the Supreme Court on the
Correct.
interim application
Yes,
itself.
interim
Let
application.
us assume they didn't know at all. At least they knew now that we've been crying hoarse that there is a serious problem of.
Do you mean to say without any?
They should know without it. That's
without any diligence they have done all this?
Absolutely no diligence. But when all of these statements are made, please see how the advisory committee examines it.
Adralle idya memoli?
Yes, but it's part of that minutes itself.
Yes.
Can I request Mano to kindly come all 5, 6 at page 20, 5, 6, 7, 8, 9, 10 are all with respect to the problems.
Correct.
Then 11, Chair. Chair stated that during last year, capacity of jute mills has gone up. Demand of jute bags from government side for packaging of food grains has gone down. Therefore, capacity of jute mills must be utilized for production of jute bags for packaging of sugar, so that industry may get proper and timely indent for supplying of jute bags. Jute mills have come forward to register themselves as GEM portal for supplying of jute bags. Jute geotextiles, technical textiles are emerging industries.
What is the answer to the problems?
No answer. Simply said, this is it. Food grains, 100%, 20% sugarcane, sugar production. That's it. No answer for anything. There is no consideration of any material. And Lord, this is not something which we have been saying now. Rangarajan committee appointed by the government has said it long back. 2013 onwards, and I show your lordship those very quickly. I've made on convenience compilation for your lordships.
Yes, it's here.
Cholla also gave it to your lordships last time.
Yes, it's here. It's here. Yes.
Yes, Lord. I want to show your lordships CACP.
Page
430. That is the Commission for Agricultural Costs and Prices. This is 2023 I'm showing you lordships, but the same thing we have produced from the year 2013 onwards. They're all similar.
Yes.
Yes, Lord. Please come to page 448. I'm sorry, 444, 444. Which, my lord, is your lordship will find it para 8, and then specifically, my lord, at page 451. 1.14.
I've already marked all those.
Your lordship will mark it.
I think Pulla sir has made a mention of all that.
Yes.
Yes.
So similar statements are there continuously in every year from 2013 onwards, saying no more sugar, jute for sugar.
And again 4.188, 487.
487. Then 491, my lord, there is
491, then 557, the communication.
Yes, 557 communication, you lordship
Yes.
will please see. Then Lord Rangarajan report at page 384. At my lord 392.
392
and para 11.
Para 11.
Para
Already,
11.
already marked.
Marked sugar should be
Yes.
removed from the purview of.
Yes, yes.
I asked myself, Lord, now material is available.
Yes.
Now the standing advisory committee is not a committee which is simply some kind of a rubber stamp. It has an obligation under the
Now,
act.
if you see 373 and at 377, clause D, insofar as jute bags are concerned, sugar may be exempted completely.
Correct.
That's
That was,
the
Lord,
advisory committee's recommendation.
that was the minutes of the 30th meeting.
30th meeting.
At the 30th meeting, though this recommendation was made, government simply said 20% continues.
Yes. And now with the 32nd meeting, what is said is only not what you read out.
Yeah, that's
Yes.
it. That's all. And on that basis, Lord, a fresh notification is issued. 100% food grains, 20% sugar.
Sugar.
That's essentially what they've done.
So jute is now directed to be used for 100% food grains.
Yes.
It's only 20% sugar.
20%. No.
20% of the sugar,
Entire sugar manufacturer.
sugar manufacture, 20% should be,
20%.
jute should be used.
Jute should be used. Whether it is not 10% or 20%, the consequences, all of that jute is going to hit households. Because institutional buyers don't buy it. And therefore, there are certain kinds of bags which don't require it. Like for instance, they've called fortified sugar. Sugar fortified with vitamins.
Now the sugar manufacturers, you pack it in a jute bag. Jute bag of what quantity?
50 kgs.
50 kgs. Which consumer will buy 50 kgs straight away?
No, 50
Then
kgs no one
it is
buys.
only, who buys it is the distributors or retailers.
Shops. Retail shops. And
Retail,
then they,
retail shops of 50 kilos. That is then bought into plastic bags or whatever, however they sell it.
or
So it
sold
is not,
loose.
it is not going to the consumer straight. But since sugar is stored in that batched oil jute bag, you
which is
say
hygroscopic.
it transports
Which
that
is hygroscopic.
carcinoma.
Which is hygroscopic. There are
Which
two
is
things, Lord.
hygroscopic, of course, yes, because absorbs all the
Moisture.
moisture there.
So the oil, my lord, with the moisture and the sugar in it is a deadly combination, which essentially, the point is someone has to consider it.
Yes.
The standing advisory committee, my lord, has failed in its obligation to consider it.
Yes.
And nobody can dispute these facts because these are not reports that we've generated. These are reports, my lord, which have come from independent entities.
Yes.
Now, I think your lordships, last time it was shown on this, insofar as institutional buyers, we had produced, my lord, documents. Institutional buyers, which means companies which buy.
Yes.
Page 560 onwards.
560,
the convenience compilation.
It's Parole Agro.
Parle, at the end, your lordship will see packaging size 50 kgs, packaging condition packed in HTP bags with PP lining.
Yes.
Then your lord will kindly see at page number 565. This is Abbott Nutrition. It should be packed, my lord, in polypropylene bags on point B. With food grade polythene liner or polypropylene bags parallelized and stretch wrapped.
Yes.
Then your lordship will see Ferrero, which Nestle, my lord, is at page 566. The requirement is it should be impervious to moisture. 566.
Yes.
Packaging. Then at 567.
No, sugar, yes, it should be.
Yes.
Otherwise, no use in putting it in a jute bag or let's see what the.
Of course,
state
my lord.
has.
I'll very quickly show you lordship, a couple of other things. Now, my lord, on shortage, there are a few pages your lordship must see. Page 366. This is from the Ministry of Textiles.
Already noted.
Already marked. Yes. Then I'll give a list.
Valla sir has completely taken me through the convenience compilation.
I'll make the point then.
Yes.
Now, essentially in all of these documents, what emerges is that the quantity of jute which was available was not even sufficient for food grain. And therefore to say that you must now utilize it for the purpose of sugar, in my respectful submission, is a rather meaningless approach when it is not even, and food grains, it is okay because you can wash food grains. If I can wash sugar, my lord, then I then have a carcinogenic water.
Correct. Sugar wash.
Sweet carcinogenic water.
Sugar wash will wash away sugar. Yes.
On this, my lord, there's a short memo which we've also prepared. Please pass. There is a study conducted. There is a study conducted, my lord, at page number 4.
Yes.
On the selection of plastic woven sacks for storage of food commodities. If my lord kindly comes to fungal population growth at page 6. My lord will see it's been considered for rice, paddy and wheat, which are stored for 6 months. And your lordship will see in PP and HTP, it's the least. And then that is one study. Of course, these may seem very obvious to me also, but there is a study which goes into it and how fungal growth occurs. Then insect development at page 8.
Now, why is it insisted? Because for the growth of the jute industry?
Beg your pardon, yes.
No, why is it insisted?
Yes, the act requires that you must promote that industry.
Oh, promotion of the industry.
Promotion of the industry. There's no doubt about it, which is why I said the act itself is a promotion. And therefore, no one can say you shouldn't promote it. But you must take into consideration the factors that are mentioned in the act. And I think my left.
No, if your statement is taken,
yes,
promotion of jute industry, one such promotion is manufacture of these jute bags. So if that is a prominent promotion of the jute industry in terms of the act, then not only sugar, anything that is packed into it carries carcinoma because of the batching oil should be there in every jute bag.
Yes.
Whether you pack sugar, whether you pack food grains, whether you pack anything, it does get the
transfer
carcinoma that is in the batch oil transmitted into the product that is there in the jute industry. And what promotion is
the
it?
difference is, of course, that's a point which is right. But I'm only saying that only difference is, at least in case of food grains like rice, wheat,
you can
wash it. So there may be a reduction in the quantity of batching of jute batching oil, which attaches itself to the food grains. But in sugar, you can't wash it. You have to necessarily use it.
Sugar, you can't wash it.
These reports, I'll only summarize, specifically say that the fungal and insect growth in a jute bag is much, much higher than it ever can be in an HTPE bag.
In a HTPE bag, yes.
And then, Lord, there are reports from various departments. Page 20 onwards.
Yes.
Department of Food of the Union of India, page 20 of the memo.
Yes.
Department of Food and Public Distribution writes, my lord, to Ministry of Textiles. Please see para 3. Representations have been received from sugar industry associations highlighting constraints in implementation of this direction. I would like to highlight the following points for your consideration: moisture absorption, financial viability, storage feasibility. As you're aware, the department is hearing.
This is by the government themselves.
Government itself. One department of the government is saying it is absolutely impractical. Then on the next page at page 21, again, the Ministry of Foods writes, my lord, to the Jute Commissioner.
Yes.
Pointing out these problems. Again, this is issued on 24th January 2024, before the meeting was held in July. But there's no reference to this letter at all. No mention whatsoever in the minutes. Similarly, my lord, at page 23, another letter is issued on 22nd May 24,
yes,
pointing out the identical problems which exist in packaging of jute.
Yes.
Now, if you'll also only look at the act for a minute, and I'll then finish, my lord.
Yes.
The copy of the act. Page 2 of the compilation.
Packaging Commodities Act.
Yes. Section 3, my lord, is power to specify commodities which are required to be packaged in jute packaging. Notwithstanding anything contained in any of the law for the time being in force, central government may, if it is satisfied, after considering the recommendation. Therefore, my lord, there is a second application of mind which is required by the central government after the recommendation is made. That it is necessary to so to do in the interest of production of raw jute and jute packaging material and of persons engaged in the production thereof, by order published in the official gazette, direct from time to time, that such commodity or class of commodities or such percentage thereof shall and from such date so and so be packaged in jute packaging material. Then Constitutional Advisory Committee at section 4. It has a list of things, my lord, which has to be examined by it. Lordship will see G. Such other material matters as the Standing Advisory Committee may think fit.
So Standing Advisory Committee has now opined so many things.
Standing Advisory Committee has recorded the observations of everybody, and the chairman says nothing else on any of the observations. 80%, 100% food grains, 20% sugar.
Yes.
That is all. And your lordship will see every other minutes that have been produced before your lordships, it is the same situation. You have said it, which is very good, but really we can't do much about it because we want to say 100% and 20%, and government will not, who is, in my humble submission, statutorily required to apply their mind to the advisory committee's recommendations under section 3, does not do anything. The orders that are passed or the notifications that are issued are again cyclostyle. It only changes the dates. They refer to the standing advisory committee, and on that basis, the same cyclostyle document is published. Third point is, fertilizers and chemicals also were being packaged. Fertilizer and cement were being packaged. That not has been exempted fully. I thought that was very obvious, because if you put water to cement, you will get cake, a hard piece of cement. Now, if it is good for cement, for health it is irrelevant. Therefore, for food grains and sugar, food grains, of course, I'm not holding a brief for, but for sugar, quite clearly and obviously, it is going to have the most disastrous consequence because of caking. And ultimately, I'll tell you what will happen. All of these sugar bags will go to rural places. If it is caked, and if not, it forms cakes and lumps, these will all go to and will be sold at much cheaper rates somewhere in the rural areas, where someone will say, I'll buy this sugar because this is the cheapest sugar that is available. And they are the ones who will suffer. No one else will.
And buying a health hazard.
You are buying a health hazard. And a hazard, my lord, which everyone knows now. And despite knowledge, you don't do anything about it. Therefore, my lord, if I may respectfully say so, if there is no application of mind by the Standing Advisory Committee to matters which are well within their knowledge and which have been brought to their knowledge by another department of the central government, various state governments, and, my lord, associations like us, and if all of that is ignored, and despite all of that, they proceed to simply pass or issue an advisory that it is going to be 100% for food grains and 20% for sugar, in my humble submission, that is absolutely violating the provisions contained in the Act itself.
Yes.
Lord, at the heart of the dispute lies the legislation called the Jute Packaging Materials Act, enacted in 1987. First, my lord, let us understand what was the object of that act. If your lordship would take the convenience volume.
Act to provide compulsory use of.
May I read it? Page 2. An act to provide for the compulsory use of jute packaging material in supply and distribution of certain commodities in the interest of production of raw jute and jute packaging material and of persons engaged in the production thereof and for matters connected therewith. So therefore, there is a statutory mandate for the government to protect the jute growing farmers and to protect their products.
Fair enough.
How to do it is laid out in section 3 and section 4.
Yes.
If I may take your lordship to section 3. Power to specify commodities which are required to be packed in jute packaging material, notwithstanding anything contained in any other law. Lord, so I will emphasize there that it begins with a non-obstante clause. Any other law for the time being in force, the central government may, if it is satisfied, after considering the recommendation made to it by the Standing Advisory Committee. So I will pause here for a moment. So all that the central government needs to do is that it has to consider the recommendation made by a Standing Advisory Committee.
Correct.
That it is necessary so to do in the interest of, not kindly see what is the interest, in the interest of production of raw jute and jute packaging material and of persons engaged in the production thereof by order published in the official gazette, direct from time to time that such commodity or class of commodities or percentage thereof as may be specified in the order shall, on and from such date as may be specified in the order, be packed for the purpose of its supply or distribution in such jute packaging material as may be specified in the order. I'll highlight and emphasize a couple of expressions. It's kindly see whose interest must be borne in mind. Number one, production of raw jute and jute packaging material and of persons engaged in the production thereof. So it clearly excludes those persons who will be compelled to use it. By law, the government is required to take into consideration the interest of the person engaged in the production, not of the person who is going to use it. That is the mandate of the law.
All right. Now, if that is the mandate of the law, the consequence of such usage you will blissfully ignore?
No, I'll come to that. I'll come to that. No,
that's all.
The consequence is something which the standing advisory has to
yes, promotion of jute industry, promotion of jute growers, all that is fine. No problem. to any other industry
No,
is
there-
fine.
there is no-
Now, when you impose that to
No,
a
my respected
a
answer.
hydroscope
I
product.
got your lordship's question. My answer to that would be, it is already considered. I will demonstrate how.
All right.
Your lordships are obviously bearing in mind the certain ill consequences which on behalf of the petitioners I have
That
raised.
is all the concern.
I will address all that. I will
That is
address
all
all
the
that.
concern.
And my submission would be,
No
that-
imposition should be
Yes. My
against
submission would
public
be-
interest.
my submission would be, in the first place, it is baseless. And number two, it has been considered in some way. I will demonstrate that. And in fact, the argument that has been raised about the carcinogens today was never ever raised before the Standing Advisory Committee. I'll demonstrate before lordship.
So now if it is raised, will it be put back to the Standing Advisory Committee and that was taken and then
Your
taken it
lordship
forward?
will only examine whether it has been raised or whether it is raised for the first time.
Correct. Now,
If it
see-
is raised for the first time, my lord, then the writ petition does not lie.
No, that's not the problem. See, even if it is raised for the first time, the issue is carcinoma being transmitted
that
by
not I
good
demonstrate.
batching oils.
No, that-
The court
it's
is
a-
only
it's a-
interested or
it's a-
concerned about the
it's a-
public health.
It's a
public
completely hollow
interest.
allegation, my lord, I'll demonstrate.
That's all. Whether it is raised there or raised, now it is raised before me.
True.
So
I'll demonstrate.
cannot
Yes,
say hands off to
I'll
that
demonstrate.
end. That's all.
So lordship will notice that the statutory mandate is to bear in mind the person who is producing.
Correct.
Now, please have a look at the constitution, because I have to go by the Standing Advisory Committee.
No problem.
If I do not follow the recommendations, then there is scope for judicial review. So long as the Standing Advisory Committee makes a recommendation and I follow it and I am satisfied, my satisfaction is demonstrated, then my lord, there is no scope for judicial review. Now, if I may read section 4, it says Constitution of the Standing Advisory Committee. The central government shall, with a view to determining the commodity or class of commodity or percentage thereof, in respect of which the jute packaging material shall be used in their packing, constitute a Standing Advisory Committee consisting of such persons as have, in the opinion of the government, necessary expertise to give advice in the matter. Now, my lord, later I will be demonstrating before your lordship that the Standing Advisory Committee is really broad-based, in the sense there have been representatives from every department, every ministry, which is material. Lord, are your lordships with me? Lord, I am reading subsection.
Yes, don't worry. Yes.
Subsection 2. This is very critical.
Yes.
The Standing Advisory Committee shall, after considering the following matters, Lord, I'll emphasize on what needs to be considered, indicate its recommendation to the central government. A, the existing level of usage of jute material, because just to know what is the demand supply. B,
Kindly excuse me for 5 minutes.
Huh?
Can I be excused for 5 minutes?
I thought you wanted to say something.
Not an ASD saying.
Yes, yes. Yeah.
A lot to say, but after the finishes.
so when even before I say what it
No,
is,
lot-
if
lot
somebody
to say,
says a
but
lot
what
to
not
say,
to say.
which means it is predetermined.
No, that's why I said lot to say, but what not to say.
Lord, clause B,
Yes.
the quantity of raw jute available. C, I'm sorry, the quantity of raw jute available. C, quantity of jute material available. Lord, all will relevant, because based on that, therefore. D, protection of the interest of person engaged in the jute industry.
Correct.
And in the production of raw jute. This is commensurate with
The act.
what I read out in section 3
Yes. Yes.
and the object of the act.
Object
E,
of the act.
the need for continued maintenance of jute industry. They may also decide to phase it out. F, the quantity of commodities which in its opinion is likely to be required for packing in the jute material, and such the matter as the Standing Advisory Committee may think fit. So lordship will notice that conspicuously absent is the challenges faced by the usage industry. Now, obviously, when there is a compulsion, when there is a promotion, there is some inconvenience caused to somebody. One analogy that I can think of is the MSP, which is a price which is fixed by the government. It is inconvenient to certain persons.
But
it
that
has
is
to be
price
followed.
fixation. Now, the inconvenience that is projected is concerning the health of
Oh,
the
no, I'll
public.
come to that.
That's the only concern.
I'll come to that. I'll come to that. I'm going to address that.
Yes.
The lordship will, I'm making a responsible statement. That is the crux of the issue. I'm going to address it.
Yes,
I'm going to address it. But at this point in time, I'm trying to help the court understand what is the object and what are the material to be considered by the Standing
SAC.
Advisory Committee.
The
Standing,
SAC should consider these things. Standing Advisory Committee.
Yes.
Fine. Object of the act, there
Yes.
can be no qualm
Yes.
about both the things.
yes.
And judicial review over the advisory committee's recommendations, whether considered perspective. Yes, it is
No, but
definitely, this court would be loath
yes.
to interfere, true.
Two
But
things, my lord,
this is
will
the only
emerge
thing.
at this point in time. Number one, there was a challenge to the constitutional validity before the Honorable Supreme Court, and the Honorable Supreme Court made certain observations which would be relevant.
Yes.
Number two, at the heart of the dispute also what lies is the recommendations made by standing advisory committee, which is not under challenge before your lordship. Now, I have simply followed the recommendation made by the hero here is the standing advisory committee. I do not do. It is the standing advisory committee, which is broad-based, which gives an opportunity of being heard to various industries. It is the standing advisory's thinking which is necessary. I just follow. But
to you, the hero, our anti-hero.
no, fine. But then they have decided not to challenge the recommendations made by the standing advisory committee. For me, the basis of my decision is the recommendation made by the standing advisory committee. If they were agreed, they would have challenged it. Now, today I heard my learned friend say standing advisory committee has not applied its mind. It has only cyclostyle, but their decision is not under challenge before your lordship. And my notification forms the basis in section 3 read with section 4.
Notification is under challenge.
Notification alone is under challenge. But for me, there is a basis. Lordship will notice that I, as central government, I do not conduct the kind of hearing that they do. I do not take stock of what is the position of the jute production. I do not take stock of what are the issues that are concerning the issue.
So they have not challenged the raw material, but the product.
Yes, which was very, I would say, not my respectful submission at the very premise that was necessary. Not having challenged the recommendation made by the
SAC.
they cannot now punch holes in the recommendation.
Notification.
In the, and the note and the consequential notification. Now, my lord, very quickly, my lord, the certain observations made which are relevant in the Apex Court's judgment. My lord, may I pass on a couple of authorities which I would like to place reliance upon.
Yes. Oh, you produced everything.
Yes.
31st, 32nd, ella ide.
Yes, because some documents were not produced by the petitioner, so we have produced it.
What is the order of the NGT here?
There is some relevance, but I'll come to it.
Yes. Yes, sir.
At the appropriate point of time, I will refer
No,
your
no
lordship.
problem. You go in your own place,
Now I'm on the fundamental premise.
Yes,
So that was the Dalmia judgment, my lord. It's a bench of 3 honorable judges. In that, where I would like to read is para 2, my lord, at page number, my ink page is 31. Para 2, somewhere about 8th or 9th line, beginning with the words, the restriction. The restriction by way of compulsory packaging of their finished products with gunny bag is an unreasonable restriction. Further, it is not in the interest of general consumer public. The word general qualifies the whole public. In other words, the restriction must be in the interest of the entire general public, namely the consumer of diverse goods. It must not merely be a small section of the public, namely the producer of jute. The restriction must also be for the advancement or to the benefit of the society as a whole. Packaging with jute bag made compulsory irrespective of cost, suitability, availability, consumers' non-preference, all these arguments which are now raised, and hosts of other relevant factor is arbitrary. Executive priority or preference to the jute sector at the cost of and in total disregard of the interest of other sector like cement, sugar, alternative industry or general public would be unreasonable, arbitrary, and a total prohibition. Just for your lordship to know what was the case before the Honorable Supreme Court. Para 23, a couple of lines would be of relevance at page 40.
Yes, sir.
From this perspective, let us consider the constitutionality of the provisions of the Act. The statement of objection. Page number 11. I'm sorry, sir. Para 23. Okay. The statement of objects and reasons, the preamble of the Act would unmistakable terms indicate that it intends to provide livelihood to nearly 4 million rural agricultural families and 2.5 industrial workers. Ancient agro-based jute industry occupied a significant position in our national economy, in particular in the economy of the northeastern region of the country. It is an agro-based, labor-intensive industry. It is also an export-oriented one, and its raw material is based entirely on indigenous jute produced by the above agricultural families. Parliament avowedly intended to protect the interest of the persons involved in the jute industry, therefore requires protection. Then para 26 on the next page. Subsection 1 of section 3 with a non-obstante clause excludes the operation of any other law for the time being in force and regulates use of jute or other jute packaging material in supply and distribution of certain commodities. It gives power to the central government on being satisfied on consideration of the recommendations made to it by the SAC, empowered to issue directions from time to time for use of the packing material. The primary purpose and object of such direction is to protect the interest of the producer of the raw jute and jute packaging material. The central government is enjoined to protect the interest of the persons engaged in the production thereof. Such orders should be published in the official gazette. The order needs to be based from time to time. The rest of it I can skip. Para 30, my lord, a couple of lines at the bottom.
Yes.
The question therefore is whether the directions issued by the central government for compulsory packaging of the commodities with jute packaging with respect to sugar 100% use, at that time it was 100%, is unconstitutional. And then, my lord, the next page, 3 lines above para 32. They are referring to the parliament. They are the best judges to direct the central government to act on their advice in a particular way based on the existing factual material. Parliament is empowered to overrule the order of the central government under subsection 3(1) by disapproval. It is a question of fact to be considered in each case as to what percentage is required to be used. It is primarily for the central government to decide as executive policy. The central government is guided by the material placed before it and advised tendered to it by the SAC constituted under section 4. It depends upon availability of the jute and its products in the market, quantum of the raw jute produced by the agriculturalists, its demand in the market and its capability for diversification into other industries for ancillary use of the jute material, and host of other factors enter into the decision making process. The exercise is required to be undertaken from time to time. The act, rules and the material placed before it by the committee and the advice tendered by the expert body form the basis. The decision taken and the direction issued cannot be said to smack of arbitrariness. The guidelines are available under the act and the rules made in this behalf. They are parliamentary control. Paramount public interest is to provide economic security and equality and justice to the producer of raw jute and the workers engaged in the manufacturing of jute material. And then
47, 48 is the answer.
Yes, and 44, a couple of lines.
All right.
Page 48. In municipal corporation versus so and so, a constitution bench of this court held that normally the legislature is the best judge of what is good for the community, but the court should not shirk its duty to determine the validity of the law. In determining the reasonableness of the restriction imposed by the law under 19(6), the court cannot proceed on a general notion of what is reasonable in abstract or even on a consideration of what is reasonable from the view of the person or person on whom the restriction are imposed. The court has to consider whether the restrictions are reasonable in the interest of general public. The question of the interest of the general public is of wide import, comprehending public order, economic welfare of the public security, morals, and the objects mentioned in the directive principle. The test of reasonableness has to be viewed in the context of the issues which face the legislature. In constructing such law and judging their validity, courts must approach the problem from the point of view of furthering the social interest, which is the purpose of the legislation to promote. They are not in the matters functioning to vacuo, but as part of the society which is trying to be, by the enacted law, to solve the problems and further the moral and material progress of the community as a whole. And then number 47. The next question is whether the prohibition of 100% use of gunny bag by sugar industries.
This is what will become applicable to this case also.
And 70% by the cement industry is reasonable. It is true that the committee constituted by the government had recommended to phase out use of gunny bag on the ground that in a free market economy now sought to be introduced, the restriction is not justified primarily to encourage free market. It is seen that the state has not abandoned and cannot abandon the mixed economy and power of regulation as mandated by the constitution policy. Parliament and executive are bound by the constitution. The act was made in implementation of socio-economic equality and policies. Even a private industry by operation of the directive principles contained in part 4 is bound to adopt them, implement them, and the government policies to establish an egalitarian social order. The committee in its free market frenzy became oblivious of the policy resolutions of the 8th five-year plan, the Trinity, the preamble, the fundamental rights and directives. The executive policy of the state should be cognizant to these mandates, which should always bind the government and all agencies, including private agencies. As seen, the advisory committee constituted under section 4 has recommended 100% usage of packing the sugar with gunny bags. On consideration of the report, the government had acted upon the same. The economic policy to tender socio-economic justice to the growers of raw jute and the workmen is based on the above constitution policy, lest the report of the committee on the basis of a free market economy would be in negation of the preamble, the directive principles and the fundamental rights to economic justice to the agriculture. So the contention is clearly unsustainable. The SSC therefore had properly advised, and the government obviously has taken decision to continue the policy of compulsory packaging of the commodities or class of commodities with jute bags regulated under section 3 of the Act. Parliament did not negate the same. The further contention that on account of the regulation,
that is 1906.
yes, Mr. The SDP industry has become unviable and is on the brink of liquidation, and the Act tends to create monopoly in favor of the private industry, which does not get protection under 1906 is untenable. This court declines to examine the relative economic viability of the respective industry. It would be for the central government and the parliament, and not for this court, to take into consideration the declaration of the Act as void. The court has to see whether the Act serves the public purpose and restrictions are reasonable. SSC goes into the factual detail. The government examines and takes the policy decision. It lays the order on the table of both houses. The parliament controls the exercise of the power and other executive policy. Restrictions are inbuilt. So these are some of the objects of the Act. So therefore it promotes socio-economic justice. Of course it does cause some inconvenience and challenge to somebody, but then there is a larger cause which we need to promote. The health hazard, I am addressing that issue. My next submission would be that there are certain built-in safeguards in section 3 and 4 to protect an arbitrary exercise of the power. Now, what are those? Number one, the government, if your lordship will now take the Act, the government orders must be based on the SSC recommendation.
Yes.
But I cannot say I'm the central government.
No, there is no doubt it is based upon that.
Yes. So therefore, I cannot arbitrarily decide on something. There is a broad-based body. It's an expert body. Later, I'll show to your lordship the composition of that. Then number two, the SSC is comprised of diverse experts as well as stakeholders. The stakeholders are given an opportunity. For example, the textiles industries, the sugar industry, the food grain industry. These are all
they have vented out their grievances.
Yes. And third, my lord, which is of paramount importance, that after the SSC recommends, we issue an order, we gazette it, it is placed before the parliament. It is placed before both houses of the parliament. So it attains a legislative character. It is not just some secretary sits there and decides. Please see the amount of the checks and balances that are involved here. If the parliament comes to a conclusion that the government should not have recommended 20%, then the parliament, both houses of the parliament would have raised an objection.
Is it parliament or the cabinet?
No, it is parliament. It is the parliament. Yes, both houses of the parliament.
Yes.
Place. Anyway, it doesn't matter. I'll let him complete it.
It's not placed in this case.
I have not concluded.
Accept. Parliament, no problem. No, I wanted clarification.
Subsection 2 of section 3. And my lord, the Supreme Court judgment refers to it. Supreme Court judgment refers, my lord, it refers to it. My lord, the petitioners cannot be accepted saying that that exercise was not done. I mean, if it is not done, then it is a ground for challenge. They have not raised it. I mean, they should place material
of the SSC recommendation.
Yes, yes. Allah, that the fact that it was not placed before the
Parliament didn't have section person in an
subsection 2
of 3.
It says, from the benefit of Mr. Holda, may I read, my lord. Every order made under subsection 1 shall be laid as soon as may be after it is made before each house of the parliament, while it is in session for a period of 30 days, which may be comprised in one session or in two or more successive sessions.
Yes.
And if before the expiry of the session, immediately following the session or the successive aforesaid, both houses agree in making any modification in the order, or both houses agree that the order should not be made, the order shall thereafter have effect only in such modified form or be of no effect as the case may be. However, that any such modification element shall be without prejudice to the validity of anything previously done under that order. So if the parliament felt that 20% was not right, the parliament would have recommend or advised any modification in that. That is not the case here. So therefore, my lord, these structural safeguards ensures that there is no arbitrary exercise in recommending 20% or in notifying that 20% is necessary. My lord, now next to show to your lordship what were the issues raised before the SSC in its meeting. And whatever decision may take your lordship to those two. I think I have produced it in my compilation as well. Antunana?
31st and 32nd meeting.
Yes, 31st and 32nd. Lord, okay, 31st is at page number 2.
Yes.
I'm sorry, the minutes begin at page number 3.
Yes.
But before that, my lord, the very first consideration is by the representation of the petitioner organization.
Yes,
Page
that's
number
what-
3. It says the representative from the Indian Sugar Mill Association ISMA and the National Federation of Cooperative Sugar Factories submitted the following. Large gaps in the jute bag allow leakage of sugar and moisture regain. Hence the possibility of fiber getting mixed in sugar, which affects the quality of the sugar pack. Bad quality of sugar attracts penalties by FSI. Hygroscopic nature of the jute bag deteriorates the sugar from formation of lumps and loss in color, whereas plastic bag absolutely avoids air and moisture. Hence, jute bag is not the best option for packaging of sugar. Packaging of sugar in diversified jute bags does not serve the purpose in total, and this is not accepted by the consumer. Sugar season lasts for 6 months, and sugar produced in those 6 months is sold in next 2 to 12 months, 14 months. Therefore, in monsoon season, jute bags being porous attracts moisture from air, and sugar becomes moist, thereby falling between.
So, where is the objection regarding batching oil?
Tagdela, it was not raised. My fundamental grievance
No,
is that it was
batching
not
oil
raised.
and it causing
It was not raised.
carcinoma.
There are only 4 more left. Let me read. In the international market, PP, HDP
No, these are all
adopt-
commercial
these are all
considerations.
So first 6 are about the porous nature. I'll address that, and the rest are all about commercial. So therefore, my lord, my first major submission would be that the issue of this batching oil was never ever raised. And the request, the petitioner's request regarding export was considered. Now, my lord, would your lordship now please have a look at the exemptions given, page number 8. Page number 8. Kindly see the consideration of the request made. The following may be kept out of the purview of reservation under the JPM Act. Packaging for export of commodities, because they requested that the export market is not accepting. We did not want them to lose out on the business.
So it was exempted.
It was exempted. And then please see the other ones. Sugar fortified with vitamins, small consumer packs of 10 kg and below for food grains and 25 kg below for sugar. Bulk packaging of more than 100 kgs, because the gunny bag is not of that size.
Yes.
Sugar packed for export which could not be exported on the basis of an assessment and recommended by the so-and-so. The meeting concluded with the vote of thanks. And then also, my lord, the one paragraph above that, beginning with the words, the caption, food grains and sugar.
Yes.
Where the below 11, after taking into consideration so-and-so, so-and-so,
Yes.
100% of food grains and 20% of the sugar production may be reserved. Then B, provision of indenting 10% so-and-so. Then C, further, in case of any shortage or disruption in supply of jute packaging material,
Yes.
or in case of any other contingency or exigency, the Ministry of Textiles may, in consultation with other ministries concerned, allow further dilution of the packaging material up to a maximum of 30% of the total procurement of jute bags by the SPAs and FCI in the whole jute year.
There is one at clause 4, representative government of Punjab at page 4.
Yes. Yes, ma'am.
To say she also emphasized on the use of non-flammable jute batch oils in the manufacturing of jute bags.
Yes.
And requested for an SOP for complaint lodging mechanism. But this carcinoma was never said anywhere.
It was never said. But anyway, I'm going to address that. My lord, for me, it's a big issue. I'm going to address it.
Yes.
So therefore, and similarly, my lord, if your lordships looks at the next meeting, similar issues were raised. The issue of the batching oil being carcinogenic in nature and the content becoming a health hazard was never used in any of these meetings.
Yes.
Therefore, my lord, now, my lord, before your lordship, there were about 5 grounds which were raised to question this. Although in the grounds of the writ petition, there are some 14, 15. Majorly, my lord, from what I've heard from both my learned friends, the first contention was that there is non-conformity with the SAC recommendation. Now that my learned friend Mr. Holla, to urge this point, he referred to the 30th meeting. Now my impugned order, which is based on the 31st meeting, not on the 30th meeting.
Not even the 32nd, it's only 31st.
The 32nd was during the pendency of
This petition.
So
yes.
the impugned order was based on 31st. So therefore there is complete conformity with the SAC recommendation. So therefore that ground does not hold good.
All right.
The second ground was that there is usage of batching oil and which is carcinogenic in nature. My lord, jute is a natural product.
Yes.
It is from I understand it is from a plant. When it is soaked in water and then dried, it becomes very hard. To soften it, they use batching oil.
Yes.
My lord, there are other means of softening avenues available. We can also use vegetable oil.
Yes.
Which is slightly expensive than batching oil. So number one, there is an alternative option also. If the consumer, if he insists, he can insist on the manufacturer not to use batching oil, but to use other vegetable oil to soften it. So that is available. Number two, the batching oil, if used in a extent of not more than 3%, does not pose any health hazard. The Ministry of Environment and
you have not imposed it should be this much.
I have. On the other hand, the Ministry of Environment has imposed a restriction not to exceed 3%. I have produced
so up to 3%, it is no problem.
It is no problem. I have produced a copy of that notification. It is in the convenience volume at page number 91.
You are e-kotidda?
Illa, whatever filed by the petitioners.
91.
Page number 1991. It's a notification dated 4th of October
1996.
If I may read, my lord. In exercise of the decision recorded in paragraph 5 of the resolution of the Government of India in the Ministry of Environment and Forest published in GSR number so and so, the central government hereby notifies the following criteria for labeling textiles as environmental friendly products. General,
Yes.
And then item number 2 is jute and jute products at page number 91. Here, if your lordships will see item number 3 on the next page, non-halogenated hydrocarbons, which is jute patching, right? It is 3%. Sir, Nimma volume only 91.
Page 92.
Convenience volume.
Okay. Nimma,
92.
in your convenience volume,
portion of the Gazette.
90, 91, 92. Otherly, item number 3, that is hydrocarbon.
Non-halogenated hydrocarbons.
So this is jute batching oil. This. So the law imposes a restriction that up to 3% it is environmental friendly.
No, now the jute does not soften with 3%.
No, but if it exceeds, there are authorities to review that. There is serious punishment for that. Please have a look at page number 95. Page 95. The Jute Commissioner, in order to enforce this law, the Jute Commissioner has issued a notification, page 95, on 28th August 2001. Whereas the Government of India, Ministry of Environment and Forest.
Next parallel is there. I further direct no person shall manufacture and hold stock of
Howd,
jute
howd,
goods,
howd.
packaging purposes more than 3%
Yes.
non-halogenated jute.
So this is issued by the Jute Commissioner, whom I am representing. We have issued this. And it is not a case of the petitioner that there is a violation of this notification.
Yes.
So therefore, my lord, the bags comply with this rule and they are environmentally friendly bags. So there is nothing that causes to the content.
Then
my lord,
you-
the case.
Are you suggesting the grievance to be commercial?
Lord, I'm addressing that. The petitioner's case is built on a research paper by a foreigner. And that foreigner, what he did was he took some mice, he painted them with batching oil. Adu satthoytu. I think he died.
More than 3%.
He painted it, the mice with the batching oil.
Yes.
So therefore they died. And the petitioners have not produced any material either before your lordship or before the right authority, which is the SAC, that there is a violation of your Jute Commissioner's notification. This is the report of an authority in India that.
Foreigner andre ಈಗ?
I'm sorry?
Some foreign.
No, I'm saying they should have approached some Indian authority which is legally admissible material. There are so many authorities in India which can conduct. I mean, there are so many labs, there are so many authorities they could have approached. They have not done any of this exercise. As on today, they do not have any material that people are dying or facing a health hazard because of the bag. But then there is a small irony here, Lordship will notice, that there is no health hazard because of the jute bag. But what is contained inside, 1.6 million people are dying every year because of the content.
You stole my tag. Exactly what I wanted to say. It's not that the jute bag is creating the problem.
True.
Sugar inside has created a lot of problem.
World Health Organization has issued a report in 2022 recording that 1.6 million people die every year.
No, true. That WHO itself has said that it is slow poison.
So, Lord, when we were young, we had read this adage that people in glass houses should not throw stones. But here is an industry which has made almost half the country diabetic, and 26% of the population is suffering from diabetes, and lakhs people are dying every year. And that industry is coming with your Lordship and raising an issue of health hazard.
Correct, but
there cannot be a greater irony than this.
But consumption of sugar has never come down.
So, therefore, my lord, I would seriously knock off this argument of the petitioners that it is causing a health hazard. And on this, I will summarize my submission. Number one, the batching oil argument has to fall to the ground because of the two notifications. Number two, they have not produced an iota of evidence to show that it was possible to send a gunny bag to a lab to check what is the content there. They have not done the exercise.
No, if they had raised that objection, perhaps you would have done that exercise.
We would have considered. In fact, the MOEF issued because of some people raised the issue that batching oil is kind. So therefore, the MOEF rose to the occasion and laid down the law. Because that was issued in 1996. Prior to that, there was no law. Probably that is when they started using the batching oil. Perhaps that is what I understand. So
no, 1997 began then.
Yes,
batching oil began then.
So the batching oil is a hollow argument, and that cannot be considered. Then, my lord, as far as the porosity is concerned, we have a response to that as well.
So they have asked for a lining inside.
Yes, we have the BIS. BIS has, in fact, I have produced a copy of that. It was not produced by in the volume. It was not produced in the volume.
So the perforations are blocked.
Yes, the perforations are blocked. So it costs a little more, maybe a few paise more per bag, but then a facility is available. I have produced it in my statement of objection. If your lordships will kindly, statement of objection. I had requested to put it. My lord, in my statement of objection, straight away, lordship will head to page 54, annexure R5, where the Bureau of Indian Standards and the part that are produced is exclusively for jute bags for packaging. And page number 56, number 1, scope. This standard prescribes constructional details and other requirements of 3 types of jute bags for packaging 50 kg sugar. And page 57,
yes,
type C bag. My lord, kindly ignore type A, type B. Type C bag. It says at the bottom of the 405, it says plus 32 liner. This is a plastic liner.
Where is it? I'm not getting it.
Page 57.
I'm at 57.
Then in page 57.
Yes. Type C.
Type C.
Yes.
Type C. Otherly, maybe about 6th line. Plus 32% liner.
Yes.
There is a small note at the bottom, if I may read. The bags, item number 2 there. Average moisture regain shall be maximum 22%. However, 10% of the individual value of the moisture regain percent may be about 22% with an upper limit of 26%. So if this is done, it sufficiently prevents the moisture absorption. And my lord, so therefore the porosity is also taken care of. And my lord, considering that the variety of purposes for which the packing is made, all this 20%, 80% they have complete choice. They can use HDP or any carton or any of the bottle or whatever. The 20% melody is going to the PDS, the other distribution center. If somebody had to complain that either it is coming in the lump form or there is loss, it should have been our own Food Corporation of India or the distribution or the recipient. None of them have approached this honorable court. The petitioner has not obtained any affidavit from them. There is absolutely no material. So as on today, these are all arguments in the air. The question is whether is there any material placed before this honorable court? No. The answer is no. And the next argument was that there is shortage. It is not available. My respectful submission is that there is no material evidence produced, and the SAC has already factored into it. And I have in my statement of objection, I have produced. I'm sorry. In the convenience volume. In the convenience volume, if your lordship would now turn to page number 457, it is part of a report. Page 456 rather. Page number 456, the table shows that there is no dearth of domestic supply for the year 23-24.
Anyway, these are policies of the
yes, no, but the
government,
yes,
based upon the mandate of the statute.
Yes, and if there is a real dearth, then I have already read out the provisions of the SSC recommendation that the Ministry of Textiles can exempt them. If they make a representation, sir, jute bags are not available, we are finding it difficult, and if they produce probably necessary proof.
Any representation has come?
No, we have not received any such representation. There is no such representation which has been received.
Yes.
Then, my lord, there is one more argument of violation of 19(1)(g). Lord, we have, if we had said don't sell sugar, it would have been probably. This is a reasonable restriction, particularly to promote, to comply with a statutory mandate.
That's what the apex court in Dalmia Cement.
Yes. And then, my lord,
even the next judgment of state of Kerala.
There are on the judicial review, very quickly.
On state of Kerala, para 34 and 36, particularly at 36. Nimde judgment, ನೀವೇ ಕೊಟ್ಟಿರೋದು ಈಗ.
Yes.
ಅದರಲ್ಲಿ 36.
ನಾನು ಅದನ್ನೇ ಓದೋಣ ಅಂತಿದ್ದೆ. Just very quickly, two paragraphs.
36. 34 and 36 ಅಲ್ಲಿದೆ.
So it's an indication that I need not even open that.
Yes.
So, if your lordships have read I'm sure lordships will have read the other. So if I may summarize my submission, the mandate is to protect the jute industry.
So all this is considered in 2016, the last judgment of yours.
And yes, lordship.
Complete para 20 to 40 then.
So my respectful submission is that the impugned notification which we have issued is valid because we have followed the safeguards, we have followed the recommendation. Our policy is on the basis of an expert body, so there is no scope for interference with that. It is constitutionally permissible, and whatever notification we have issued is in full compliance with the JPM Act. And as far as the arguments of the health hazard as well as the porosity, I've already made submission, and they should have produced at least some material rather than just raising it as a scientific argument. There should have been at least some material. So in the absence of this, the petition does not survive and requires to be dismissed. Yes, sir, you please come here. I'll move. No, you please come here. I'll
Well, there'll be
supplementing.
Yes, supplementing, lordship. On my own iPad now. Well, there are 3 SSCs here: 30th, 31st, and 32nd.
32nd is during the pendency of the petition.
Now, 30th SSC led to a 30th SSC recommended total exemption for sugar.
Sugar, yes.
It was on the basis of that, the cabinet, the government did not accept that recommendation and notified 20% on so sometime in 2023.
Yes.
20%. In spite of that, now the sugar industry does not challenge it. Does not challenge the only occasion when the government went contrary to the SSC's recommendation.
No, one clarification. Now, if you see the convenience compilation, page 377, that is the 30th SEC meeting where sugar was sought to be exempted complete. You said the cabinet took a different view.
Cabinet took a
Where is that?
That is, well, I do not know. We have prepared a short compilation.
All right.
If your lordship kindly takes a look at the compilation, we have given the. Give the other side also, please. Kindly see the 30th SSC is page 16 here.
16.
16. Where the recommendation was sugar.
At page 20.
Page 20. But
yes.
Just two more facts here. Paragraph 10, Roman 3. It was considered that jute is biodegradable and eco-friendly.
Fiber, yes.
But what went against the jute is paragraph 11C. Non-availability of jute bags at that point of time. So the recommendation was exempt fully.
Yes.
Now page 22 is the central government notification. Considering this SSC at page 24, it retains the 20% sugar.
Yes.
Now, my lord, thereafter comes the 31st SSC, where considering the jute being eco-friendly, there is a recommendation.
Yes.
Recommendation of 20%. On the basis of which notification is made, lordship kindly sees page 26 is the page 26 is the SSC's recommendation, and notification is page 35.
Yes, sir.
Now, my lord, what I raise a point. Now, writ code is a court of equity.
Para 11, page 32 is the recommendation on 31st SAC that is implemented in page 35. You find sugar at 20% at page 36.
Now, kindly jump straight away to my compilation to the order passed at page 43.
Yes.
The only time they got an interim order from this honorable court is by kindly see the.
This is set aside.
Set aside. They came and said that the notification, which is at page 30, which is at page 35, is based on 30th SSC. So they rely upon the 30th SSC.
Yes.
And they suppress the 31st SSC and say that the government has made a notification contrary to the SSC. And on that basis, the interim order, as far as this is recorded in the order.
Yes.
Page 43.
Yes.
Now, 32nd SSC, the 31st SSC considers once again the eco-friendly nature of jute products. That is, lordship will be finding that in my compilation at page 32. Jute is biodegradable, Roman 3 on top. Because this issue was raised. This issue was raised indirectly, not by Government of Punjab, page 28, Roman
Correct.
4, because inflammable.
That is answered at paragraph 11, and pursuant to that, notification is issued. In
Which is
page 3 of the notification contains all this, 20%.
Now, my lord,
Interim order was granted. At paragraph 10.5, division bench set it aside. Supreme Court said, you get the matter heard. We are not interfering.
32nd SSC
Yes.
specifically notes that
All these.
No, all these, and also the factor that there is a lot of surplus jute bags. Lordship kindly notes that there's a lot of surplus jute bags available
Yes.
because it is not being able to sold. I mean, the food packaging is not being able to use up the entire quantum of page 81. Page 81 is
Yes.
the 32nd SAC,
Yes.
where what is found is at page 86, paragraph 11.
Yes.
The chair stated that during the last year, at the bottom, the capacity of jute mills has gone
there-
up, but the demand of jute mills from
No, there
government.
was underproduction in one
So
particular year.
so the
Yes.
object of the JPM Act comes in to protect the jute industry. As the learned ASG has already submitted that this issue of batching oil was, I mean, that being carcinogenic was never raised. Now, but what we have done in our affidavit is to give the United Nations a report, their food department, on use of plastic bags. And there is a specific recommendation of the UN government, of the UN, that plastic is the most carcinogenic product possible. So, using plastic,
It overtakes batching oil by
by
large
large.
extent.
So maybe the sugar eaters are better off slightly, but the general public, because of the plastic being non-biodegradable, and will be affected much more. That 6 million also sugar eaters who should not be eating sugar. Though I am very addicted to sugar myself, but they should not be eating sugar. Maybe slightly affected. I mean, there's something. But what about the general public because of the carcinogenic plastic bag? My affidavit in opposition, has relied upon very heavily
Yes.
the UN report, and Lordship, just a few pages from there,
Where is that?
my affidavit in opposition of the statement of objections of the of IJMA, respondent number 3, page.
Could you, madam?
The date is 9 January 2025.
9 January 2025. Ideally.
The written objection, the affidavit.
Additional of 9 January 2025. Have a copy?
Lordship, yes, copy. Do you have? I can give mine. Mine is slightly marked, Lordship.
That's all right. Oh, those days are gone. Can't mark the orders, the judgments and give it all gone. Yes. Today we need that marking in the to save time.
Page, Lordship, the report starts.
You have a
at-
copy with you? Of course, you have electronic copy.
Yes. Page 44 it starts. It is
One
the
sec.
Food and Agriculture Organization.
I get it here. Sorry. Have it, yes. Page 40.
Page, mine. Page 44 is the UN's body where this is where the report starts. Page 44, the United Nations of Food and Agriculture Organization of the United Nations.
No, that's all right. Then why has the Union government, ASG sir? Now.
No, we have also relied upon the.
No. Microplastics, all right, in food commodities, including sugar, it's more carcinogenic. Why have you left 80%?
Not enough capacity. Not enough capacity. Jute industry.
No, if that is the case, why have you left 80% and kept 20%?
That can't be helped because there has to be something else to come in. With jute, you can't substitute because
No, you can't substitute with jute, but why continue with HDP, high density plastic?
They should have paper or some other product, some other packaging.
See, yes.
In fact, UN has recommended that should not be used. So, Lordship, can you see the first page 48? The contamination of the environment with whole plastics or pieces there is the subject, micro and nanoplastics is the subject of extensive discussion nowadays in academia and the media. In addition to environmental matrices, micro and nanoplastics have been detected in fishery products and other important food commodities, with concerns over their impact on human health. Food consumption is considered one of the most significant routes of human exposure to these small.
Yes.
Now, Lordship, kindly come straight away to the packaging, to the, yes, Lordship, page 137.
Recommendation, chapter 14.
Chapter 14.
All right.
The following recommendations are offered as guidance for national, international authorities and food safety. The second bullet point: recognize the impact and impact of packaging and food contact materials on the quality of food products, including their potential impact on
Organoleptic.
Yes.
Organoleptic properties.
Organoleptic properties. Yes.
Impact on the organs.
Page 14.
Yes.
Lordship, page 175. That is the Indian report. Oh, this one. Now, my lord, page 164 is the toxic link report of microplastics. This is the basis of FSSI. FSI has relied on this while publishing its food standards norms. Kindly come to page 175. We have a clear copy if it's not.
No, that's all right. Yes.
Page 175.
Sugar and salt, class H.
Apart from the fruits, vegetables, beverages, and water, microplastics have been also been detected in salt and sugar. Salt is the most widely, well, that's sugar is. And master microplastics in sugar is again 186.
No. 180. Clause
Yes,
2.2.
180.
Yes.
2.2.
Yes.
And page 185 is the last paragraph is the regulation and mitigation strategies. Lordship, kindly, I hope mine is better. I mean, mine is very bad. I hope your Lordship's is better. Otherwise, well, Lordship kindly sees.
No, paper is always better.
The last paragraph in terms of mitigation strategies.
Correct. And there, mitigation methods, several methods have been proposed.
Several methods have been proposed to reduce MP contamination in food production and processing. These include improving wastewater treatment to
I've
prevent.
seen.
Yes. Now, well, one last thing, Lordship, since Lordship has followed, Lordship kindly sees my compilation. In the Calcutta High Court affidavit, some documents were placed where
Yes, correct.
this issue came up. Lordship kindly, there's enough availability of jute packs page.
Affidavit was filed by the wing of the government saying that there was no availability of jute bags.
Yes, Lordship,
before the High Court of Calcutta.
Page 41 in my compilation. They had selected one or two letters from that affidavit. I've got the entire affidavit. Page 41 is part of from the same affidavit, 22nd July 24.
Correct.
The third paragraph. At present, 13 jute mills having BIS license for production of type C in liner bags. That is the thin plastic liner bags which they have been harping upon. And the 30th SSC recommended against using of sugar, exempting sugar because non-availability. There are now 13 jute mills with the BIS licensing to make C-type bags. 500.
Equivalent
Yeah.
18.09 crore.
I've seen.
So, and I've annexed a few more letters which shows a lot of availability of.
Correct. 40, 41, 42.
Lordship had the Gujarat judgment which my learned friend relied upon, that Gujarat State Sugar Federation. Now copy that. Lordship.
Which judgment?
they had relied upon one Gujarat High Court judgment. One copy is that
Which one?
in their compilation now, in their case compilation. Yes. In their case compilation, there is
In the convenience compilation or?
Separate case law. Firstly, I read that also.
Yes. Yes, sir.
this was a case where the
It's here, yeah.
sugar was 100% exemption of sugar. Sorry, 100% packaging.
That's
of
2006.
2006. And SSC had recommended the notification was 100%. SSC's recommendation was 75%. Lordship, kindly see paragraph 13 of this judgment, running page 21. SSC had recommended 75% for sugar. The government went against the SSC's recommendation.
Yes.
Government totally ignored the SSC's recommendation, that is paragraph 32. This will work totally opposite their case, because paragraph 32, because the government did not take note of the SSC's recommendation. And SSC's recommendation is very important. Lordship, paragraph 32 also condemned by council. Now, Lordship, the third, 6th, 8th line, looking to the reasons given by the central government for brushing aside the advice given by the Standing Advisory Committee, namely their commitment to UPA government and jute policy of the year 2005. So that was an extraneous consideration, which is also overlooking.
Yes.
And running page 35, 33 says.
Page 34, para 38.
Yes, ma'am.
Yes.
Because they say they veered out of the JPM Act and for political reasons they done.
The para 38 is what it says.
Well, yes.
Para 38, page 34. That's all?
I don't think I will not travel by lot.
Yes.
I'm very grateful to her.
Yes, sir.
Shall I?
Yes.
My Lord, first of all, my learned friend said, my Lord, UN report says it is carcinogenic. Made a statement. Nothing was shown except, my Lord, microplastic. UN report does not speak of micro, my Lord. It's only, my Lord, it is all microplastic, not, my Lord, in respect of, my Lord, certain, my Lord, plastics have microplastic. The liner, my Lord, which now I ask myself this question. AST said, jute bag ought to have, my Lord, a liner of plastic. Please look at, my Lord, the AST's answer, my Lord, to this is, you must have, one liner, thin liner of plastic.
Correct.
On the one hand, my Lord, my learned friends
Never said it should have.
No, to block the perforations.
No, I said type C, there is a bag called type C which has a liner. I never said it should have.
All right.
Only one thing.
I think we'll not
permit him.
One point I missed out saying that we have the option of making the jute bags without batching oil or with rice bran oil. That is recorded.
It's all right. That would turn out the product to be expensive and the consumer would be hurt by that. Yes. Rice bran oil, yes, also does the same thing. Vegetable oil, yes.
Therefore, my Lord, first submission of my learned friend was come, my Lord, senior counsel was come all the way from Calcutta. It's carcinogenic because that's what UN says. UN doesn't say so. One. So therefore, my Lord, that is to be discounted. Second, my learned friend says 31st SAC was suppressed. No, we have filed it with the Memo, my Lord, on the first day. It is there. From the first day itself, my Lord, it was there. So that is also not correct.
That's a part of the convenience compilation itself.
Convenience compilation, my learned friend said, learned single judge
earlier.
No, it was filed, my Lord, on the very first day. There's nothing, no suppression, my Lord. In fact, my Lord, we have produced everything. Then.
No, the division bench notices that, but sets aside the order on the ground that notification should not have been stayed.
That's all right. That division bench is entitled because,
That's
they
correct.
said.
No, 31st SAC is noticed by the
Correct,
division
correct,
bench.
correct. Because, my lord, we had produced it.
Yeah,
Otherwise, my lord, it wouldn't
that's
have
why I
noted.
said it.
Anyway, then, my lord, so one argument, oh, plastic is bad. Therefore, my lord, liner itself, my lord, he says, my lord, I must use it. If, my lord, liner is not to be used, then what happens to the sugar? I ask myself. My learned friend says it's all given, my lord, in the for, my lord, free what is that?
PDS.
PDS. Please look at, my lord, what Andhra says. What, my lord, please take, my lord, the 31st itself.
Yes.
Report.
No, there all states have objected to.
Correct.
Because of its hygroscopic nature.
That's right. Therefore, to say, my lord, it's going, my lord, for PDS, my lord, it's not. Nowhere does it say that, my lord, it must go for PDS. So, my lord, that argument also, my lord, it goes. Then, all the reports are, my lord, of foreigners. No, we have produced, my lord, an IIT report. Please come to the memo filed on Indian Institute of Toxicology, sorry, on 29th of April, 2025, we had filed that. CSIR, Indian Institute of Toxicology Research.
Huh.
Where is this?
Yes, sir.
Please, my lord, that is, my lord, page 7, your lordship, my lord, will have. That's, my lord, the, my marked copy was there. All right. It's all right.
Dossier.
My lord, dossier on
carcinogenicity.
Correct. Correct. Now, my lord, please come to, my lord, page 11.
You requested for a report.
Yes, ma'am. My lord, ultimately, my lord, I requested because, my lord, it's a government institute, not, my lord, something, my lord, it's a private organization. And batching oil, my lord, can cause contamination, food packaging, soiling the carpet, sustaining so-and-so, oil migrates into so-and-so, impacting. Reducing the oil content to 1% or using refined odorless oil can mitigate the issues. Where is that carcinogenic business?
No, in, sir,
please,
in that report at page 9.
Correct.
JBOP can contain up to 3.3%.
That is, my lord, what my learned friend said.
No, that is the report also.
Correct.
Andre 3% orgu you can use batching oil.
My lord, 3% ಮಾಡ್ತಾ ಇದ್ದಾರೆ because, my lord, there's already an order passed by the government.
Correct.
Saying use only 3%. So, my lord, my mark portion was there. I don't know where it went. My files are all taken in. Where is that? I had my mark portions. That file itself is missing.
This paragraph 5, if you see, Agarwal et al.
Correct.
There again 3.3% by weight. It is not. These findings underscore potential health risks associated with JB, particularly its carcinogenic potential due to presence of these hazardous PAHs.
Therefore, my lord, the statement that only, and please come to, my lord, summary. Last page, that is, my lord, page 12. Jute batching oil is carcinogenic due to its high content of polycyclic aromatic so-and-so. Exposure, my lord, induces benign and malignant skin tumors in animal models, confirming its role in tumor initiator and promoter. Presence of potent carcinogenic PAHs, such as benzopyrene, directly contributes to its carcinogenic effect. Therefore, JBOP poses significant health risks and conclusively classified as carcinogenic. So, my lord, foreign reports only, no Indian.
Why don't you use rice bran oil?
My lord, they'll have to use it, not me. I don't know.
Yes.
I don't know. Then, my lord, second, third, the argument, my lord, third argument is the judicial review. My lord, judicial review is concerned, no difficulty, my lord, it is very restricted. Question is, my lord, three things, my lord, which are posed before your lordship. One is the health hazard. Other is non-availability of, my lord, the jute bags itself. In fact, if your lordship, my lord, remembers, I had pointed out, and there's no answer for this.
Import from Bangladesh.
Not only import from Bangladesh, there is a shortage, my lord, for 24-25. I produced all that. There is no reply, there is no rejoinder. In fact, my lord, the government itself said there is a shortage. My lord, I produced all that. My lord, in my note also, my lord, I have given one note also I had given on the earlier occasion. There's a shortage. That is not considered by, my lord, the commission. The committee, my lord, my learned friend said, the learned additional solicitor general said, recommendation, my lord, of the committee, my lord, is binding on the central government. Central government can't do anything. I asked myself, my learned friend, my lord, my senior counsel, my lord, from Calcutta said,
No, cabinet vetoed that and imposed.
my lord, how I asked myself, if it is binding on the government, so that is not binding on the government. One. Secondly, my submission to your lordship is there must be an application of mine, my lord, on the part of the committee. Did the commission, my lord, committee, my lord, apply their mind? Your lordship saw, my lord, the entire, my lord, proceeding. Everybody objects except, my lord, jute manufacturers. And, my lord, he says, the chairman says, I now recommend so and so. There is total non-application of mind, and therefore, my lord, there is arbitrariness. And my learned friend started saying, oh, there are experts. My submission to your lordship is, please see, my lord, who are they? It is the chairman, my lord, who takes the decisions.
Chair has taken.
Therefore, there is, my lord, total arbitrariness, my lord, on the part of, my lord, the commission. And, my lord, it was brought to their notice that there is, my lord, shortage. Even that is not taken into account. As I pointed out, my lord, on the earlier occasion, the production, my lord, has come down. My learned friend, my lord, pointed out something to say, my lord, production has gone up.
2025, there is surplus stock is what?
No, my lord. That again is, my lord, please take, my lord, what he has pointed out. Please take, my lord, what he has produced. He says, my lord, there is excess. Sorry. 24, 25. Just.
Which page is that?
1 minute, my lord. I'll tell you, lord. He gave me one just now.
Which page was that? Surplus jute stock.
Anyway, my lord, Mr. Dhyan, my lord, will submit that. Where is that? Somebody took it from me. All right. My lord, 27/3/2025, 25th, page 25. Ministry of Textiles says, yeah. What are you saying? 29th of April, my lord, which I pointed out.
Yes.
Review of backlog of jute mills.
Huh.
What do you want to say?
No, he told me about which page?
86 of my compilation.
86.
Paragraph 11.
It's here. Yes. Para 11 of the 32nd SAC.
Not challenged.
32nd SAC says, the chair said during the last year, capacity of jute mills has gone up and demand for jute from the government packaging food grains has gone down. Therefore, demand and supply variation.
My lord, that is July 2024.
July 24.
July 24.
Please
yes.
come to my lord, March 2025.
25.
Yes, memo filed on 29th of April 2025.
Again, there is shortage.
Absolutely. Page 29, page 25. At 29. If your lordships come to 25, this is, my lord, Ministry of Textiles.
25 of what?
Of that memo, my lord, which I pointed out, my lord, dated 29th of April. That's what I was telling my learned friends here. We have filed, my lord, some 10 memos and 10 different districts. Yalla one kade hakbeku. My lord, how will the judge, my lord, be able to look into all this?
Yes.
We must make, my lord, his life as page, my lord, 25, my lord.
This is 27th March 2025.
Correct.
All right.
Please come to, my lord, the backlog. Please look at this. Review of supply of backlog. What is the backlog? Please come to page 27 onwards.
Yes.
27 to 29. There is a tremendous amount of, my lord, backlog. In fact, my lord, per company we have it is pointed out. Who I did not point out. Textile, Ministry of Textiles pointed this out. And none of this is taken into account. But they simply, my lord, keep on, my lord, extending. My lord, when they extend, have they applied their mind? Did they, my lord, sit and do it? Answer is no. On 32nd, my lord, 31st, they recommended 20%.
So this backlog is jute bags only.
Yes. My lord, what, if jute bags are not available, what do we do? And textile, my lord, Ministry of Textile itself says there is, my lord, backlog. And none of this is taken into account. My lord, if your lordship recollects, 32nd was the last meeting.
That
When
is
was that?
11/8/2024.
That's right. Thereafter, there is no meeting at all. Extension, my lord, just like that. Therefore, my lord, there is a need for them to look into all this. None of it is looked into. As I pointed out, every state government has objected to, my lord, jute.
That is there in the
That's
meeting
one.
itself. Yes.
That is also not taken into account, my lord, while they take a decision, judgment takes a decision. Then, my lord, the other, my lord, submission that has been made is, by the learned additional solicitor general, is that
These SAC meetings are held annually. Is it?
supposed to be held, but they are not held. And as far as the health hazard is concerned, first submission of my lord ASG was, whatever recommendation is done, my lord, government has to accept. That, my lord, is found to be, my lord, not correct, because 30th, my lord, when they said 100% exemption, government did not accept it. So, my lord, that contention, my lord, is on the face of it not tenable. Secondly, there has to be application of mine both by, my lord, the SAC as well as, my lord, by the government, would be my submission. Even, my lord, when the government passes an order, there has to be an application of mine, which is not there in this present case. And, my lord, lastly, of course, my learned friend is ready. I don't want to, my lord, delay him.
Yes.
Lastly, my lord, my submission is, Dalmia judgment, my lord, if your lordship sees, please take that. When was that passed? 1996.
Yes, sir.
How many years have passed?
That way.
Which is the one I say? Sorry. 1996, in the 30 years have passed. And what is it that that was recommended? There has to be a periodical reduction. Was there a periodical reduction? Answer is no. After 20%, there is no reduction at all. My submission is, this was, my lord, in those years when, my lord, pastoral, my lord, was, my lord, agriculture, my lord, was at a high level. Today, everything has come down, my lord. Therefore, jute also is coming down. And therefore, my lord, there is shortage. We have produced, my lord, enough material, which is not, my lord, refuted by them.
Jute also is coming down. That is the such.
Therefore, I'll come this way.
One submission which was made, is out of the
Was
many.
made. All right.
You have not challenged the advisory board's recommendations. The decision is challenged. Recommendations need not be challenged.
Decision-making process is not challenged.
No, process is challenged.
No, notification you have challenged.
Once I challenge a notification, not every step that is there to
Towards
reach
the
the notification
notification.
are all under challenge. There's no separate. Otherwise, I'll be in a situation where even without a decision being taken, I can come and challenge the recommendation made by the Standing Advisory Committee. The recommendation of the Standing Advisory Committee under Section 4, in my humble submission, of no consequence until it is acted on by the government by applying mine separately. But every single year, your lordship will see, in every one of those notifications that are issued, they are all of them identical, which shows a gross non-application of mine by the central government. From the ASG's point of view, my lord, it's a little difficult situation for my learned friend. The reason is the Ministry of Textiles has a position, the Ministry of Food has a different position. The Ministry of Food's position is this is not good for sugar. Ministry of Textiles is only looking at
good for jute.
Good for jute. But the such, my lord, is where the consumer suffers. And that, my lord, in my humble submission, is a matter which the Standing Advisory Committee is bound to look at. Because under one of the requirements, the last requirement.
I asked, are they required to meet every year?
Yes, they were not originally in the act. They were not required to meet every year, but after the Gujarat High Court's judgment, in Dalmia after the Supreme Court's judgment, they said you must meet annually because you must determine it per jute year. This is why I started not saying there's no doubt about the fact that you look at it from the point of view of jute. Always you have to look at it from their point of view first. But I don't think the learned ASC will agree when or will disagree with me when I say that the constitution may stand a little higher than the jute manufacturer's protection itself, because ultimately if a person's life is in danger for any reason, that stands higher in pedestal than anyone else.
Why you did not raise those objections before the SSC? None of you have said about it.
It is
Why?
not said. That is
Why?
true. It is
Why?
not there.
Why?
There is one letter which is there, which is from the, your Lordship may see the memo.
No, it is not a part of any of the SSC.
It's not part of this.
But later wisdom has dawned to bring this out. We'll
No,
see.
it is, no, there are two things here.
Mm.
One, Lord, is the 3% issue. Now, the 3% issue is an environmental issue. For it, no, I'm slightly on a different point. The requirement of maximum of 3% comes from the Environment and Forest notification, which provides, and your Lordship may only see that page number at 187 of the convenience compilation, where it says, when will a product be considered environmental friendly? So the labeling of environmental friendliness.
So if it is up to 3%.
Up to 3%.
Then it becomes an environmental hazard.
As it is.
Yes.
But for human consumption, it is not that report which is relevant, but the report, my Lord, of the Indian Institute of Toxicology. And my Lord, there's one more document which I think is also there. In addition to the Indian Institute of Toxicology.
What is the life of this notification now issued? 20%?
They are annually. Every year there is a SSC's recommendation. There was July 24th. There will be one very soon, SSC, and there will be and notifications are normally 3 months extended till the next SSC recommendation.
Now the 2024 is the last one. But my learned friend knows that how many of them have come even before, though the 2024 meeting occurred, the 2023 notification was being extended. And the requirement is ultimately, my Lord, it is in my humble submission quite fundamental that the meeting of the SSC is very important. But it is not just an empty formality to say that I'll meet, take all the statements made by various persons and then reject it at the end, or not even consider it and
That
simply
is,
say
reject, yes, can be.
reject.
But
You can,
consideration.
but you have to consider it. Now, if you don't consider it, and my Lord, please see this. We filed the writ petition. All of this material, my Lord, which we have now placed before my Lord, from the Rangarajan committee report to all the other CACP reports and all the reports were available with the central government now. Since August of last year, they have had it. And despite all of that, in April, my Lord, an identical notification is issued without reference to any of the material. Now, insofar as the committee is concerned, it is not like, my Lord, some kind of a committee which has to wait for information to come to them. They are duty bound to collect information, and we are only providers of information. But if information is otherwise available from the Department of Food itself, can they just ignore it and say, oh, no arguments were made before me, therefore I will not consider them? That obligation, in my respectful submission, is an obligation to the entire country.
We'll see. Yes.
One of the grounds for judicial review of a policy is when there is extraneous material which is considered. So if I, as the government, had considered Rangarajan, it would have been extraneous. I am required to consider only as SSC alone.
Well, only one more thing, Lordship. Since he talked about March, there was a shortage that was considered by Calcutta High Court recently on 8th of May, and Calcutta High Court held that shortage was due to non-placement of orders for 1 month and then sudden bunching effect. Lordship kindly takes a look at this order. I'm giving them both copies, and the government was asked to not, because they had in the process diluted 8th of May. Is it the 8th of May order? Yes.
Have we given the right one to the?
Yes.
Yes, one more copy. Just give them. So because some of our jute bags were then transferred to plastic for that.
All right, I'll look into it. Yes. Whole of afternoon.
Grateful. Yeah, very good.
Yes.
Grateful. Or should we file a short note of submissions? Not required.
After all this.
No, I'm asking you. Only to make a list of documents.
That is better because you have taken me all over.
So, this thing, we'll make not more than 3 pages or 4 pages. More than
Which
that.
has a reference to documents.
I will never do that.
That is correct. Because
As it
there's
is,
so much of material is here.
Because so many memos, at least about, that's what I was telling
A
you.
lot of memos are there.
Other like a lot of documents. Therefore, we'll.
Anyway, flag them, we'll see. It would
also file a short synopsis.
It would be helpful with regard to the documents. Next, the tender. ಇದರಲ್ಲಿ ನೀವೇ ಇರೋದು.
Should we do it another day?
Tomorrow,
Tomorrow or next week?
4:45. Oh,
Tomorrow, man.
tomorrow.
Friday. Monday ಆಗ್ಬೋದಾ?
Tuesday.
Then we will say Wednesday. Nale will let it be listed. We'll see.
Some difficulty tomorrow.
Because in the afternoon I have an election petition. ಅದನ್ನ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹಾಕೋಬೇಕು.
ಅಲ್ಲ ಅದು ಬೆಳಗ್ಗೆನೆ ಹಾಕಿರ್ತೀನಿ. We'll finish it off ಬೇಕಾದ್ರೆ. Tender ಅಂತ ಅಷ್ಟೇ, nothing else, because all the scrutinized tender documents are with me. Because they have placed everything here.
I know.
I directed everything to be placed before me. They have placed it in a sealed cover before me. Adre I'll take it at 12 o'clock ಬೇಕಾದ್ರೆ finished. ಅದ್ರಲ್ಲಿ ಏನಿದೆ? That's all, not much. ಈ ತರ ಜೂಟ್ ಪೇ ಜೂಟ್ ಏನಿಲ್ಲಲ್ಲ.
The problem is, in every case, the jute is on the other side.
No, till now it was central government, now it's come to state government.
Yes.
We are not on the
Government
jute
after government.
ನಾಳೆ
12 o'clock.
ನಾಳೆಗೆ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್ ಈಗಲೇ. BKP ಮೇಡಮ್ ಒಂದು ಆರ್ಡರ್ ಕೊಟ್ರ.
My lords, may I trouble your lordships with respect to the 330 matter that your lordships had put? This was the quashing of the CBI FIR day before.
Whole time. The other matter took away the whole time.
Absolutely. I'm sorry for intervening in the middle. Would your
This
lordships?
is Nimda Steel Hypermart.
That's right.
ನೀವು ಅದರಲ್ಲೇ ಇರೋದಲ್ಲ? Other lot of matters
I
waiting.
understand, my lords.
Tomorrow or Monday?
Could it be Monday, my lords?
Monday, sir. Same time, but Monday.
Very grateful, sir.
Monday, the mining matter is also getting listed.
Monday ಯಾವುದು?
Dharwad mining matter.
7th ಗಾ?
ಹೌದು.
ನೋಡಿ ಮೇಡಮ್, ಅದು ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? 7th ಇದೆಯಾ? ನೋಡೋಣ ಇರ್ಲಿ, that will get over. Because ಅದ್ರಲ್ಲಿ your reply ಅಷ್ಟೇ ಇರೋದು. Yes, Monday ನಿಮ್ಗೆ RCB ಇಲ್ವಾ ಮೇಡಮ್?
ಇಲ್ಲ ಸ್ವಾಮಿ. 8th 9th ಬೇರೆ.
Match ಇಲ್ವಾ?
10th ಇಲ್ಲ, ಮ್ಯಾಚ್ ಇಲ್ಲ.
Yes.
We are free. ಬಟ್ ಇಲ್ಲೇ ಸ್ಟಾಂಪೀಡ್ ಆಗೋಷ್ಟು ಜನ ಹೊರಗಡೆ ಇಲ್ಲಿ ನಿಂತಿರ್ತೀವಿ.
Yes. Mahesh Chaudhary is there? You tell him.
This side.
Even if it is 5:15, I will dictate and go.
Much okay.
You just ask him to come. Yes. ಅಲ್ಲ ಇದು 230 ಮೋಡ್ ಬಂದಿಲ್ವಾ? ಅದು ತಗೊಂಬಿಡಿ ಫಸ್ಟ್. DSJ ಸರ್, ನೀವು ಯಾವ್ದಕ್ಕೆ ರೇರ್ ಡಿಸೀಸ್ ಕಾಯ್ತಾ ಇದ್ದೀರಾ? I'll take it. Madam is here. Jaina madam is there ಅಲ್ಲ? Wait, I'll just finish this sentence.
1978 was, my lord, the preliminary notification. 82 was the final notification, my lord. 83 was the award. But even thereafter, no position was taken, and until today, my lord, I continue to be in the possession of the property, my lord. Larger survey number, my lord. Large portion of the property, my lord. RMV second stage was, my lord. Possession was taken over. Only with respect to, my lord, a smaller portion, my lord, because we were living there, the possession was not taken, my lord. Till today, it continues the same. I have produced the photographs. I have produced, my lord, the proof of my residence there constantly. It's one portion is, my lord, about 6,000 square feet, and another portion is, my lord, 3,000 square feet, which was skipped from being taken, my lord, taken over by way of, my lord, BDA possession for 30 long years. Now, my lord, somebody goes and, my lord, finds out that there is some unallotted area. And, my lord, somebody who is long-handed, my lord, goes and
long-handed
ಸ್ವಲ್ಪ ಈ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಉದ್ದದ ಕೈ ಇರ್ತಾರಲ್ಲ ಅವರು, high-handed and long-handed.
Long ಗೊತ್ತಿರಲಿಲ್ಲ.
Somebody say, my lord, I have a very long hands here. That's the reason. So, my lord, some long hand penetrates And my lord finds out.
Seriously, what is all this?
My
Long
lord
hand, okay, adella yake.
And finds out, my lord, there is some unallotted area as per the records of BDA, which is, my lord, in fact correct. As per the records of BDA, acquisition, my lord, award.
All right, you're challenging a notification 1978 and 1982.
I'm not per se challenging.
Per se andreno.
My lord, I am only, my lord, saying, now in the meanwhile, my lord, we have also made applications that since this has not been taken over, regularize it in our favor that we'll pay the allotment cost. Don't disturb our position. This is all, my lord, we are asking. Let our applications be considered, my lord. Until then, my lord, we can't be dispossessed.
230 ಗೆ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ?
ನಿನ್ನೆ ಎಲ್ಲ ಬಂದು measurements ಮಾಡಿ dispossess ಮಾಡ್ಲಿಕ್ಕೆ. My lord, your lordship.
Measurement ಮಾಡಿದ ತಕ್ಷಣ dispossess. You have long hands.
I don't have, my lord. My only approach, my lord, my travel ends before this honorable court. My lord, my application, I have also said, my lord, I was the erstwhile owner of the property.
50 years ಆದ್ಮೇಲೆ I will not permit challenge of anything.
My lord, I am not challenging, my lord. I am only seeking the allotment in my favor because it was never allotted.
That we will see.
Yes, my lord. That's all, my lord. In the meanwhile, my lord, I should not be dispossessed.
RMV second stage ಅಲ್ಲಿ ಏನಿದು? ಎಷ್ಟಿದು?
One is Bhoop Sandra, my lord. It's called RMV second stage, my lord. It's not as good as Sadashiv Nagar and actual RMV.
It is in Bangalore ತಾನೆ?
It is Bangalore, my lord, but my lord, I would.
Sandra ಅಂತ ಇದೆ ಅಂದ ತಕ್ಷಣ ಬೇರೆ ಎಲ್ಲ ಬೆಂಗಳೂರು ಅದನ್ನ. Yes.
If your lordship sees, my lord, the electricity bills and my lord, the pictures I have produced, my lord, we are all living.
For what purpose?
We are living.
Possession antana.
We have been in my lord, I was the erstwhile owner. From us, my lord, it was taken over. I have not even claimed compensation for this because, my lord, Mr. Jayendra, who was the erstwhile owner of the property, my lord, my ancestor, he never claimed compensation. And my lord, we were let to continue in so far as the places portions we were, my lord, staying. Rest of the portions were taken over by the BDA. We are good with that.
It is 1970.
I understand that, my lord. We are not challenging the notification at all, my lord. We are only.
You also understand that no interim order can be granted.
No, my lord, only dispossession, my lord. That's it. Your lordship could kindly see the photographs, my lord.
ಯಾರ ಪ್ರಾಪರ್ಟಿ?
ನಿನ್ನೆ photographs ನಾವೇ ಇರೋದಲ್ಲ.
ಅಲ್ಲ ನೀವೇ ನಿನ್ನೆದು ಗೊತ್ತಾಯ್ತು, ಬಟ್ ಅದ್ ಯಾರು?
This schedule, my lords, may kindly say, subject to, my lord, the correctness of these pictures, my lord. If these pictures, my lord, are not of this property, my lord, I lose it. My lord, I can't mislead. I can't misrepresent to the honorable court. My lord, till.
Allah, picture may be worth 1,000 words, but not 1,000 acquisitions.
I understand that, my lord. I understand. But, my lord, what would happen is, I was the erstwhile owner and, my lord, possession was not taken.
What were you doing for 50 long years?
We have been constantly making
owner and notifications. These notifications are not cannot be said that it comes to your knowledge now.
No, my lord, we are, my lord, all the other properties, my own property, which was taken over by BDA,
Anyway,
my lord, has been developed.
Without hearing the BDA, I will not.
I understand. Till then, my lord, not to dispossess, my lord. No coercive action, my lord, if I am not dispossessed yet. That's all, my lord, I need. My lords, may kindly have it, my lord, in a day or two, my lord, if I am unable to show that I am still in position, my lord, I lose it.
Oh, this is abuse.
All that I am saying, you let me continue because I was residing there. My house was there, except my house, all the other property you have taken over. You have allotted also.
43 ವರ್ಷ ಆಗಿದೆ.
ಹೌದು, 43 ವರ್ಷದಿಂದ ನಾವು ಅಲ್ಲೇ ಇದ್ದೀವಿ. 43 ವರ್ಷದಿಂದ ನಾವು ಕಾನ್ಸ್ಟೆಂಟ್ we have been living there.
We'll see. ನೀವು ಅಲ್ಲೇ ಇರಕ್ಕೆ ಸಾಧ್ಯವೇ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ, electricity bill ಇದೆ, my lord, pictures are there.
Electricity bill?
ಹೌದು, if your lordship sees, my lord, I am paying electricity bill every month.
Voter ID ಇಲ್ವಾ? ಆಧಾರ್ ಕಾರ್ಡ್ ಇಲ್ವಾ?
ಇದೆ,
ಎಲ್ಲ ಸಿಗುತ್ತೆ.
ಎಲ್ಲ ಇದೆ.
ಅಲ್ಲ ಎಲ್ಲ ಸಿಗುತ್ತೆ.
ಎಲ್ಲ ಇದೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಇಲ್ಲ ಯಾವುದು ಮ್ಯಾನುಫ್ಯಾಕ್ಚರ್ ಮಾಡಿಲ್ಲ. ಅಲ್ಲ, at least electricity bill we can't manufacture. I am paying electricity bill every month. ಅಲ್ಲ, unless I consume, my lord, being in the property, I can't, my lord, pay electricity bill.
Bill date 2007 ಅಂತಿದೆ.
ಇಲ್ಲ, if your lordship sees, my lord, page number 82, my lord.
I am there.
24 ಇದೆ,
82 to 88 ಎಲ್ಲ 29/1/2007.
ಅವೆಲ್ಲ ಇದೆ ಹಳೇದು, my lord.
ಮತ್ತೆ ಹಳೇದು ಹಾಕ್ಬಿಟ್ಟು ಹೊಸದ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Hurry of, my lord, approaching the honorable court.
ಮತ್ತೆ ಹೊಸದಂತೂ
ಇಲ್ವಾ? We will
ಇಲ್ವಾ?
certainly place all the documents.
Bill ಹೊಸದಂತೂ ಇಲ್ವಾ?
ಇಲ್ಲ, we will certainly place the bundle of documents to show, my lord, we are constantly in
Kannada?
possession.
ಅಲ್ಲ, ಅದೇನೋ ಬಂಡಲ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
Bundle of, ಇಲ್ಲ English.
ಕನ್ನಡನ ಇಂಗ್ಲಿಷ್?
English bundle, my lord, English bundle, not, my lord, Kannada bundle. ಕಲೋಕ್ಯ.
ಯಾಕಂದ್ರೆ 50 ವರ್ಷ ಆದ್ಮೇಲೆ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕನ್ನಡನೇ ಇರಲ್ಲ, ಅಪ್ಲೈ ಆಗೋದು, ಇಂಗ್ಲಿಷ್ ಅಲ್ಲ.
We bow down to your lordship, my lord.
Yes. You serve on the BDA.
We serve on the BDM.
ಇವ್ರಿಗಾರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಸ್ಫೂರ್ತಿ?
ನನಗೂ ಕಾಪಿ ಇಲ್ಲ.
ನೋಡಿ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ. 2:30 ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಯಾರಿಗೂ ಕಾಪಿ ಕೊಡಲ್ಲ.
ಸರ್ಕಾರದಲ್ಲಿ ಕೆಳಗಡೆ ಅಲ್ಲಿ ಸರ್ ಇವ್ರಿಗೆ ಕೋರ್ಟ್ ನಲ್ಲಿ ಇರೋರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ.
No, we don't know. We'll take it on Monday.
Till then, my lord, if I am not already dispossessed, my lord, all that, my lord, yesterday they come, my lord, especially these, my lord, the big people who are able to, my lord, find out this kind of unallotted areas are quite powerful, my lord. They are quite powerful in terms of everything. My lord, if they come and suddenly take over, and my lord, there'll certainly be an allotment. My lord, I'll be left remediless. Lord, civil court can't protect me because, my lord, it is an acquisition.
No,
proceeding.
acquisition is not maintainable before
Yes.
civil court. Yes. List the matter on heard the learned senior counsel M.S. Shamsundar appearing for the petitioner. The arguments advanced in support of an interim prayer, though are so bleak, notwithstanding the said bleakness, if the petitioner has not been dispossessed as on this moment or the dispossessed, if the acquisition has not been taken to its logical conclusion qua the property of the petitioner, property said to be in the possession of the petitioner as on today, she shall not be dispossessed.
Greatly obliged, greatly.
She shall not be dispossessed if not already dispossessed.
Greatly obliged.
Till the next date of hearing, Tuesday, preliminary hearing.
Yes, it also served.
Tuesday, Wednesday.
R2, my lord, R2 and 3, my lord, BDA, my lord.
Adhe BDA, Ajay Kumar, one nimisha. Learned counsel Ajay Kumar is directed to accept notice for respondent 2 and 3, petitioner to serve set of papers upon the counsel forthwith. This Wednesday.
This is a defendant's writ against refusal for permission to lead additional evidence. In a suit for partition, my lords, the defendant sets up a
At
will.
what stage did you seek?
Please, my lords, the order sheet is at page 19.
ನೀವು ಹೇಳಿ sir, order sheet.
My lords, immediately after DW1's evidence, I file an application to summon the attesting witness to the will. The court accepts and allows my application, issues summons, records satisfaction of service of summons, issues warrant. Warrant is returned unexecuted as door closed. Immediately on the same day, the Honorable Trial Court closes the stage for further evidence, posts the matter for arguments. On the date of arguments, which is the
Petitioner is before this court calling in question an order dated 26/6/2025. In ಎಷ್ಟು ವರ್ಷ ನಡೆಸ್ತೀರಾ ಈ ಸೂಟ್ನ? 2025 in OS 419 of 2008 for partition. The learned counsel for the petitioner submits that the attesting witness to the will was summoned to be examined. Summons were served but did not appear. Warrant is issued and the warrant is returned on the score that the door is closed. Therefore, the evidence is closed. In that light, the further proceedings before the concerned court shall remain stayed. The petitioner shall serve on the counsel who represents plaintiff 1 to 4 before the concerned court and file an acknowledgement of such service by the 8th of July 2025. List the matter on 15th, further 15th in preliminary hearing. Extension of parole.
Appearing for the petitioner, my lords.
Who has granted?
My lords, the medical
ಎಷ್ಟು
report.
ಸರ್ತಿ ಆಗಿದೆ ಸರ್?
Medical report is at page 12.
Medical report ಬಿಡಿ, ಯಾವ medical report?
Medical report as issued by the Manipal hospitals.
For what?
Advising further treatment.
What further treatment?
I am suffering from stage 5 chronic kidney disease.
CKD,
Chronic kidney disease.
CKD,
my lords. And my kidneys have already suffered permanent damage.
But
My
how long can
parole
you
was
be-
actually
what is the offense?
Offense is 138, my lords.
138.
Yes, my lords.
ಎಲ್ಲ 138 ಇಲ್ಲೇ ಮುಗಿಸ್ಬಿಡ್ತೀರಾ, ಆಚೆ ಏನಾಗದೇ ಇಲ್ಲ.
I have already suffered 6 months imprisonment. Subsequently,
3 months, 20 days.
Okay.
ಆಯ್ತು, ಡಯಾಲಿಸಿಸ್ ಅಲ್ಲಿ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
ಇಲ್ಲ ಆಗಲ್ಲ.
ಏನು ಅಂಡರ್ಗೋಯಿಂಗ್ ಪೆರಿಟೋನಿಯಲ್ ಡಯಾಲಿಸಿಸ್, ಹಿಮೋಡಯಾಲಿಸಿಸ್?
I'm now advised high dose immunosuppressive therapy.
ಅದೇ ಅಲ್ಲ, ಹಿಮೋಡಯಾಲಿಸಿಸ್ ಪೆರಿಟೋನಿಯಲ್ ಡಯಾಲಿಸಿಸ್ ಕೇಳಿ.
I have to ask.
I don't know. Yes. ಆಯ್ತು, another 60 days. ಅಲ್ಲೇ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಬಿಡಿ ಸೆಂಟೆನ್ಸ್. ಪೆರೋಲ್ ಅಲ್ಲೇ ಸೆಂಟೆನ್ಸ್ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ.
Sorry, my lords. Yes. Obliged.
प्रसन्न कुमार, तीसरी अंक.
But today I had some inconvenience in the afternoon, therefore yes.
But I've secured the instructions, my lords. There is difficulty in extending for the reasons which are mentioned. They were discharged on 19th. They were taken up for 2 follow-ups. Now we are on 3rd. It's cataract surgery. But
ಅದೇ ಹೇಳಿದ್ದು 1 eye
Lordship, I am not
30
into
days,
that.
second eye 30 days. ತೀಸರಿ ಅಂಕ್ ಎಲ್ಲಿದೆ ಮತ್ತೆ
12
ಕೊಡಕ್ಕೆ?
days follow-up is also
I
over.
already, I requested this honorable court for what reasons, para number 7 and 8.
ಅವ್ರು ಹೇಳಿದ್ರೆ ದಿಲ್ಕಾ ಮಾಮ್ಲಾ ಅಂತಾರೆ.
ನಾನು ಹೇಳಿದೆ ಡರ್ಕಾ ಮಾಮ್ಲಾ ಅಂತ.
ಗರ್ಕಾ ಮಾಮ್ಲಾ ಆಯ್ತು.
My humble submission, Lordship, I leave it on this honorable court to consider for any period, Lordship.
But there is one objection I would like to bring to this honorable court. The petitioner, my lords, blows hot and cold based on the circumstances. He was the one who showed us the way when he came before this honorable court for bail. When this honorable court rejected the bail application, filed a review petition saying no,
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಾಗಿ.
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅಂತ. ಈಗ ಬಂದು now I am not on merit, I am on mercy. Therefore 21 is not applicable ಅಂತ ಇದೆ.
My
He
learned
wants
friend,
to urge for medical bail. Let him urge in the trial court. My lords, this is not the way. They can't expose a different person's fundamental rights before this court. But surgery is over. Follow-up is also over.
Follow-up to follow-up is not over.
Follow-up to follow-up. My lords, cannot be stretched to the brink point of elasticity.
Elasticity. Then we will try to stretch it.
ಅಲ್ಲಿ ಆ breaking point. No, last time when your
Again
lordship was
10 days ಬೇಕಾ? 30 days ಕೊಡ. 20th.
Lordship, I'll have
20th
to
2 weeks ಅಲ್ಲ. 17th.
Lords, I'll have to, your lordship may kindly have it tomorrow at least. I'll secure an instruction.
He
But
said
my-
okay na? NIA ಅಲ್ವಾ ಇದು?
KGLE, DJLE.
ಅಲ್ಲ ಬಟ್ NIA ಅದಲ್ಲ.
NIA is
ಅಲ್ಲ
not, the
offenses
UAPA is there.
UAPA ಇದೆ.
UAP is.
Oh, he is there. Oh.
We are regular enemies
ಇದಕ್ಕಾದ್ರೂ 10
inside
days
and regular
ಕೊಡ್ಬೇಕಲ್ಲ.
friends outside.
Tell your senior ಇದಕ್ಕೆ 10 days ಸಿಗ್ಬೇಕು ಅಂತ. ಓ 15 days ಕೊಟ್ಬೇಡ ಬಿಡಿ.
Yes, let's kindly have it tomorrow.
All right. ಯಾವತ್ತು ಎಂಡ್ ಆಗ್ತಿರೋದು ಯಾವತ್ತು?
Lordship, have it
Tomorrow.
please.
Don't worry, your colleague is there. ಅವ್ರು ನಿಮ್ ತರಾನೇ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ ಅವರು. ಅಲ್ಲ ಅವರು ನಿಮ್ ತರಾನೇ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ, ತೊಂದ್ರೆ ಇಲ್ಲ. Yes. Next this Praveen Kumar, huh? Tomorrow it will come. ಏನಿದು? ಟೆನೆಂಟಾ? ಏನಾಗಿದೆ ಎಕ್ಸಿಕ್ಯೂಷನ್? ಏನಾಗಿದೆ ಎಕ್ಸಿಕ್ಯೂಷನ್? In the execution, ex parte decree. Why you did not appear? Made me as a party? What do you mean? Yes. Who is the tenant? Who is the Shama Rao then? Only first floor was sought, is it there? ಈಗ ನಿಮ್ನ ಎವಿಕ್ಷನ್ ಕೇಳಿದಾರ? ಫ್ಲೋರ್ ಒಂದೊಂದು ಫ್ಲೋರ್ಗೆ ಒಂದೊಂದು ಸೂಟ ಅಲ್ಲ, ಈಚ್ ಫ್ಲೋರ್ ಎ ಸೆಪರೇಟ್ ಸೂಟ್. ಕರೆಕ್ಟ್. The petitioner is before this court calling in question an order dated 13/6/2025 which rejects the application of the petitioner seeking to enter into the execution proceedings as an objector, as he is now sought to be evicted without making him a party in the in OS so and so. OS ಏನದು? OS allowed ಮತ್ತೆ ಮಾಡಿ. Why did you get into those proceedings? No problem. ಇದು 230 ಯಾಕೆ? ಅಲ್ಲ, ಅರ್ಜೆನ್ಸಿ 230 ಯಾಕೆ? Matter for what? All right, list the matter on Monday. The concerned court shall not insist on compliance of the order on the next date. Yes. No. Yes. ಅಷ್ಟೇ ಸಾಕು. ಅದು ನೀವು ಏನು ಅಂತಾನೆ ಹೇಳ್ತಾ ಇಲ್ಲ. No, you please come on Monday. Yes. ಇದು ಈಗ ಆಯ್ತಲ್ಲ ಇದು ಮತ್ತೆ ಇನ್ನೊಂದೇನು? Prop care. By this. Oh.
Now, the DRT, the registrar of the DRT, stated a close of petition on the basis of the circular issued by the Central Government in 4/9/2022, which will have several high courts have stated that the amount.
ಅದೇ beyond 1 crore. 100 crore, sorry. ಇಲ್ಲಿ ಎಷ್ಟಿದೆ?
243 crore.
ಅಬ್ಬಾ.
243 now, because of her proceeding clause, the Central Government circular is stayed by several high courts.
I have stayed. I have myself stayed.
Now, this order of
Where is the order of the DRT? ಈಗೇನ್ GMCPC ನ ಇದು? GMCPC ಯಾಕೆ? ಹಾ.
Yesterday, the DRT officer rejected my petition before the DRT. Now, the commercial code does not take up my application. Notice, but application for temporary change is not tested even till today. Both the IS number 4 and IS number 7, IS number 5 are posted for arguments and being urgent. And only stage for this season. That before the DRT will not be challenge the order of the rejection. Not may have regard to the earlier order set back the matter.
Yes, that is jurisdiction is not mine.
The matter before DRT is interpreted again. Still then, that the interim order were also granted was because till the interim order was granted by the matter.
Why did I grant the interim order? Because of the circular of the government of India?
So I'm totally remedial because I cannot go to my shut the door yesterday. And the commercial code does not take up my number 4 for granted rejection. Therefore, my limited prayer is later the commercial code decide my application. Still then they cannot proceed with the proceedings or sale of the property.
This Chitra Nirmala madam was here. She's here.
In the meanwhile, the lordship say this order of the registrar challenge.
Register, how can I in GMCPC state? That is before the other court. No, before the other court, the court has already sent you back. Where is the question of staying it again now? The other court. ಈಗ ಅಲ್ಲಿ interim order ಇದ್ದಾಗ what was the proceeding going on here before the commercial court? Nothing was happening.
So we moved the matter to the commercial court again, and again we are being urgent. Page number 56 and 59. 56 and 59. Again the matter was listed on 1/7/2025, page 59. Trace back to here on item 4 or temporary item number 5 objection of the claim. That if I am rejects application for rejection of the claim is allowed to have separated. The problem is I am completely remedialist.
Heard the learned senior counsel S. Basavaraj, appearing for the petitioner. The petitioner challenging the proceedings instituted by the respondent Indian Bank invoking the provisions of the SURFACE Act was before this court in writ petition 9197 of 2025. The writ petition is disposed by the coordinate bench directing the petitioners to approach the DRT. The petitioners appear before the DRT only to be told that a circular, only to be shown a circular of the Government of India transmitting all the cases before the DRT to the DRT Chennai, Chennai as the TRT Chennai, as by then the pecuniary jurisdiction of the DRT had changed, as any amount, any loan, any borrow amount beyond 100 crores were to be placed before the DRT Chennai. On that circular, the proceedings are turned down. Therefore, the interim order that was subsisting at the time when the writ petition was pending and its continuance is of no avail now. The learned senior counsel further submits that the commercial court has now kept the proceedings for what purpose, he said? The learned senior counsel submits that the application is pending before the concerned court on filed under Order 39 Rule 1 and 2 seeking temporary injunction which is yet to be considered and only notice is issued. ಇದು ಯಾವುದೋ ನಾನೇ ಮುಂಚೆ ಮಾಡ್ದಂಗೆ ಇದೆಯಲ್ಲ ಯಾವುದು? Yes, so and so. In the light of the said submissions till the next date of hearing, i.e. Wednesday, the concerned court shall defer its proceedings. The commercial lawyer shall defer its proceedings. Surface idರಲ್ಲಿ ಹೆಂಗ್ ಕೊಡಕ್ಕೆ? That is why I am not able to grant. Surface ಇಲ್ಲಿ not to proceed ಅಂತ ಇದ್ರಲ್ಲಿ ಹೆಂಗ್ ಕೊಡಕ್ಕಾಗತ್ತೆ? Defendant is before me, but your injunction ಏನ್ ಕೇಳಿದ್ದೀರಾ? That is not even maintainable before the commercial lawyers. The respondents are restrained from precipitating the matter qua the amount, qua the borrowing, qua the loan amount till the next date of hearing. That should suffice. Wednesday preliminary hearing. You serve on Chitra Nirmala. She was here. No, ಇನ್ನೊಂದಿದೆ ಸ್ಟೀಲ್ ಹೈಪರ್ ಮಾರ್ಟ್ ಅರ್ಜನ್ ಆಯ್ತು. Yes. The learned counsel Srimati Chitra Nirmala is directed to accept notice for the respondent Indian Bank. Petitioner to serve set of papers upon the counsel forthwith. Wednesday. Yes. ಏನ್ ಮಾಡಬಹುದು? ಒಂದು ಅಲ್ಲ. Further hearing call out ಮಾಡಿ. We'll see. Have you informed Mahesh?
He's yours.
Yes. 90 second. Wait. I'll finish this. List copy. What, you're ready with all the books at 5:15? Mate?
That's just.
We'll repeat. Yen madadu? I know, I don't want to reserve it. I'll do it. There's some reserve matters. I'll finish them and then pile them up. Yes. It will be in the list.
Any date minutes?
Tuesday in the continue agat ಮತ್ತೆ.
Except 10th any day.
Don't worry. From Tuesday it will be in the list. Whenever you want, you come. Yes.
Not like that. Whenever the matter is there.
Interim order. We'll continue. Yes, next.
My lord, appearing for the respondent slum dwellers, my lord. I have filed my synopsis, my lord, in this.
Idu that Devasthanad Pakka.
Allah. This is Bangalore, my lord. In fact, this petition, my lord, at para 9 of the writ petition, they admit that the land that they are claiming is theirs is already acquired by the BDA. And a slum has been declared on that land. They came here first time.
That we'll try on Tuesday or Wednesday.
Please, my lord, in this, my lord, what's happened is by virtue of this, the order of the appellate authority, they went before the appellate authority, their appeal has been dismissed. My lord, the houses have to be constructed for the slum dwellers on this place, my lord. That's held up at this
No,
point.
it's, you do one thing, on Tuesday or Wednesday, when it is listed, you make a mention at 3:30. We'll take this and, because of slum dwellers, we'll close it.
Grateful, my lord.
Yes.
Most grateful.
ಏನ್ ಅಮೌಂಟ್ ಎಲ್ಲ ಬಂತಾ? Yes, Sanita madam.
We have given to all the petitioner as.
All
93 orderal ಬರೋರಿಗೆ.
handful.
Get it
Last time ಹೇಳಿದ್ನಲ್ಲ, ಅದೇನು ಕೊಟ್ಟಿಲ್ಲ ಕೆಲವರಿಗೆ ಅಂತ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ.
ಎಲ್ಲರಿಗೂ ಆಗಿದೆ.
ಈಗ ಎಲ್ಲರಿಗೂ ಆಗಿದ್ಯಾ?
93 orderal ಬರುವಂತ ಎಲ್ಲಾ petitionerಗೂ we have dispersed the loan amount.
All 93 have got the amount now.
Handful are yet to receive, my lords.
How many handful under 10?
About 4 and 5 petitioners.
No, my lords.
That's due to some banking issues, they yet to, they have not received it.
ಅಂದ್ರೆ ಅವ್ರು
In few
ಕೊಟ್ಟಿದ್ದಾರೆ.
days time, they'll receive it, my lords.
No, my lords. All are.
ಅಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Because of their banking issues, they have not received, they'll receive it.
Just 3 of them were deceased. We cannot give to that.
Why?
ಅಲ್ಲ ಅವರು 3 ಜನ ತೀರ್ ಹೋಗಿರೋದ್ರಿಂದ ಕೊಟ್ಟಿಲ್ಲ.
ತೀರ್ಕೊಂಡ್ರದಿಂದ ಕೂಡ ಅವರ ಬಿಸ್ನೆಸ್ ಏನ್ ಮಾಡ್ತೀರ? ಬಿಸ್ನೆಸ್ ಕೊಡ್ತಾನೆ ತಾನೆ ಇದು. ಆಯ್ತು, ಹೋಲ್ಡ್ ದಟ್, ವಿಲ್ ಸಿ. Then we'll.
ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕಿದೀನಿ. ಅದರಲ್ಲಿ ಯಾವ ಇಸ್ವಿನಲ್ಲಿ ಯಾವ ಪ್ರಾಜೆಕ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ, ಇವನ್ NKD.
ಆಯ್ತು, ಇದನ್ನ ಒಂದ್ಸರಿ ತಗೊಂಡ್ ವಿಲ್ ಫಿನಿಶ್ ಇಟ್ whenever is possible. Yes. ಎಲ್ಲ ಶಾರ್ಟೆಡ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ರಿಪೀಟ್ ಆಗುತ್ತೆ. Let it be repeating, we'll see. Yes. The Learned Council, ನೀವು ಬೋರ್ಡ್ಗಲ್ಲ ಮೇಡಮ್?
Please, my lords.
Learned Council of Safai Karmachari. Learned Council, Srimati Anita, representing the board, would submit that in terms of the orders passed earlier, all the amount, the orders passed earlier, the amount to all the 93 persons have been dispersed. And in terms of 93 sanction orders, the amounts have been dispersed except to 3. Correct, except to 3, is it?
Because they were not.
Except to 3. The Learned Council appearing for the petitioners would accept the same. However, the Learned Council Vaibhav would submit that handful of them have not received due to banking constraints, not on the part of the board, but on the part of those petitioners, and would resolve the issue by the next date of hearing. List this matters week after next shuru martini. Tuesday, next, we'll list it on 15th now. 15th. Interim orders wherever subsisting would continue till the next date of hearing.
Gratefully, lordships.
Yes.
Obliged.
28. For the petitioner.
28.1 I apply for the petition.
406, 420.
406?
420.
ಅಷ್ಟೇನಾ, ಎರಡೇನಾ?
There is an agreement, my lords.
Breach of agreement and substandard.
Then the agreement, they agreed to supply biodegradable bags making mission.
ಅದು ಇದು.
Yes.
Partly supplied, my lords. It's not that.
Partly supplied, collected full amount, and he has not returned the
No, I
amount, as
returned
well
the
as he
part
has
amount.
not done the 1 crore 26 lakhs they have collected, entire amount. They supplied missionaries worth of 25,000 by raising invoice of 50 lakhs, sorry, for 25 lakhs by raising
Clearly
invoice of
covered by
50
Lalit
lakhs.
Chaturvedi judgment,
per
my
rest.
lords, and the judgment of this, your lordship and Lalit Chaturvedi judgment, my lords. There is an agreement.
Not only to this person, there are various complaints which came to be filed before the respondent number 1 police station.
They
They
are
are
not
giving
made
a
a
endorsement
company
by
as a party.
stating there are 2 FIRs came to be registered, and in those 2 FIRs stay is granted by Honorable High Court. As such, we cannot take your complaint until disposal of those 2 criminal petitions. Based on the outcome of that, we are going to take your statement. There are so many
ಇಷ್ಟೇ
people.
ಇರ್ಬೇಕಾದ್ರೆ ಅವ್ರು ತಗೊಳಕ್ ಆಗಲ್ಲ ಸರ್.
ಅಲ್ಲ, ಬೇರೆ ಕೇಸಸ್ ಕೊಡೋದಕ್ಕೆ, FIR ಕೊಡೋದಕ್ಕೆ.
ಅದು ಬೇರೆಯವ್ರು ನೋಡ್ಕೊಂತಾರೆ.
ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೊಟ್ರೆ ಅವ್ರಿಗೆ ಆತರ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. The persons who have been
15th.
duped by them.
Week commencing from 15th.
Please. Interim order. Interim order.
Interim order.
All the petitions, 28.
All the ಎಷ್ಟಿದೆ?
ಎರಡು,
ನಮ್ಮ ಮತ್ತೆ ಹೇಳದ್ ನೋಡಿದ್ರೆ ಪೇಜ್ ಪೂರ್ತಿ ಇದೆ. Yes.
Please.
This case, my lord, we have tried for settlement.
ಆಗ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, ಆಗ್ಲಿಲ್ಲ.
3,80,00,000.
ಅಲ್ಲ, 3,34 ಲಕ್ಷ ಸ್ವಾಮಿ.
ಸೆಟಲ್ಮೆಂಟ್ ಎಷ್ಟು ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
They themselves are offering us 1 CR. Up to 70 lakhs they are offering. Yesterday night also we spent time hours together in their office only.
Ashtak. So
Try to negotiate ಅಷ್ಟೇ.
yesterday night we spent time, yes.
Night.
ನೀವೇ ಹೇಳಿದ್ದು.
ಆಯ್ತು. Night from 7 to 10. I'll stand corrected. I'll stand corrected.
Evening ಅಂತ ಹೇಳಿ.
Evening. My lord, this matter has been sufficiently heard by this honorable court.
Again,
It may be posted for.
Just because I've shown some indulgence, don't think I will not
No, my lord, yesterday we had
dismiss
a
the petitions.
discussion with the petition, respondents also, my lord.
No more
Next,
further.
be posted, my lord. Meanwhile,
I'll
if
post
that-
it, I'll post it on Friday next. ಈಗ ಆಗಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ, it may posted for reserved for
No,
judgment.
sir, ಅದು ಮಾಡಲ್ಲ. I will do it when I want. Yes, I'll post it on Friday next. ಒಂದು ವಾರ ಇದೆ. Day time ಅಲ್ಲಿ ಮಾಡಿ. ಎಲ್ಲ day. Hold discussions in the daytime.
Much obliged.
Perhaps we may settle.
Date may.
It's 11th. Yes.
Much obliged.
Interim order may be extended.
Intermodal country.
Appear for the respondent. We have not filed our objections and we have taken a conscious decision to not file it and I.
Conscious
We have
decision.
taken a conscious decision.
Yes, and we intend.
File.
Now,
Yes.
today.
Never heard that
No, no,
from
one
the
minute.
union.
Now
I will demonstrate. Very well.
Today I have read the papers. Who are the patients you are wanting to get the medicine? List of patients and have those patients approach the central government, which is that.
Yes.
The
Clinical-
COE, the Center for Excellence.
Center for
There has
Excellence.
not been a shred of.
Where is that
statement made
material?
by them stating that
Because
they have.
I see why Srinivas Raghavan sir is wanting to come in, because your pleading is entirely on patent.
Exactly.
And
this
not,
is-
One minute, why
madam,
is my friend?
your pleading is entirely on patent, not on patient.
No, no,
So
it is.
you should tell me who are the patients who want medicine and not dealing with patent here. If you want patent to be decided, he should come in.
The reason I'm the
Yes.
petitioners are the patients.
Where?
The three of them. The petitioners are there.
Where did they go before the government of India seeking that medicine?
They have.
It has not been
made-
stated in the petition.
No.
wait,
Let my
tell me.
friend, either he should file his response if my friend is for the
Consciously they have
union.
said they will not. do.
Then if they've consciously decided not to file a response, can they say, I won't file a
No,
response,
the
but I'll
plead-
give my
Madam,
response in
pleading
oral?
should be about patients and
Yes.
not patents.
Patience itself is my pleading. My lords, I want to make one submission. Under the national policy for rare
No,
diseases.
Absolutely no problem. You give me the list of patients
No,
that are there.
even in the national rare disease policy, the maximum is 50 lakhs.
Have
No
they availed
problem.
that 50 lakhs
Money-
or not is also
Madam,
under control.
I will straight away tell them
No,
to
50
release
lakhs
the
is
funds that are there
No, yours.
in that center if you had gone there.
No,
And it
I
would
have-
be released in a period of
I-
15
I'm-
days.
I
Yes,
don't
15
understand
days,
this.
he's saying.
No, I don't understand 1 minute, my lords. I don't understand this style where the minute I say one line, my learned friend starts butting in the middle. Either he argues or I argue. He started saying that I am taking a conscious decision not to
Anuj,
reply.
you sit. Yes.
I'm the petitioner. If he's not filing his
No,
reply.
now you answer the query of the court.
I want, yes.
Yes. Now, why have these petitioners not approached the, what is that center, Anuj?
Center for Excellence.
Center for Excellence seeking treatment. Why have you not done? The moment you go, he is undertaking that he will release in 15 days.
The reason, I'll tell my lord.
Yes, you want medicine, right?
I want medicine.
Correct. You
Now,
want medicine,
I
you will
want
get
medicine.
medicine.
Now, the reason we have made representations to the central government, those representations are on file. The reason we haven't, the reason
Oh,
we
don't
haven't.
get into, he's just stood up. Yes.
Exactly, let him sit down, let him, what is his
Don't
worry?
worry, you carry on. Yes.
The reason we have not sought for the 50 lakh medicines is that my annual medicine cost is more than 2 crores.
They will grant.
The National Rare Disease Policy
Madam,
regulation.
why don't you go before them? I have 15 days, in 15 days, if they don't release that amount for the payment.
I will show it
as
to my
payment.
lords. I will show it to my lords. My lords, kindly see page
No, no,
142.
I only want a straight answer.
Yes.
Why are you fighting? Why are the patients fighting shy to appear before the Center of Excellence
No,
or
we
whatever
are
of the
not
government of
fighting-
India?
We are
Why?
not fighting shy.
Why?
What we are not fighting shy, the
Yes.
reason is that the maximum limit even under the national rare disease policy is 50 lakhs.
It's all right. We will direct.
No, that 50 lakhs, with great respect, just to answer, because my lords asked me the question, why are you not going here? Why are you seeking compulsory licensing of patents? My lords asked me that question. Are you interested in patents or are you interested in your
Correct.
treatment?
That's the pleading.
Yes.
That's the problem.
And I want to answer that. The reason I'm seeking for the government to exercise its powers under section 92 and 100, either for government use or compulsory licensing, is that only if the government takes these steps to make the medicines available, I will be able to get the medicines for my treatment. Under the rare disease.
You want
policy,
medicines, madam?
I want medicines.
All right.
Now, under the rare, may I just
1 minute,
show
ma'am.
one?
You
one
want
document?
medicines
Yes.
for the treatment of these 3 petitioners.
For these 3 petitions.
Correct.
May I just show one, apologies, just one document. At page 142, the difficulty is, there is an office after the rare disease policy was issued. At page 142, there is an
There is
office.
financial support up to 50 lakhs.
Yes. Initially, it was about 20 lakhs.
All right.
That they increased it to 50 lakhs. Now, that is the maximum. Now, beyond this, even if I approach, they cannot give me more. This will not survive even for 1/4 of a year. Therefore, and in fact,
one
there-
moment.
yes.
Yes.
Let them first utilize the 50 lakhs. Now they spoke about a representation that they've sent to the government concerned.
Now,
Kindly-
we will direct these 3 patients to come to the Center of Excellence.
Yes.
All right.
Very
Now,
well.
what is the immediate treatment that is required to these 3 people? You have to immediately disburse that amount.
That will be dispersed, and that's the center of
No,
excellence.
if the cap is 50 lakhs and the treatment would require more than 50 lakhs, then what is the solution?
So that in that situation, there was a writ petition that was filed before the Delhi High Court in a similar
Correct.
situation.
In Delhi High Court judgment, there are 250 people who are listed
Exactly.
as
They have given
patients
their
who are
exact
wanting.
details.
That is
So
what I
these
am asking.
petitioners
Where
have
are the
not even
details
given
of the
their details.
patients? Only 3?
Yes,
Only 3. Restrict to 3.
Very well. So let them approach the center of excellence firstly and state their grievance and produce the report as to what it is that they've exactly.
And what is the disease that you are, a rare disease, and
Cystic
you are telling
fibrosis.
about?
Cystic fibrosis. No,
All
no,
right.
this is a specific disease. In fact, my lords, the Delhi judgment,
Yes.
the Delhi judgment.
Delhi
has
judgment
bar-
says the government of India should not restrict itself to 50 lakhs. If it goes beyond that,
No,
it
the
should
Delhi-
give.
And that has been
Correct.
stayed, just to
With
butt in.
respect, the Delhi judgment, in fact, asked for a fund to be made
Correct.
of about 900 crores.
Correct.
And a fund to be made for all rare diseases. That judgment, in fact, has been stayed by the Honorable
Supreme
Supreme
Court,
Court
yes.
with certain directions to disperse some
In
payments.
accordance with the policy.
In accordance with
Yes,
the
yes.
policy. But the other entire judgment to make the fund has been stayed. Now, my submission, my lords, we are seeking for these 3 patients. If my learned friend says, we are 50 lakhs is a drop in the ocean. Now, after 50 lakhs, now my learned friend says, let us first you prove
No,
it.
no, no.
do
Drop
all
in the
this."
ocean is not what he said. You should first appear before them. 50 lakhs will be dispersed all to these 3 patients individually immediately.
Let them give it on affidavit.
Yes.
Let them give it on
It's
affidavit.
in the
Why
policy.
affidavit? I will direct now.
Let them give it on
Hey,
affidavit.
why are you worried about affidavit?
undertaking.
I am passing an order on a statement that it will be released immediate within 15 days. If you appear before them, show what is the report. And
Fibrosis,
no,
yes.
what is the report?
That is if they do fall under the classification of what is
That's what-
under the rare disease
Fibrosis
policy.
is under the rare disease.
It
Now,
is.
even cystic fibrosis, there are about 2 types of cystic
Correct.
fibrosis.
They will provide the report that they have with them for you to release it. If it is in the policy or whatever, you release it. Otherwise, we will post it after 15, 16 days and we'll pass orders.
Very well.
Yes. Now, I would request another consideration. Yes, if my lords passed, it's not as if we don't want even 50 lakhs. That's not the point. The only reason we are seeking the prayers is that 50 lakhs may survive for maybe 3-4 months. Fine. If they are saying we will give it and my lords pass that order, yes, we'll take it. Thereafter, we'll report it. Ultimately, what is my permanent solution?
That we will get. First, you begin to take medicine,
Yes.
then we will
My lords may
think
record.
about some solution later.
Yes, my lords may record it that in 15 days upon us going and showing them the
Yes, that he is
our
saying.
reports.
We will, but then I would just like to show the prayers of the petitioners and the representation that they've made. If the court may kindly turn
Now,
to page
Anuj,
223.
1 minute. Now, the government of India should come forward with this policy of 50 lakhs
Yes.
to treat the patients
Yes.
of if the disease that is there is enlisted in the rare
The
disease.
policy.
That is what the learned senior counsel is saying. Now they will come before you.
Yes.
Produce the reports.
Yes.
Whatever is necessary now, we do it. We'll consider the prayers later, implementation of policy
That is
and
the
other
primary
things.
point. The prayers are in the nature of a public interest litigation. Please
No,
see the
prayers are,
representation.
prayers are manifold. We can send it to the PIL bench also.
Yes.
It's not the thing. But in the meantime, these three patients should not suffer, so they'll appear before
So
you.
they can do that. There
Yes.
is not a shred of pleading, stating any grievance about those particular three petitioners.
No, that's what I said.
Everything is about
Petition-
nowhere. There is just three paragraphs stating that these three patients do suffer from cystic
what else
fibrosis.
can I
That is all. There is no report produced by them. There is no attempt
It is
made
a
by them to
patient
go to the Center for
privacy. I don't
Excellence.
want to produce, it is
No,
patient.
produce it
them,
before
of
the
course.
Center of Excellence.
That of course I'll produce.
Yes.
I've not produced it in the court. That's why I've even not produced their names. The names are in a sealed cover. The names are in a sealed cover because I don't want patient privacy.
No problem.
Of
So,
course, we will produce our
yes,
reports.
you
There is
produce,
no
you
difficulty.
produce it before the Center of
What
Excellence.
difficulty?
The center will then analyze it, list it, unlisted things. They will immediately within 15 days of your appearance,
Let them-
production of report, release the amount.
Let them say which center in Bangalore. I will come.
There is a notified center in the policy itself.
Page,
Which is the one in Bangalore? We will.
The one
be
in
there.
Bangalore.
page.
It's a page 134, that is Center for Human Genetics with Indira Gandhi Hospital, Bengaluru. So this is the notified center.
134, is it?
Yes, 134, which is a part of the policy as produced by the petitioner.
Page.
Page 134. of
Other
the
lele
petition. The
134 of my petition.
para H
Where is
on the
H?
top. On the left side of the page, it starts with Center of
Center
Excellence
for
and-
Human Genetics with Indira Gandhi Hospital,
Hospital,
Bengaluru. Yes, you appear there, madam.
Let that be recorded that once
Well,
I appear and give my report.
It is on the same page, para 9.4, the centers of excellence will take the required decision for treatment and fund allocation on
weeks.
rare
No,
disease
but
cases
I
within
want
2
to
weeks
make it, I want to.
of
yes.
receiving fresh application.
want
It is in
to-
the policy.
I want to make it clear. I will produce to show the records that I have cystic fibrosis. Then let the undertaking of my friend be recorded that if I produce those records, within 15 days, they will release 50
That's
lakhs
the
to each
policy
of us.
itself.
No, but let that direction be given.
No, that I will do.
Yes.
If
I'll
they
do that.
produce the records and they do fall under these categories, then very well.
In terms of the policy, sir,
very well.
dehorse policy, I'm not directing anything unless it is a PIL which they will have to file.
Yes.
Now,
Because
with
here
these
it
three
says
petitioners, with these
technical
three
committee.
petitioners,
Yes.
the petitioner, the three petitioners are said to be suffering from cystic fibrosis, which is a rare disease. They are before the court seeking permanent solution by way of medicines to be supplied to these three petitioners. The contention is that the government of India, in terms of the policy, has not considered the representations and generated supply of such medicine.
If your lordship is recording that way, kindly see the representation that they've referred to.
In the so and so. The where is the
The
representation?
page, the part that I relevantly want the
My
court to look at is at page
representations
223.
are at page
220?
220 onwards.
It starts at 220.
220 onwards.
The relevant part that I want the court to look at is at page 223.
These are the representations.
This is one representation that they've collectively sent. If I may be permitted to read it.
Page
223. In light of these above facts, as patients of CF, since the medications for CF are totally unaffordable in India, we request you to take steps in public interest. This is not a representation to seek medicines or any
In
financial
the-
support.
In the interest of Patents Act and issue government use license section 100. Why do the patients
This is the
want all this?
representation that they,
Sorry,
on the
no,
strength
it
of
is
which
from
they've come
It is
here.
from the patients.
For seeking a patent.
Alternatively, we take steps to invoke cancellation of patents under section
No,
66.
page 220 is the representation.
No, that's all right.
that
The
starts.
prayer in the representation.
Yes.
Is this petition by the,
They are
no, is this
unaffordable.
petition by the patients or something else?
This is by the petition's father,
No,
parents.
I really can't understand my learned
No,
friends.
why?
No,
You should be interested in medicine. You
Yes,
get
that's
medicine.
all.
Why do you want patents to be cancelled, patents
I-
to be invoked?
Ultimately, how am I going to get the medicines, my lord?
That ashte. That's
How
all.
am I going to get
That
the
government of
medicines?
India will
The-
come about a solution.
Yes, We have no difficulty. We
Otherwise,
want-
PIL you can definitely file, no problem at all.
No, we want the medicines.
Yes.
We are 3 patients. If at the moment they are saying you approach and we will give you 50 lakhs within 2 weeks, I'm more than willing to comply with that.
If, in terms of the policy.
Yes. The only concern I have is, of course, in terms of the policy, because after the names of the centers are written, it says, however, more centers will, so therefore, let the time limit be given.
No, I was last time wondering why Srinivas Raghavan sir has come to object about patents.
No, of course, because we are asking for compulsory licensing. Certainly, we want the drugs.
Yes. No
All
problem.
we want is the drugs.
Patient should get the drugs.
That's all we
That's
want.
all.
We
Patient
want
should
the
not be
drugs.
worried about patents or patents cancellation
No,
or coming down.
ultimately, patents compulsory licensing is only a method to make the drugs available.
That they will look into it, yes.
If the government does it in any way, we have no difficulty. We
We'll
are
see,
not
first
concerned.
you take medicine.
Certainly,
Yes.
let them do it in 15
They-
days. We will
yeah,
appear.
Are not considering the representation submitted by the patients for the purpose of supply of medicines for the aforesaid rare disease. The learned counsel Anuj, appearing for the respondent Union of India, would take serious objection to the non-consideration of the representation, as the representation was in the nature of public public interest, as the last paragraph of the representation would indicate so. Be that as it may, if the patients are now suffering from the rare disease as indicated here in above, the patients shall appear before the Center of Excellence, which is
Which is the Indira Gandhi.
which page is that, Anuj?
134, my lord, Center for Human
Center of Human Genetics with attached to Indira Gandhi Hospital, Bengaluru. The patient shall appear before the said Center of Excellence on
Within a week?
next on the 9th of July 2025.
Along with all the documents and records.
Wait, 9th of July 2025. The patient shall carry with them all the necessary documents and the reports with the reports of them being the patients of the cystic fibrosis and cystic fibrosis. If the patients would come with all the documents and present themselves before the Center of Excellence, i.e. the Center of Human Genetics with attached to the Indira Gandhi Hospital, Bengaluru, the said Center of Excellence shall assess the same, and in accordance with the policy of rare treatment for rare diseases, a decision should be taken and medicine and amount should be released for the purpose of amount should be released for
Amount
the
of
purpose.
50 lakhs, my lord.
That's what in policy, in terms of the policy, amount should be released in favor of those medicine in yarigadu.
Cystic fibrosis.
No.
The Center of Excellence should inform the Union of India.
Correct. The Center of Excellence shall immediately communicate to the Union of India towards the release of amount in terms of the policy to treat these, to treat the 3 patients of rare diseases. The decision taken shall be communicated immediately to these petitioners.
And the amount by Union of India, therefore, to be released within 2 weeks.
That they will do, all that procedure they will do. And the taking decision communicated to these petitioners, and the amount, if they are entitled under the policy, shall be released without broking any further delay, beyond any further delay, which shall be within those 15 days.
Much obliged, madam. Grateful. It may also, may I request to be recorded that Union has taken a decision not to file their reply.
That's recorded. And if you want me to, the
Let
learned,
it be
If there is some specific query put forth by the court, then we would.
the learned counsel appearing for the Union of
We
India
will file
has
it.
now made a submission on the instructions that he has received and not through the statement of objections, and would reserve the right if the statement of objections would become necessary at any point in time in future.
Much obliged.
Order copy may be.
That will,
Yes.
tomorrow morning, not.
Great.
Yes. Tomorrow,
When could my lords give some date
9th,
end?
I've told on 9th.
9th will appear, but maybe end of July for the matter to be listed. So
This matter will be on 24th.
24.
Yes, 15 days.
Just as submission,
the learned senior counsel said that union does not want to treat them. It's not that. From 2021, when the policy is made, about 27 crores, 38
No,
lakhs
no,
is
amount
released
I
only
have
for
seen
Bangalore.
that. I have seen that, yes.
Please.
Ultimately, my lords, this 50 lakhs, if they're disbursing, of course, we want to take it. But the larger question will remain.
That
And
we'll
we will
see.
come back to my lords.
Anyway, we'll list on 25th.
25th, great.
Yes.
Great.
Next, yav, madam.
131.
Ah.
131.
For the respondent, my lord, GMCPC matter.
ಈಗ ಬೇರೆ ಯಾವ್ದಾದ್ರು ತಗೊಂಡು GMCPC
No, my lord, this was,
ನೀವಿದ್ದೀರಾ vacating interim order.
They want the interim order to be vacated.
You have filed your synopsis,
synopsis is ready, my lord.
both of you?
Please, they have already filed it.
With
She found it to
judgments?
file it. With judgments, I'll file it.
File it.
The matter was already heard, my
I know
lord,
it's
and-
heard. I just want to get the synopsis.
No, original records, my lord, had not been inspected.
Original records of what?
Original records of the entire proceedings before the trial court. My lord, I have inspected and have modulated the synopsis. My lord, it is to be heard again because.
Heard again? Why?
Yes, I'll submit, my lord. At the time when the last submission was made, it proceeded on a different footing. Then I submitted that I will inspect the record first.
You inspected the
I
record.
inspected and it shook my conscience. Therefore.
It shook your conscience?
Yes, yes, definitely. First time, my lord, I have come across in the entire, my lord, little career of mine, that a record of court and an advocate, my lord, who appeared for us, who is supposed to protect my interest, my lord, gives a go by and my lord, starts, my lord, meddling, my lord, for the respondent hearing from the inception of the suit itself. First time I have come across, if your lordships go through the record, 3 or 4 dates, then, my lord, your lordship probably, my lord, will be able to, my lord, again recapitulate as to what has happened. That's what, my lord.
Tuesday, Wednesday.
Please, ma'am.
ಈಗಾಗಲ್ಲ, Wednesday.
Whenever, whatever.
But file your synopsis by then.
Very well.
Let it get into the file. ಅದು ಕೊಡಿ, ಅದು file ಗೆ ಹಾಕ್ಬಿಡಿ madam.
ಇದು ಮಾಡ್ಯುಲೇಟೆಡ್ ಸಿನಾಪ್ಸಿಸ್ ನಿಮ್ಮ ಹತ್ರ ಇರಲಿಲ್ಲ. ಇದು ಐ ಆಮ್ ವಿಡ್ರಾಯಿಂಗ್ ದ ಬಿಕಾಸ್ ಅದು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಫಸ್ಟ್ ಸಿನಾಪ್ಸಿಸ್. ಈಗ ರೆಕಾರ್ಡ್ ನೋಡಿದ್ಮೇಲೆ ಆಲ್ಮೋಸ್ಟ್ ಅದೇ ವೇರ್ ಐ ಹ್ಯಾವ್ ಇನ್ಕ್ಲೂಡೆಡ್ ವೇರ್ ಎವರ್ ಮೈ ಲಾರ್ಡ್ ದ ಥಿಂಗ್ಸ್ ಹ್ಯಾವ್ ಚೇಂಜ್ಡ್. My lord, I proceeded, my lord, on the records that were available, but otherwise the records indicate in this very suit. What happened was this. My lord, we go to a lawyer, fully believing him. What lawyer does in this case is, she files a suit on our behalf.
Proceed against that lawyer.
No, that's a separate issue.
What?
No, here the court record reveals, and I was never made to know about any of these developments.
That's between you and your lawyer.
No, court record. What happened? I'll explain, my lord.
ಇವತ್ತಿಗೆ Wednesday.
Therefore, my lord, I thought where a plaintiff, my lord.
You file whatever you want. Yes.
No, I could not file all those things because they are all from the original record.
ಇಲ್ಲಿ ಬಂದಿದೆಯಾ ಅದು?
ಇಲ್ಲಿ ಬಂದಿದೆ. Original records ಬಂದಿದೆ.
We'll see Wednesday.
Please, ma'am.
Lord, interim order.
No, that continues. That's all. Then big group ಇದೆಯಾ madam? 60? Yes. Remaining matters will give date. Yes. Passover, wait.
That's it, one submission.
Page wise I will call.
Please.
Yes. CRP alva?
64, I'm for respondent.
17th, yes.
65, then 66,
Same, 17th,
57,
17th,
68,
17th,
69,
For the petition, my lord.
17th.
Please.
78, then 71,
71, my lord. In this case, my lord.
70 is adjourned, sir.
71, my lord.
70 is adjourned.
71, my lord. Connected matter is already stayed, my lord.
17th, yes.
71, my lord. My name may be shown in the cause title when I filed wakalat for respondent 3, my lord.
P. Usman,
No, Muhammad Niaz, my lord. I filed wakalat.
learned counsel so and so submits that he has entered appearance for the third respondent registry to print the name of so and so as appearing for the third respondent. Yes.
72,
17th, sir. Yes.
73 adjourned. For 75 adjourned. B group matters.
LA BDA ಎಲ್ಲ ಕರಿತಾ ಹೋಗಿ.
88 is my matter.
One
LAC
minute,
matter.
ಒಂದೊಂದೇ ಕರಿತೀನಿ.
Please, ma'am.
76, 2012.
76,
76 is 15th.
77,
15th.
78,
2014, madam.
ಅದಕ್ಕೆ ಮುಂಚೆ 2012 ಇದೆ. Yes. 15th, yes.
79,
For the petition, interim order may kindly be extended. 79,
That will be extended, sir. Wait.
80,
80 BDA, again 15th.
81,
ಎಲ್ಲ 15th.
82, appearing for petitioner, my lord. 82, my lord.
15th, yes.
84 adjourned, 85,
not 85, 86, both are covered by judgments, my lord.
Covered by judgments. 15th, yes. 15th in preliminary hearing ಹಾಕಿ. ಇಲ್ಲ, ಬರೀ 85, 86 ಮಾತ್ರ. ಕವರ್ಡ್ ಅಂದ್ರಲ್ಲ ಅದಕ್ಕೆ. 87. 15th, yes.
88,
That's for petitioner. May I please seek for tomorrow, my lords. I don't have an interim order in this matter.
What's
Sir,
the
2028.
consideration of interim prayer ಅಂತ ಇದೆ? ಜಯಕೀರ್ತಿ.
My name is not reflected. I filed NOC wakalat.
Learned counsel Srimati Sadhana Desai submits that she has entered appearance on behalf of the petitioner registry to delete the name of so and so and print the name of Srimati Sadhana Desai as appearing for the petitioner.
That's tomorrow, my lords.
Not tomorrow,
Yes.
madam. Interim order ಇವಾವಾಗಿಂದಿಲ್ಲ. We'll take it on Tuesday.
Tuesday is what?
Tuesday 8th.
8th, please.
Because of
Please.
consideration of interim prayer.
No, 8th,
Yes.
I'm not there in town minutes. 10th,
10th, yes,
please.
10th.
I'm grateful.
89,
89, 15th.
90,
Interim order ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್.
For the petition.
90,
90, 24th. 90 ಇಂದ 24th ಕೊಡ್ತಾ ಹೋಗಿ.
91,
Lordship, 91, your lordship, this is the matter
24th,
where
yes.
interim order, though there is an interim order, your lordship, the connected matter has been disposed of, allowed, quashing the same very
We'll
same.
see, we'll see. 24th, yes.
92,
Interim order ಇದೆಯಲ್ಲ?
Interim order ಇದೆ.
ಮತ್ತೆ ಅದೇ 24th, yes.
They are, since they are interfering
No
with
problem,
the possession.
24th.
92,
My lord, 19 hour for the petitioner, my lord. No interim order,
Twen-
my lord. And this is the 4th round of litigation.
10th, yes.
93, for petitioner, my lord.
Interim order ಇದೆಯಾ? This 24th, yes.
94,
Lord, I am for the petition, my lord. My lord, my request, my lord, my client is suffering from bone cancer. Request for a short hearing.
10th,
For preliminary hearing, my lord.
10th, sir.
For preliminary.
Preliminary hearing, all these interim orders ಇಲ್ದೇ ಇರೋದು ಬರ್ತದೆ. Yes. Yes, next.
95,
My lord, I appear for the petitioner. This matter has been covered by judgment and the judgment is produced at Annexure E, my lord.
24th, yes.
Grateful.
Same 24th.
97,
Up to 102, 24th.
hearing on IA,
CRP all 17th, madam. Interlocutory.
104, serial number 1.
Which, madam?
Corrected.
ಅದು ಬೆಳಗ್ಗೆ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ವಿ.
My lord, 99 and serial number 99 and 100. Interim order request to be extended, my lord.
Don't worry about it. Yes, next.
99 and 100, please.
Yes, sir. 101 ಏನು?
24, interim order may continue.
That will be extended, madam.
105,
Yes.
My lord, respondent, this is regarding will, madam.
102, my lords.
24th, yes. ಅಲ್ಲ 17th.
ಅಲ್ಲ ಇದರಲ್ಲಿ my lord 105 ಅಲ್ಲಿ court is refusing to extend interim order, my lord. Further proceeding stay ಅಂದ್ರೆ ಅಲ್ಲಿ interim order extend ಮಾಡ್ತಾ ಇಲ್ಲ. This is regarding will.
24th, yes.
ಅಲ್ಲ 10ನೇ ತಾರೀಖೇ ಇದೆ. Will ಅಲ್ಲಿ we are ready to comply with the bill. All the terms we are ready.
We'll see. Yes.
Thursday.
Thursday ನೇ.
Let there be a
17th,
clarification to the
17th,
trial court. Trial court is refusing to accept my interim
No
application.
problem, sir. Yes,
Interim order may kindly be extended.
that will be extended.
106,
Same 24th,
107,
24th,
My lord, kindly see. Just
24th.
My lord, I have filed a 151 application for releasing the deposited amount.
Yes, deposit money there.
Agriculture, 3 lakhs, my lord. The agriculturalist, my lord, he has purchased
List,
the.
list on 10th, 107,
108,
I am for the petitioner.
24th.
109 adjourned, 110.
Appealed for petitioner, my lord.
Yeah, Madam.
No.
No, 110.
Yes, ಎಲ್ಲ
for
20,
petitioner.
all 24th.
Interim order.
That will extend, yes.
112,
ಅದು ಅಷ್ಟು ಪೂರ್ತಿ up to 114, yes.
final disposal, 115.
114 ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ, ಯಾಕಂದ್ರೆ 4 ಜನ ಪೇಷಂಟ್ಸ್ ಇದ್ದಾರೆ, ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಬೇಡಿ ಅಂತ
List on
stay
24th,
ತಗೊಂಡಿದ್ದಾರೆ.
yes, next.
114 I appear for the.
Wait, sir, 24th, yes. Next.
115, final disposal.
17th ತಗೋಬೋದಿತ್ತು.
ಯಾವ ಇದು ನಾನು ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿರೋದಾ?
ಹೌದು, 114.
114 ಅಲ್ಲಿ
ನಾವು ಇಂಪ್ಲೀಡಿಂಗ್
not to disperse.
ನಾಟ್ ಟು ಡಿಸ್ಪರ್ಸ್ ಇದೆ.
ಅದನ್ನ 10th ಹಾಕಿ, ಲಿಸ್ಟ್ ಆನ್ 10th. Yes.
115, final disposal.
Final disposal ಎಲ್ಲ ಆಗುತ್ತೆ on 17th, CRP. ಅಲ್ಲ, CRP, yes. 17th WP CRP ಎಲ್ಲ ಹಾಕಿ. Yes, next.
And final hearing.
118 for the petitioner, my lord.
Yes.
117 is not a CRP, it's a WP matter.
Sorry?
117 is a WP matter.
So what?
I believe it was told CRP is on.
No, both WP and CRP, 17th. 17th ಎಷ್ಟಾಗಿದೆ?
118 for the petitioner, my lord. It's a 2015 matter, my lord.
53 ಆಗಿದೆ madam, posted to 24th.
24th,
Yes.
my lord.
Yes, yes. 118 also the same, 18 to 120.
My lords, memo for hand delivery of entry order.
ಯಾವ್ದರದು?
Third list, first.
ಯಾವ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದು?
Video.
ಯಾವ್ದು ಫೋಟೋ?
A photo.
Lordship, serial number 102, interim order may be extended.
I won't extend. In mention ಮಾಡಿದ್ರೆ extend ಮಾಡಲ್ಲ.
My lords.
Yes.
List for serial number 2, I may permitted to have the hand delivery of the interim order, my lords, granted by today.
Memo.
ಕೊಡ್ತೇನೆ, my lords.
ಕೊಡಿ ಆಮೇಲೆ.
Please, please.
Serial number.
Hand delivery tomorrow, ಇವತ್ತಾಗಲ್ಲ.
Please, please.
ಎಲ್ಲ ಅಡ್ಜನ್ ಆಗೋಗಿದೆ, ಮತ್ತೆ ಡೋಂಟ್ ನೌ ಆಮೇಲೆ ನೋಡ್ಕೊಳ್ಳಿ. ಎಲ್ಲಿ ಅವರು ಡಿಕ್ಟೇಟಿಂಗ್ ಆರ್ಡರ್ಸ್? ಎಸ್, ಕೊಡಿ ಅದು.
Appearing for the respondent.
ಅಷ್ಟೇ, we'll dismiss it.
That's one fact, that's.
Absolutely, yes.
I just want, that's whatever, let's have. The only thing is that that's I filed a document. In any event, that's the contention which was taken by the respondent was that they have claimed and they have averred in their plaint that I am the tenant. That fact or that averment is not.
That's the contentions.
That's a content. They have told that I am the tenant.
Sir, we are on 92.
Yeah, 92.
Whether you can call
I can call the plaintiff or not.
for
And I have
evidence.
made out a special circumstance.
No special
No,
circumstance.
have I? That's the point, that's which I tried to argue. Please, I just wanted to bring to my lord's notice that the contention they took was I am the tenant, which they have not averred in their plaint. So that cannot be the fact which can be recorded or even averment which can be recorded. That's my request.
My lord, to counter that, at page number 48 of their petition is the written statement filed by them. They themselves have admitted that they are the tenant in the suit.
That is being retracted.
You tell me, who on earth will just give, you stay in the house, that's all.
My lord,
And what's this Suraj Raju Gabriel?
Srinivas
Raju Gabriel. Correct, sir, 1892 purchase.
Subsequently, there are 2 sale deeds in my favor, my lord.
ಅದೆಲ್ಲ ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. 2002, we are only on whether you can be called, you can call the plaintiff as your witness, that's all. Not possible. That's it. Dismissed.
My lord, if I also could make a submission, there was a cause that was imposed on the earlier occasion in a WP, my lord, for.
And now also will impose costs. We'll direct the court to conclude the proceedings in 4 weeks.
Much obliged, ma'am.
What happened to you? Oh, yeah. Oh, correct. Anyway, you got a note. I wanted to finish it off first. Will it? How can it influence? I'm only on the application. I'm only on the application, sir. If you were on this side, you would have done the same thing. If you had orders in your favor, you would have done the same thing. No peremptory orders. Yes. No, nothing. That's all. Dismissed. Observation of what? So you mean to say I write something and clean slate it? Of course not, sir. I am only answering the application. Beyond that, nothing else. I am only considering the legal position as Justice Dixit or Munde, same parties. It is held that plaintiff cannot be bought an evidence in favor of the defendant. That's all. I am only following that inter parties. It has become final and nothing else. Ashte. And suit in Yashtina Nadistira.
My lord, we had already almost concluded the final arguments. It was the fag end of the arguments.
Oh, so because you came in 4 months ago, another application.
My lord, the matter before the trial court is on Saturday, so we can go ahead and.
Tomorrow is Friday. We'll release it by tomorrow. Don't worry.
Much obliged, ma'am.
Who?
We wanted to conclude our arguments.
ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡಿ ನನಗೆ ಯಾಕೆ ಅದನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀರಾ? Yes.
Much obliged.
Passed on matter 45.
Because I had made her wait since morning, I will pass orders.
I understand, my lord. You have.
Yes.
45. We have it.
ಏನ್ ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಾ? ಎಸ್ ಮೇಡಮ್, ಎಲ್ಲಿ ಪ್ರದೀಪ್ ಕುಮಾರ್? ಹೋಗ್ಬಿಟ್ರಾ? ಇರ್ಬೇಕು ತಾನೆ. 6 ಗಂಟೆ ಆದ್ರೆ ನಾವಿಲ್ವಾ ಇಲ್ಲಿ? ಎಸ್, Thursday, next Thursday. ಇನ್ನೊಂದು ಪಾಸ್ ಓವರ್ ಮೇಡಮ್.
59.
No, don't worry. If they do it by the next week, we will take care of it. Yes.
59.
For respondent.
ಮುಂದಿನ ವಾರ.
Appearing for respondent number 1.
Yes, Sidramani, urgent. Entry ಮಾಡಿದ್ಯಾ?
Is entry matter. Both the cases were posted for evidence. One is on 9/7/2025. Another is on 18/7/2025. So these two properties were not included by petitioner in his partition. So I was made as a party to the proceedings in his partition. Let both the cases be clear. And time may be fixed for early disposal. Evidence has been already commenced.
ಈಗ properties and defendants both are different in each case.
Yes.
ಹೌದಾ?
Both are partition.
Both are partition suits and both are parties are common.
Parties are common.
ನಡೀಲಿ ಬಿಡಿ ಒಟ್ಟಿಗೆ. I will not club the two, but I will direct the court to take up both the matters simultaneously.
Before one court.
One court, different court simultaneously.
Yes. Sorry.
We'll pass that order.
Yes, please.
On consent, we'll pass that order and close it.
Yes, please.
The petitioners. ಇನ್ನೊಂದು ಸೂಟ್ ಯಾವ್ದು ಸಿದ್ದರಾಮಯ್ಯ?
My lord, I have given a memo.
And
OS
I am
490.
ಅಲ್ಲಿ
490/2000.
ಕೊಡಿ, ಎಲ್ಲಿ ಮೆಮೊ?
ಕೊಟ್ಟೆ.
ಎಲ್ಲಿದೆ?
ಮೆಮೊ ವಿತ್ ಮೆಮೊ ಕೊಟ್ಟೆ, ಬೇರೆ ಕೊಡ್ತೀನಿ.
ಇಲ್ಲಿದೆ.
Before third additional senior civil judge.
ನಾನು ಮಾಡ್ತೀನಿ, ಈಗ ಸುಸ್ತಾಗಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ, ಸಾಕು.
ಆಯ್ತು.
ಅದೇ ಆರ್ಡರ್.
Yes, please.
Both suits, same court. ಏನಾಯ್ತು ಈಗ ಅದಕ್ಕೆ? 10th ಇರ್ಬೇಕು. Yes. No, 10th. Yes, not at 6 o'clock.
ಏನಂದ್ರೆ